All right, good morning, Colorado. This is the Colorado Oil and Gas Conservation Commission. We're on day, I'm not sure what, of financial assurances rulemaking. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Good to see everybody. Hope you had a nice night. Good to be here this morning. Before we get into our financial assurances rulemaking, we do have a consent agenda, which is comprised of 8 matters, 3 spacing and 3 pooling. Does any commissioner have any questions with regard to consent agenda? Seeing none, do we have a motion to approve consent agenda?
So moved.
Second.
Motion and a second. Further discussion? Seeing none, all those in favor indicate by signifying saying aye. Aye.
Aye.
Opposed? Motion carries. All right, getting right into it, we have a full days of party presentations in docket number 2106-00097. As I mentioned, I think it is Wednesday, January 26th, 2022. With that, I believe we will first hear from the conservation group comprised of Earthworks, Sierra Club, and Logic, as well as the Larimer Alliance for Health, Safety, and Environment. So if we could bring their counsel to the meeting, we will get ready to hear.
Thank you, Chair Robbins. Can everyone hear me?
Yes, we can.
Good morning, everyone, and I'm going to share my screen here.
Okay, while we're doing that, Ms. Larson, I always like to check and make sure we're right with regard to time. My agenda has 29 minutes for this party.
That is correct.
And Mr. Freeman, do you plan to have any of that time set aside for rebuttal or closing?
Yes, thank you. We would like to reserve 5 minutes for rebuttal.
Would you like Ms. Larson to let you know when you're at 24 minutes?
That would be fine. I think we'll be okay, but if she wouldn't mind doing that, that would certainly be helpful.
Very good. All right, I believe you're up. We look forward to hearing from you.
Tom?
Great. Yeah. Good morning, commissioners. Tom Delahanty of Earth Justice on behalf of Logic, Sierra Club, and Earthworks. And as you can see, my colleague Mike Freeman is here as well. Before launching in, I just want to thank the commissioners and commission staff for all of the work that they've put into the rulemaking so far, and also for the opportunity to present here and continue the conversation and hopefully move the rules forward in a good direction. So there are 4 points that we'll cover today. I will first go over some core issues that have broad support, at least within the environmental and local government community. I'll then turn it over to Mr. Freeman to talk about the phase compliance plan that we've put forward previously, and to also discuss why the proposed blanket bonds as written would violate SB 181. And then I'll conclude the presentation by talking about orphan and zombie wells and how these are a real problem in the state. So, like I said, I'll start by discussing some core issues that have broad support. And just to clarify, when you see consensus here on the slides, this is referring again to support within the environmental community and many local government groups, not necessarily industry parties. So these groups include, for at least some or all of the issues that I'll go over here, Western Resource Advocates, Wild Earth Guardians, Colorado Rising, the Conservation Alliance Group, Pitkin County, the affiliated Local Government Coalition, City of Aurora, and the Brighton Group of Local Governments. The first issue with broad support is the need for these rules to apply to federal wells, which we think is a straightforward requirement of SB 181. As countless parties have pointed out, failing to require financial assurances for federal wells will leave a significant portion of the state's wells without adequate bonds, including all of the wells in Pitkin County, for example, and most wells in many other Western counties. So we endorse Pitkin County's proposal and their proposed red lines to address this issue. And we urge the commission to fulfill this unambiguous mandate to require proper financial assurances for all wells in the state. And quickly, this is not on the slide, but one other issue that sort of relates to this that also has broad support is the need for improved standing for local governments and surface owners to request a 211 hearing. You've heard this already from Mr. Sura, and we'll likely hear more from local government groups, and we support that position. The next consensus issue is that full cost bonding should be required at minimum for all new wells and all existing wells that are transferred. Starting with new wells are a really small fraction of the total number of wells in the state. There were just 414 wells spud in the last 12 months, according to COGCC's daily activity dashboard, which is less than 1% of the total number of wells in the state. So the total cost for implementing this measure would be really minimal. And that's also true on a per well basis, because the per well cost would be roughly 1% of the cost to drill a modern well. We think this is a common sense thing to do because it will prevent the current problem that we face from festering and from reappearing again in 10 years. And we're really hopeful that the commission will avoid repeating past mistakes by requiring that, at least going forward, all decommissioning costs are fully assured upfront. And I also want to quickly address a point that Commissioner Gonzalez raised in some questions yesterday about setting aside money early on. While we should be eminently clear that operator bottom lines should not dictate the financial assurance requirement outcomes here, there are options to ensure that a bond that's posted at the start of a well's life isn't just sitting idle or being put under the mattress. A really simple solution to this is something like a trust fund, which at least one industry party, Own Resources, has proposed and we fully support. And a trust fund would allow wells to be fully assured at the outset while still generating a reasonable return to operators on those dollars that they've set aside. So moving next to the transfer piece, we certainly urge the commission to adopt full cost bonding upon transfer as a reasonable measure to help deal with existing wells. However, bonding on transfer is not a standalone solution. Commission staff have taken the position that it does not have clear authority to prevent a transfer that lacks appropriate bonds. A Colorado Sun article published last week quoted Director Murphy saying that the commission cannot necessarily reject a transfer. And similarly, as the commission witnessed last week in the matter regarding Overland Resources, operators can transfer legal ownership of wells irrespective of COGCC approval of a Form 9, which in the case of Overland allowed an operator to orphan wells by transferring them to a financially incapable operator. So if that's the case, that the commission can't necessarily reject transfers on the basis of bonding, then bonding on transfer is not going to be an effective measure because you'll expect transferees to argue that they don't necessarily have the capital to post a full cost bond. Given that, it's really critical that bonding on transfer needs to be bolstered with other requirements, including, most importantly, full cost bonds for all new wells. The third issue with broad support are refinements to the Tier 3 and out of service well list concepts. As written, these are just inconsistent with statute because they have far too much discretion baked in without any clear or enforceable guidelines. Tier 3 doesn't really offer any specific requirements or guidelines that an operator's proposed financial assurance plan must satisfy, nor does it even include criteria that the director must assess when reviewing the proposed plan. And similarly, the out of service well list doesn't mandate any specific timeline for plugging, nor does it explicitly require any amount of financial assurance for a well that's been placed on the list. We'd note that even industry parties have expressed concern about the significant ambiguity in the December draft rules on these points. The total lack of clarity and specificity in the Tier 3 and out of service well list provisions do not comply with SB 181. Furthermore, just from a policy perspective, Tier 3 offers a wide open off-ramp to Tier 2. It's hard to imagine an operator choosing Tier 2 when Tier 3 exists as drafted, meaning that the commission will likely face a huge number of financial assurance plans that differ completely in their proposed method of compliance, the criteria for assessment, the timelines, and countless other factors. The level of discretion that's baked into the draft rules and the open-ended off-ramp of Tier 3 are especially concerning given the commission's track record under the current excess inactive well bonding rules. As we've previously pointed out, the commission has struggled to effectively enforce this relatively simple requirement, leaving Colorado exposed to upward of $8 billion in decommissioning risk just on this one requirement. So with that, I will turn it over to Mr. Freeman.
Thanks, Tom. We would propose instead a different approach that we think would be much simpler to administer than the tier 3 and other features of the December draft. And that's a phased compliance framework under which each company would have 5 years to bring all their wells up to a full cost bonding with a single well financial assurance. We described this framework in the November hearing, and we've also submitted proposed language with our pre-hearing statement. But just to summarize briefly, under the phased compliance plan, each operator would get 5 years to either post a single well financial assurance for each well or to plug the well. The operator could also take other steps to comply, such as transferring some wells to different operators. Second, the operator would have to bring at least 20% of its wells into compliance each year. And the point there is simply to ensure that operators are making steady progress toward compliance. Third, similar to what is in the December draft, each operator would submit a financial assurance plan describing how it will be bringing its wells into compliance. The idea here is to let the operator decide which wells it can address sooner and more easily, and to delay bonding up or compliance for other wells where the operator needs more time. And then fourth, after the financial assurance plans are submitted and approved, each year the operator would submit an annual compliance report describing how it's following through on implementing the financial assurance plan. And those compliance reports would be subject to review and approval by the director. The upshot here is that the idea behind this framework would be for the commission to just set the target that each operator must meet, and then let the company decide how best to meet that standard. Next slide, please. In cases where compliance within 5 years would pose a hardship, and the operator can actually demonstrate that with audited financial statements or other evidence, the commission can allow a variance extending the compliance time period as necessary. And this is a critical difference between our proposal and the tier 1, tier 3, and out of service well lists in the December draft. The December draft would let operators essentially propose whatever they want and require the commission and the director to wade through and evaluate a whole range of different concepts, timelines, evidence, and ideas for potentially hundreds of different operators. And as Mr. Delahanty indicated, that would likely pose an enormous burden on the staff and the commission. Instead, our proposal focuses just on a single variable here. And that variable is, what's the amount that's reasonable for each operator to contribute each year to make progress towards its asset retirement obligations? That assessment can be readily determined from the company's financial statements. And by focusing just on this one variable, the staff and the director should be able to fairly quickly develop the experience and the context to make that kind of assessment in an efficient and consistent manner, rather than evaluating a whole variety of different proposals on essentially an ad hoc basis. We really think the phased compliance framework is the right approach. It builds on some of the good ideas in the staff draft, in particular an out of service well list and financial assurance plans, but it would be far simpler to administer than what's in the December draft and would require many fewer judgment calls by the staff. What we asked the commission to do is direct the staff next week to develop some language incorporating our phased compliance approach or framework for this commission to consider. We think that putting this in black and white would help surface any concerns that the staff has about a phased compliance approach and allow this commission to make a fully informed comparison between the approach taken in the December draft and a phased compliance framework. And we think even if this commission ultimately decides not to go with phased compliance, its merits and warrants really serious consideration with a fully fleshed out proposal that addresses whatever the staff concerns are here. Next slide, please. So the third topic we'd like to cover involves blanket bonds. We continue to oppose blanket bonding, and we think that requiring full cost bonding for all wells will best protect the state and ensure that operators close their wells in a timely manner. But if the commission is going to allow some level of blanket bonding for existing wells, it needs to substantially overhaul the provisions of the December draft in order to comply with SB 181. Now, what I'm about to describe here, we are suggesting only for existing wells. We think that for new wells, full cost bonding needs to be required across the board for all new wells. But even with regard to existing wells, the draft blanket bond provisions in the December draft would violate the act in at least two ways. First, the Tier 1 would let operators self-insure for the vast majority of their asset retirement obligations, but without meeting the requirements for a self-insurance. And second, the criteria for Tier 1 looks at just the current operation or the current production from the operator's wells in Colorado. And that narrow range of information and evidence bears little relationship to the central mandate of the act that the operator demonstrate its financial ability to decommission those wells years in the future. Now, I'll describe this in a little more detail, but I want to note that what we're proposing here actually is very similar to the concept that Kinder Morgan has proposed and that Mr. Sura described yesterday, but we come at it from a somewhat different direction. Next slide. So the first issue involves the self-insurance requirements of the Act. The premise of blanket bonds is that an operator poses little risk of default, and so that a substantial bond really isn't necessary. And that's also the same rationale for self-guarantees. The effect of the two of self-bonding and blanket bonding is also really similar. If you let an operator post a blanket bond that only covers 1 to 5% of the decommissioning costs, that means the operator is self-insuring for the remaining 95 to 90%, 99% of those costs. But there's a big difference between the two. And the difference is that while blanket bonds leave the state with essentially the same risk as a self-guarantee, proposed Tier 1 for blanket bonds wouldn't require any of the safeguards mandated for self-guarantees. And I think this side-by-side slide illustrates that. If an operator wants to self-guarantee under the Act and under proposed Rule 701, it needs to make an annual demonstration each year that it has sufficient net worth to guarantee its performance. It has to back that up with audited financial statements. It has to show that it's got a minimum net worth required for that. There has to be a personal guarantee from a corporate officer, and the showing has to consider the company's obligations in other states. In contrast, that same company under Tier 1 could get a blanket bond that requires none of that evidence, none of those requirements, with just a one-time financial assurance plan, and it would be allowed to self-guarantee for fully 98% in some cases of the anticipated decommissioning costs. That amounts to just an end run around the self-insurance requirements of the Act and the rules, and it's just inconsistent with the framework of the Act. If the Commission's going to allow some level of blanket bonding, it needs to acknowledge that blanket bonds are really a self-guarantee scheme and require compliance with the Rule 701 annual self-bonding requirements for those. The statute just doesn't allow the Commission to take this kind of a trust us approach to financial assurances. I'd also note that a requirement for an operator to annually submit the evidence we pointed out for self-guarantees would not be a significant burden on the staff, because that showing has to be made by the operator. The operator has to submit a audited financial statement, a demonstration of its net worth, and a corporate guarantee. All the staff would have to do is confirm that those boxes are checked. But requiring that kind of an annual showing by the operator will give the state substantially more protection that it won't be ultimately left holding the bag for that obligation. Next slide, please. So the second legal issue I'd like to address is the criteria for Tier 1 blanket bonding. And as proposed, Tier 1 only focuses on one narrow issue, which is current production levels in Colorado. Now, that may be one potentially relevant factor here, but by itself, it doesn't demonstrate that the operator has the financial capability to assure that it will close its wells. Just one example is that the financial assurance plan the operator provides is just a one-time snapshot of its operations. There's no requirement for annual reports confirming that the operator's production levels remain that high. And there's no mandatory trigger for additional bonding if the operator's production drops. So what I think you can expect to see if Tier 1 is adopted as drafted is that operators will get Tier 1 status, post a blanket bond, and then remain there for years, even as its production declines over time. The second concern here with the Tier 1 criteria is that assessing a company's financial strength requires much more information than what's in Tier 1 now, and includes information outside of Colorado. And this is the point that that Kinder Morgan made is highlighting in its proposal as well. We note, as we did in our pre-hearing statement, that the current Tier 1 criteria would appear to allow at least one recently bankrupt company to qualify for blanket bonding, and we think that's inappropriate. If the commission is going to allow blanket bonding, we recommend that you look to EPA's guidance for UIC wells as for the kind of criteria that would be necessary to show an operator's financial capability. Under EPA guidance, if the operator doesn't want a full cost bond, it has to make an extensive showing of several requirements, including that it has a strong credit rating, that it meets certain minimum requirements for net worth and net profit, and that it has a substantial remaining economic life for its leases or its production fields. None of those requirements are provided in the current version of Tier 1, but they're all far more relevant to assessing the company's financial strength than just production levels in one particular state. So we would urge the commission, if it's going to satisfy the statutory standard, to use criteria that look a lot more like what EPA is required and what Kinder Morgan is suggesting as well. Finally, I'd just like to take a step back briefly to talk a little bit about what the Act requires and doesn't require. You've heard a lot from industry about how the Act supposedly gives the commission a lot of discretion. You've heard about the different potential options that the commission is directed to consider, but not necessarily adopt. But we urge the commission to focus on the core central mandate of the Act. And with the Act, that mandate is that every operator provide assurance that it is financially capable of fulfilling every obligation imposed by the commission's rules. And that includes the obligation to close and reclaim its wells in a timely manner. The whole point of the Act is to ensure that the operator bears the risk and is responsible for closing its wells, and that the state doesn't have to bear that risk. One final point I want to note is that if you look at the text of the Act, it directs the commission to consider different options for setting aside funds, things like a sinking fund or bonding up on well transfers. And it also allows operators to use self-guarantees subject to certain safeguards. But what's completely missing from the Act, and I think this is very telling, is that nothing in the Act mentions blanket bonding as an allowable option for this commission. There's no suggestion that in overhauling this commission's rules, the legislature intended this commission to follow up and authorize blanket bonding. There's no discussion of it at all. We think that makes it very questionable whether blanket bonds could be allowed under any circumstances here. But certainly if the commission is going to allow them, it needs to account for the requirements of the Act we described above. And next, I'll turn it over back to Tom.
Thanks, Mike. So the last part of our presentation will focus on rebutting the notion that the status quo is just fine. You've heard from industry parties time and again, and will no doubt hear multiple more times during this hearing, that everything is fine, that there's nothing to see here, etc. But orphan wells, and perhaps more so functionally orphaned wells or zombie wells, are a very real problem. As then Director Lepore observed in 2017, it was more likely than not that almost 4,000 wells would become orphaned in Colorado at some point in the future. And recent tallies of orphan wells in Colorado also indicate that Colorado's orphan well problem is bigger than it was previously acknowledged to be. Now that there's federal money available to help address the problem, Colorado reports 402 orphan wells requiring P&A work, which is a 68% increase from last year's March 26th estimate of 239. And beyond these officially orphaned wells, the huge number of low producing and inactive wells makes clear that COGCC for years has failed to enforce its rules requiring wells to be P&A'd in a timely manner. And you heard some of those numbers in some prior presentations. So the images that you're seeing on the screen illustrate the problem. And we just want to make clear that these are not one-off outlier examples. There are tens of thousands of wells like these that are not being effectively monitored or addressed by the operator, by COGCC, or by APCD. And these functional orphans that have little value and little or no oversight cause very real pollution and public health hazards. So the first image you're looking at is of a well that was taken by Earthworks in June of 2021. The well was active when Earthworks visited, and they filmed these emissions from the vent tank and learned that it had been emitting like this without a permit for at least 2 years based on correspondence with APCD. So Earthworks filed complaints with COGCC and with APCD, and seemingly in response to that, the well was shut in July of 2021. However, Earthworks went back there later that year and found another problem, a leak directly from the wellhead. Based on, again, corresponding with APCD and others, Earthworks learned that neither the operator, APCD, nor COGCC was aware of this problem until Earthworks brought it to their attention by, again, filing a new complaint. The images here are of an orphan well in Medicine Bow Route National Forest. This well was inactive since September of 2019, and Earthworks filmed these emissions that you see here and then filed a complaint with both APCD and COGCC. APCD informed Earthworks that these kinds of leaks are common for orphan well infrastructure, that it didn't have authority to do anything about it, and it suggested seeking help from this commission, COGCC. The point with these two examples, though, is that old oil and gas infrastructure, whether it's officially orphaned or not, poses real risks to human health and the environment, and no one seems to have a real handle on dealing with the problem. Certainly not operators, and seemingly not APCD or this commission. Robust financial assurances are one of the very best ways to get a handle on it because it gives operators a financial incentive to plug old wells in a timely fashion. The status quo, with P&A work dependent on an endless supply of new wells to generate the revenue for plugging and on the goodwill of operators, just doesn't work. These images are what trust us looks like. So rather than continuing on this trajectory, we hope that the commission uses this rulemaking to move Colorado in a better direction. And with that, we're open for questions.
All right. Thank you both for kicking off this morning with your presentation. We appreciate you being with us and for your work over the course of this proceeding. Looking to my fellow commissioners for questions for this panel. Commissioner Gonzalez.
Thank you, Chair. Thank you, Mr. Delahanty, Mr. Freeman. Good morning. I got a question about, this premise about full cost bonding that we've heard a number of times, including through your filings. And my question is, why do we need to assume that every single well by every single operator will be orphaned? Because that's what full cost bonding assumes.
Right. Commissioner Gonzalez, thank you for the question. First, I think I might disagree with the premise of the question. The point of full cost bonding is not that we assume that everyone is going to be orphaned, but that you can't tell in advance which ones are going to be orphaned and when. And that's the reason why the statute requires an assurance that the operator demonstrate it can plug and abandon and reclaim the well and meet its obligations for doing so. Our point is that particularly blanket bonding doesn't meet that standard. And I note that, for most other kinds of operation, hazardous waste facilities, UIC wells, the standard is if the operator wants to move forward, get permitted and build a facility, it needs to post the bond up front to ensure that ultimately those closure obligations won't fall to the state and that they have it covered. If in fact, for a given operator in a given well, the risk is as low as is particularly low, there should be, in many cases, surety bonds available for that well. And where it's not, the operator can go ahead and set aside what amounts to a relatively small amount of money, either as part of the drilling or from the initial years of production to set that aside. And as Mr. Delahanty described, this isn't the same as just putting $80,000, $90,000 under a mattress. We would support a proposal where the operators have to set the money aside in what amounts to a retirement account or a trust fund. And then that could, with appropriate limitations and standards, that trust fund could be invested in investments that yield a reasonable rate of return. So the operator wouldn't, that capital would not just be isolated and set aside for no productive purpose, but it would be there to ensure that the operator is guaranteeing that it will follow through with all of its obligations to decommission the wells.
So I appreciate the last point on the trust fund and the idea of whatever bonding, whatever financial assurance we mandate through our rules, that there should be some investable avenue vehicle for those funds. So I think we're in agreement there, and I'm still considering looking for more information from other testimony. Now, in regards to full cost bonding and it not being tied to a premise of or an assumption that every well is going to be orphaned in its life, you know, are you suggesting then that each well should have its own financial assurance account? Because otherwise it kind of seems like a big blanket bond just that covers the amount of every single well and doesn't really account for risk that not every one of those wells is going to be orphaned.
I mean, I think there's probably different ways to structure it, right? You could get a surety bond for a given well, for each given well, if that's the best way the operator wants to proceed. You can imagine a sinking fund where the operator contributes a certain amount that's based on the aggregate. There would be one fund or one trust fund that covers all the operator's wells. The point being, though, is that each well, there needs to be adequate financial assurances to guarantee that each well held by that operator will ultimately be plugged. You know, one other point I think is really key to keep in mind here is the incentives, and that, you know, one of the important values behind requiring upfront full cost bond is that it gives the operator the incentive when it's planning its wells, drilling its wells, and operating them to plug and abandon them in a timely manner, so that the operator can decide, you know, is this, you know, if this well is still economic or still yielding some revenue, but very, very little, maybe it's better for the operator to plug and abandon the well and recover that bond. But the point behind full cost bonding up front is to line up the incentives so that the operator is incentivized to comply with its obligations in a timely manner, because it knows that by doing so, it'll free up the money that it's already posted.
So Mr. Freeman, let's assume that we adopt your compliance plan, and in 5 years, every well in this state is fully bonded to its full cost all the way through. What's the point of the orphan well fund at that point?
Well, so I think, as was discussed yesterday, it's inevitable that whatever rules this commission adopts, there's going to be additional orphans. You know, we agree with the parties that are just pointing out that these rules aren't going to create insolvent companies or drive them in insolvency. They're going to reveal which companies are just insolvent because they haven't set aside the capital to meet their asset retirement obligations. And so, you know, for example, even under our phased compliance plan, this commission can give companies variance and say, all right, look, tell us how much time you need to comply. And we hope and expect that a lot of them will, who can't do it in 5 years, will work out a reasonable time period. But all the evidence before the commission is that there are a sizable number of operators who are just never going to be able to comply with their asset retirement obligations. They just haven't done it. And they have, you know, large numbers of inactive, non-producing wells. So whatever approach this commission takes, there's going to be a need for an orphan well fund. Our point is, let's set up a framework that's simple and easy to administer, but also accounts for and gives operators who can continue to operate and ultimately meet their obligations, give them the time they need to do it, but make sure that they show that they're actually making steady progress toward compliance and that they demonstrate they're making progress toward compliance.
Thank you for that answer. I appreciate your perspective on it. You know, one of the things I've been thinking about is are we weighing the operator here, or are we weighing, or are we risking the operator, or are we risking the well, right? And it feels like kind of what you suggested kind of straddles the line of, well, not every operator's wells are gonna be orphaned, but at the same time we have to have enough money, that if every operator's wells are going to be orphaned, are we trying to regulate down to a zero risk here?
No, no, Commissioner. What we're trying to do is ensure that the risk stays with the operator and that the operator posts the guarantees necessary to ensure that the operator will be the one that bears the risk, not the commission. Yeah.
Thank you, Mr. Freeman.
Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Freeman, Mr. Delahunty, for the testimony and the work that you've put into this. I've had the opportunity to read through your proposals, and I appreciate the presentation you've given today. Couple of questions, and so one question came to my mind based on Commissioner Gonzalez's question, but I think what I'm hearing you say is that it is important for the operator to demonstrate the financial ability to meet all of the obligations of the Act. And that's how you determine what path forward one needs to take for financial assurances. And I'm just thinking aloud here as I think about this term demonstrate. Do you feel like if you have an operator that's been operating in the state for 20 years and has never orphaned a well or walked away from an asset, has met their financial obligations over their 20-year life in operating in the state of Colorado, do you feel like that operator demonstrates a financial ability to meet their obligations under the Act if they have a track record of doing that? Or does it have to be an assumption that they that we just need to have the financial backing up front in order to determine that they're demonstrating that? So I mean, two different definitions of demonstrate, right?
No, I think just looking at the operator's past track record doesn't demonstrate that they have a current ability moving forward to meet their obligations. And let me just offer one example of why that's the case. You may have an operator that drilled all of its wells 20, 30 years ago. It drilled them back then, produced from them, generated good production for years. All those wells are tailing off right now. They may have low production or no production in some cases, but the operators continue to just operate them steadily, but without setting aside any money for ultimately plugging and abandoning and reclaiming those. So just that past track record doesn't tell you whether the operator will be able to meet its obligations in 10 years. There needs to be a showing of what kind of capitalization that operator has, what kind of net worth it has, and what, if any, money have actually been set aside for retiring those wells.
Okay, I appreciate that perspective. So let's talk a little bit about I think your criteria for asking for a variance that would allow you to access what now would be a tier 3 concept, right? Or some folks are calling it the choose your own adventure. And so I think you're indicating that you would like to see it go through a variance process, but limit the bar, limit the showing to financial hardship in order to be able to ask for that review. Is that what I'm hearing you? So I mean, right now the variance process has 4 or 5 different pieces that they would have to go through and to make a showing in order to be able to potentially grant that variance. And they would have to meet all of those, but you're limiting it to financial hardship.
No, thank you for the question. I think that's an important point. We described it as a variance. I think the point where it could potentially be implemented without requiring going through the formal 500 series variance provisions. Our point is that where the operator can actually demonstrate a financial hardship, and again, I want to emphasize that means actual evidence, audited financial statements, not just a letter saying I can't afford to do this, can demonstrate that he has a problem, that he can't do it, he can get more time. Another possible scenario there where that kind of an extension or variance might be appropriate would be if there's just a shortage of rigs and crews available to do it within the time period. You can imagine a scenario where the operator has the capital and the revenue to meet it, to do this in 5 years, but there's just no rigs available. You can see the commission allowing additional time there. Our key point, though, is that instead of going with the choose your own adventure approach, where the commission and the staff have to evaluate whatever operators come up with, keep this narrow, focused, and on one particular issue so that it can be done as efficiently and consistently as possible.
Okay. How would you feel about utilizing the term undue hardship versus financial hardship to allow for, which is a known term in our variance process, and may incorporate more aspects other than just finances?
You know, the objections we've heard to date to full cost bonding all boil down to financial hardship. So I'm not sure what circumstances other kinds of hardship would be relevant here, but I think, you know, if there are.
Well, I think an example would be what you just said, which is no rigs available, right?
Yeah, I think that would possibly be one option. You know, our point is that any kind of extension or variance should be limited and really require proof of serious hardship and difficulty, not just the operator. You know, it would have to be a high bar. And I think if there are conditions other than financial hardship, it might be appropriate to consider those.
Sorry for that. Okay, so let's talk about the blanket bonding piece, and understanding that kind of your default position is blanket bonding is inappropriate, but I think you've indicated, should there be blanket bonding, then this, and you've made some suggestions as far as what may qualify an operator for blanket bonding, including potentially utilizing some of the criteria proposed by Kinder Morgan. What I didn't understand in your proposal is, are you recommending a production threshold and these other things, or are you proposing to eliminate a production threshold to determine whether or not an operator would qualify for blanket bonding and just limit it to a financial analysis?
My recollection is that the Kinder Morgan proposal includes both. And I think we would, if I'm wrong, I'm sure they'll correct me. I think we'd support doing it both ways, with both requirements. Our point is that whatever framework the commission requires, it has to look at the financial strength of the company as well, because that's really the critical factor to whether the company can demonstrate its ability to meet those obligations.
So last question is,
if I could, sorry.
Yeah, no, go ahead if you want to.
There's one other key point that I think maybe a distinction between our proposal and Kinder Morgan's, but I think it's really critical here, is that if the operator is allowed to use blanket bonding, it needs to make its demonstration on an ongoing basis with annual reports every year to document its net worth, its credit rating, and so on. I don't believe Kinder Morgan is providing for that kind of annual submission, but I think it would be necessary to ensure that, for example, the operator still has a really good credit rating every year.
So let's talk a little bit about the Orphan Well program, and how do you see the Orphan Well Fund, however that's developed, or if it is developed, interacting with kind of general financial assurance requirements for existing wells? And I'm talking about existing wells, not new wells. And is there a relationship between these two things? Should they be considered in tandem as far as determining overall financial assurance, or should they be separate?
Well, I mean, I think there's certainly, you're right, there's definitely a relationship between the two of them, and they will inevitably interact with each other. We haven't done as much analysis as I think Mr. Sir and some of the other parties have, but we agree with the points that a lot of parties made yesterday, that these rules aren't going to create insolvent companies, they're just going to reveal them. And that in thinking about these rules, the commission should consider orphan wells and additional orphan wells as kind of a feature of the rules, not as a bug of them or not as an unintended consequence. And what I mean by that is that we know that there's a sizable number of companies, maybe thousands, that are, if you account for their asset retirement obligations, are just functionally insolvent and are not ultimately have wells that are going to be orphaned. And that the commission should look to these rules as a way of surfacing those wells, getting a handle on them, identifying them, getting a handle on them, and then using that information to size the orphan well fund in an appropriate manner to be able to cover them, and to set whatever fees are necessary aggressively to make sure that it covers all the foreseeable orphan wells that are going to be that are going to arise inevitably in Colorado. You know, one approach that I think was raised yesterday that I think we would support is the idea of sort of an amnesty program or a deadline for operators to turn in their wells. And the idea would be, and this could be actually incorporated in the phased compliance framework we described, the commission could set the standard for what's required in terms of bonding up and single well financial assurances for all wells, but give companies a deadline, 6 months, 9 months, whatever, to turn in the wells where they just know they can't meet that standard. And then once the commission has that inventory of new orphan wells, it can size the orphan well fee and make sure it's got enough to cover that whole body of orphans, and just wrap its arms around this and take care of it all up front in an aggressive way, and acknowledge that what it's doing is trying to solve a problem that's been growing in Colorado for 70 years, but do it up front, aggressively, and quickly. And we think the idea of an amnesty program could be one really effective way of doing that. The one question we do have about the amnesty concept is how, I guess, what kind of incentives or what kind of penalties an operator would have to face for turning in the wells. You know, one possibility would be the operator would give up wouldn't be able to operate in Colorado anymore. If that wasn't required, presumably you'd want to have some sort of penalty or downside to turning in the wells so that operators don't have incentive to just turn in more than they need. But I think those are details that could probably be worked out. Our point, though, is that we hope the commission will look at these rules as a way of affirmatively and proactively getting a handle on the scope of the problem and moving aggressively to address it, including using the Orphan Well Fund and an annual fee, as well as federal money to deal with it over the next few years. And Tom, if you have anything to add on that?
Yeah, I was actually just going to touch on that very last point that you made about federal dollars, which is just to say that this is a great time to be doing exactly what Mike is talking about, right? Where part of tackling the orphan well problem is making sure that the costs, that decommissioning costs are fully internalized, and that financial assurance rules are what do that. And if that allows this problem that we have to surface, that as Mike said, that's a feature, not a bug. That's a great thing. And there's federal dollars available right now to do that. There will be more federal funding available over the next 10 or so years. It just seems like now is the time to be using financial assurances as one piece of the puzzle in terms of tackling this larger problem of orphan wells that have been growing.
Okay. I think two other questions I have, I think. One is you had indicated your support for the financial assurance rules addressing federal wells as well. Are you in support of the proposal that Pitkin County put forward on this, or do you have a proposal on your own of what that language would look like as far as how to incorporate federal wells into our financial assurances?
Yeah, we support the language that Pitkin County put forward. We think that works well to accomplish the sort of right balance between, giving operators credit for federal dollar or for bonding that's been put up with the federal government, there probably are other ways of drafting that staff could play around with, but the core fundamental idea is that these financial assurance rules need to apply to federal wells. And if there are federal bond dollars that have already been put up, operators can get credit for those, and then they just need to make up the difference to bring it up to the full state requirement.
And one other point on that, I think Pickett County raised this in the presentation last night, is that even if BLM is looking at revising its own bonding rules, there's no guarantee when that's going to happen. Even if that's going to happen, it could be years from now. And that what the language that Pickett County is proposed and the concept that we support would easily accommodate any kind of changes in federal rules, because it just lets the company get credit for whatever was posted on a federal bond, and that some of those details and some of those issues could be dealt with, we think, appropriately through a federal state MOU. There's already historically been an MOU between the commission and the federal government covering APDs and permitting. You can imagine easily using that same vehicle to accommodate coordination of any bonding as necessary too.
And actually, one further point on the federal well question. I think you've heard already, and we'll maybe hear again, that BLM has the ability to sort of deal with orphan wells in ways that this commission might not. So, like predecessor liability, for example, is one that's always raised. But this approach that we're talking about here, where they get credit for federal bonds, wouldn't interfere with any of that BLM authority. We, and by we I mean Mike, have had conversations with some BLM folks, and they're on board and supportive of this idea of having basically federal bonds count toward state requirements. So just want to, I guess, make clear that there's some synergy and compatibility there with the way that BLM is doing things.
Okay, let me ask you an inverse on this question then, because there are certain local governments, and I'll ask local governments this as well, but there are certain local governments that are imposing financial assurance at the local level. How do you imagine, or how do you envision local government financial assurance requirements interacting with state financial assurance requirements?
Well, Tom, I'll let you start that one.
Yeah, I think we'll have the same answer. I don't think we've given that as much consideration as we have for federal wells, since that federal well piece has been more salient, especially to our clients. But I think that we would be open to the idea of doing something similar with local governments, where again, the sort of core overarching requirement is that all wells need to be fully assured. And if that's through some maybe somehow you get in a scenario where it's all three. I don't know if that's even possible, but maybe you have federal dollars and local government dollars and state dollars. It doesn't really matter, I think, as long as you're at the point where where wells are fully assured.
Yeah, I would agree with that. I think we want to defer the local governments in this. There may be issues there that we haven't thought about, but the approach Tom describes sounds reasonable to us without having given it really the kind of analysis we have with federal wells.
Okay. This is really my last question. You've expressed some concern about the ability to require certain financial assurances for transfer of assets. Do you have suggested language on how that can be addressed, or are you suggesting that maybe it's not effective to have full cost bonding for transfer of assets?
As Tom mentioned earlier, we think that it's valuable to require it, and that the commission should absolutely require it, but that it's not a solution in and of itself. The current December draft requires full cost or single well financial assurances for transfers of all new wells, but not all new wells at the time they're spud or drilled. What we're frankly unclear how, if commission's relying solely on transfers, how it would enforce that requirement, or what its recourse would be if an operator said, we've signed our contract, we've executed it, we've had our closing, the well has been transferred, the new company owns it, and the new company, the transferee says, look, we don't have the asset, we don't have the capital to bond up, we can't do it. We're not clear what the solution might be there. One possibility might be to say, all right, the seller retains liability in that situation. But, we've heard legal concerns from staff and the Attorney General about that option as well. So our point is that requiring bonding up on transfer is certainly a valuable step, but it can't be the only step. There needs to be full cost bonding at the time of drilling on the wells.
Thanks for your responses. I appreciate it.
Thank you, Commissioner Messner, for the questions. I see Commissioner McGowan, followed by Commissioner Nanjapa.
Thank you, Mr. Chair, and thanks for spending time with us this morning. And I apologize. It's hard for me to pull my notes up and be on my computer at the same time. I think for single well financial assurance, you all were suggesting a flat amount. No, so the operator would be able to share their portfolio and say, and then we determine what single full financial assurance is. So when we say we want everything fully bonded, how are we determining what that is? And I'm sorry, if you did present it in your presentation, I spaced it.
No, you didn't miss anything. We actually didn't, in our comments, get into how you would calculate single well financial assurance. I think our point here, I think it's similar to what some other parties have said, is that what's key is that the single well financial assurance has to accurately reflect what the actual costs are, a reasonable prediction and estimate of what the actual costs are going to be for plugging and abandonment, reclamation, and remediation. We also recognize that there's inevitably going to be variations in different wells, different locations. This is not something where the commission can pick a particular number and apply it to every well across the state. If you do that, inevitably you're going to be under bonding some wells and over bonding other wells. At the same time, it's also critical that calculation be done in a conservative manner so that you ensure that the commission errs on the side of requiring a larger bond to make sure that the funds are there, and that it doesn't end up subsidizing the operator by imposing too small of a bond. And we think there's probably at least two ways to do that. One would be a kind of matrix approach, which is what's in the current draft. And I think Dr. Allward suggested what looked like a really good, thorough approach to that last night. Another option might be the way EPA does it, which is to require the operator to get an independent engineering report estimating the cost for decommissioning the site. And what's key here is EPA doesn't let the operator or the company come in and have a letter signed from its operating manager saying we can close this for $10,000. It has to be an independent engineer that makes the estimate that can be used for setting the bond level. The commission could potentially even take both approaches. It could use a default matrix of what the bonding would be, but also let operators come in with an independent third-party estimate to calculate what the bonding level ought to be. And then I think, to answer part of your question, the operator could assemble an account that aggregates all those single well financial assurances, so it doesn't have to have 3,000 separate trust funds, but the amount of that account has to reflect what the aggregate value is for each well.
Thank you. And so following the line of setting up a trust fund or a sinking fund, are you all open, if an operator chooses that path, are you all open to, if an operator P&As a certain number of wells, they would be required to put in less into their trust the following year, and or allowing the operator to pull from the trust to P&A wells?
So let me answer the second question first. If the operator is P&Aing a well that's covered by his existing trust fund, then absolutely the operator should be able to pull from the trust fund to when it P&As the well. From our conversations with operators, it doesn't need to pull the money before it P&As the well. It can P&A the well, and then once that's signed off on, get the money out of the trust fund pretty promptly. So it doesn't. So the commission would be protected by a requirement that says, once we've signed off on this, you can take the money right away, but you can't take the money out before we've signed off that this was done properly and in compliance with all of our regulations. The question about kind of offsetting the single well financial assurance based on other plugging operations is more complicated and we think more problematic. Because, what the evidence indicates is that the plugging that's going on right now by operators is done for their own operational purposes. It's the carbon tracker slogan that they're only filling when they're drilling, that these operators are plugging these wells in order to facilitate new drilling. And it's not clear to me how letting them do that, if you then reduced the extent that you're that plugging that well actually that the well they're plugging for operational purposes is actually covered by an existing financial assurance, that's fine, they can get that money back. But it's not clear why that plugging a well for operational purposes should allow them to get a better deal or not meet their requirements or not demonstrate the requirements for another well that they're operating or drilling. Because it basically leaves the same problem out there for and the same risk for the commission.
Okay, thank you.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you very much, Mr. Freeman and Mr. Delahanty, for your presentation. I also just appreciate, the thought that you put into this and the simplified approach. And so Commissioner McGowan got at a couple of questions that I was thinking around with respect to the price tag. I also didn't think you had presented on a particular, cost or matrix approach per se, but appreciate your thoughts on that. I was curious, since you also mentioned, Dr. Allward's testimony yesterday. There's some, I think there was some good justification on the very steep costs that were proposed in that presentation. However, would that factor into the full cost as it relates to an independent engineering report or a matrix approach? Do you think there should be a cap, for example, on the amount that we would determine for the bond, or would it just be reliant on these different factors? And what are your thoughts on that?
So first, I have to confess I have not gone back and checked Dr. Allward's numbers. So I think any kind of matrix, no matter how elaborate and detailed, we want to ground truth it and with commission staff and make sure that matrix is based on the best available evidence to generate the most accurate calculation. But one way to do this would be is if the commission wants to adopt a default matrix, whether Dr. Allward's or some variation on that, or even what's in the current draft, that would be a kind of a baseline. And then if an operator came in and said, well, no, here, I can do this, presumably the operator would come in and use the independent engineering report where it thinks it can do it more cheaply. And I think if the operator came in and said, no, this isn't going to cost me $500,000, I can decommission this well for $50,000. I think it would be really have to be a judgment call on the part of the commission staff about how credible that engineering report is. And you can see the commission staff looking at and saying, well, here's the basis for our matrix, here's how we calculated this number. Is there something different in this site specific report or is there evidence supporting it that it makes it reasonable to conclude that for this well and this operator, they can actually do this for a significantly lower price, basically.
Okay, thank you, appreciate that. And then related to that, do you think a matrix to determine full cost should also include a calculation of remediation potential?
Yes, I think for the reasons Dr. Allward said, is that, it should try and address all the foreseeable categories of costs so that the operator is the one that's bearing that liability, not the state. So reclamation and remediation and P&A too.
Okay. And with, current proposals, for example, with the registration fee and the Orphan Well Fund, it's more based on the P&A and reclamation costs. Do you think there should be some accounting for the remediation costs, or we have, an environmental response fund? I think that's the right name. Would we want to include some supplementation to that, or do you have any thoughts on either of those things?
Tom, if you have anything, please jump in. I have to confess, I have not really looked carefully at that issue. So I would defer to other parties about, how best to accommodate that, whether that through the Orphan Well Fund or through another fee mechanism. I honestly don't, we haven't analyzed that issue.
Okay, thank you. A couple more questions. You mentioned, sort of support for the amnesty type of program. In your view, and I appreciate that you also noted, so perhaps some sort of fee or something like that. But in your view, would the outcome always be that the operator that participates is no longer able to operate, or is there any scenario where you could see that an operator could use that to sort of even up their balance sheets, kind of determine which assets they feel are costing them more than would allow them to be able to meet our regulations, and therefore be able to, maintain some solvency after moving some assets into the Orphan Well program?
So I don't think we would categorically oppose an amnesty program that didn't essentially eliminate the operator's ability to operate in Colorado. The concern and the question we have is there would have to be some significant penalty for the operator in that scenario, because otherwise, it can't. An amnesty program that just says, give us your wells, we'll take care of them, and you can continue operating, with business as usual, creates all kinds of incentives for operators to offload a bunch of wells and leave that, basically socialize the cost for the entire industry, which presumably would, and so the question we have is, if the penalty is not precluding the operator from doing business in Colorado at all, what would the penalty be? What would be the disincentive for operators to make sure that they're not just, that they, before they take that step, they know that there's a real penalty, so they only do it where they just cannot comply with the rules. It may be some kind of payment plan would work, but there's probably other options as well.
Okay, thank you, appreciate that. And then a couple other related questions. So you had mentioned, with your phase compliance approach, there's really not the specific need for the out of service well list per se, because as I understand it, you're just allowing the operators to determine which wells they're going to bond fully and which wells they're going to plug. If the out of service well concept continues through, do you have, you kind of commented on the fact that there's not a financial assurance requirement for those. Do you have an opinion on whether there should be some sort of bond while they're waiting to be plugged?
One approach might be, there is some similarities with the kind of the plugging list or the out of service well list and what we're talking about. You can imagine, one approach would be for the out of service well list to say, you don't have to post a bond, but any wells on that list have to be plugged within 5 years, and you have to, plug a certain number of those wells every year in order to stay compliant. What that would be is essentially half of our phased compliance approach. It would be a phased compliance approach for plugging those wells. I think the concern we have with the December draft is there's just no sideboards or no limits on when those wells have to be plugged. But you could do an out of service well list that says 5 years with 20% of your wells plugged each year, and if you don't comply with that, you're immediately required to post a single well financial assurance for every well that wasn't plugged in a timely way.
Okay, thank you. When these wells are, I know you have commented a couple of times in it, you know, that this would be more dependent on the operator or relying on the operator to determine which wells to be plugged. Do you have any opinions on prioritization as it relates to location in a disproportionately impacted community or high priority habitat, et cetera?
You know, I think it would certainly be a good outcome for wells to be plugged sooner or dealt with in high priority habitat or disproportionately impacted communities. You know, what we proposed in our phased compliance approach doesn't go there because our focus was on keeping this simple and letting the operators decide what order they should plug them in. And the idea there being, again, our overarching goal was for this commission to set the target the operators have to meet and let the operator decide, so that this commission doesn't have to devote resources to micromanaging that. But again, we would certainly not oppose some manner of incentives to, I think, incentives to encourage plugging certain wells. It may be, you could imagine an additional surcharge for a single well financial assurance in a DI community or in high priority habitat, so that operators can factor that in. There's probably ways to do it. It just isn't part of what we proposed.
Okay, thank you. Last question. For the wells that end up going into the Orphan well program, should there be an option for other operators to purchase those, or perhaps for them to even go into some sort of auction before they go into the program?
I don't see any downside to that. I'll defer. I mean, if other parties have given that more analysis, I'm sure they can weigh in. It seems like it might be an appropriate first step to save commission resources. I think you'd want, if you did that, to require that the buyer post a single well financial assurance, so that that whoever's assuming this actually is going to get it plugged. The one question we do have would be, is, what we've sort of heard from some companies is that to the extent that wells actually have value or have, real value for production or for other purposes, the operator is going to sell them to a buyer before they hit the Orphan well list anyway. The idea being, if the well goes to the Orphan well program and is then sold, presumably that revenue would go to the state, not the operator. But a rational operator is going to sell that well and get the cost, yield whatever kind of profit it can before it orphans it, if that option is available. So.
Thank you. Yeah, I don't disagree that that's probably, the typical course, but I think, I have understood from some operators that there are wells that are in the program currently that may be desirable. And so in that instance, you think there should be, or there could be an option, or do you believe that that would be appropriate to have an option for other operators to purchase those out of the program?
Yeah, that seems like a reasonable option. Just again, emphasizing that the operator buying it has to post a full financial assurance for doing so.
Okay, thank you very much.
Questions from my fellow commissioners? Commissioner Messmer?
Thank you, Mr. Chair. I lied. I have more questions, so I apologize. But it's a couple of things that came up made me think about a couple of things. But so do you just a general philosophical question? I mean, and I think that I know the answer to this, but do you feel like it's important that we kind of support and encourage operators to plug and abandon wells? And should we develop ways to encourage that in these rules? even if it's their own assets and they're doing it as a course of business?
I think the commission should, that the best way to encourage them to do that is to require them to post a full bond. That the most effective way to incentivize them to do that is for them to know that they've posted a bond, and that they'll get that bond, they'll get that bond back even when they decommission the well. But that other kinds of incentives, and I'm gathering I'm thinking maybe you're thinking about the idea of letting them plug certain wells in exchange for not posting a full cost bond for other wells.
Well, I think there's different ways that you can, I think, encourage that activity, ultimately with the goal of seeing less productive wells get plugged and abandoned. And I think that's the whole concept of the out of service well list and the plugging list as a way to encourage operators to plug and abandon unnecessary assets. There are ideas that are going out there like utilizing the ability to offset 2-to-1 for new single well financial assurance by plugging and abandoning, reclamating and remediating, two wells in order to get some credit for the one well, or perhaps taking one well off of the orphan well list in exchange for one single well financial assurance. There's another concept that's that I've been listening to, which would acknowledge that some operators have very significant plugging and abandonment line items in their budget and plug and abandon hundreds of wells annually, but in an analysis for determining whether or not they may qualify for blanket bonding or some other financial assurance mechanism, would acknowledge that demonstrated activity, that demonstrated spend annually, and give them some percentage of that as credit towards their financial assurance obligations if they can continue to demonstrate that activity. So I'm wondering your thoughts around that.
Sure. So let me maybe take a step back. And as we think about it, there's, broadly speaking, maybe two big pieces here. The one piece is, what's the best way to deal with the existing problem and the existing inventory of wells that either that lack adequate financial assurance or that have low production, and how do you make the transition to address those wells and get as many of them as possible either bonded up or plugged and abandoned? And that's a difficult, complicated effort that is going to take some time. The other piece of this is how is the commission going to work prospectively? That moving forward, how is the commission going to ensure, and we think this is critical, ensure that future wells and currently productive economic wells are also covered, so that later in the life, 5 years, 10 years, 15 years down the road, the same problem doesn't fester and grow again. And our concern with the idea of giving operators credit for plugging certain wells is that you may help address problem one, the problem of making the transition and dealing with the existing inventory of wells, but you do so by undercutting the second piece, which is making sure that the commission's got this straightened out moving forward. And so that's really our concern, is that you don't want to basically get one well plugged now by creating 2 wells or 3 wells that are inadequately bonded going forward, and they're going to wind up being a problem in 5 or 10 years down the road. And so I think, if while the commission can and should ensure operators or encourage operators to plug their wells, it also needs to make sure that moving forward, new wells and currently economic wells are covered so that this problem doesn't come back in 10 years and haunt you.
And I would add 2 things to what Mr. Freeman's talking about. There's, in terms of financial incentives, if what we're looking at here is some sort of avoided cost, the avoided cost for a new well is probably about the same as the avoided cost for an existing well, right? So if an operator is required to post a bond for a well that they already have, the ability to avoid that cost by plugging it is really the same as if they plugged it in and avoided a cost for some new well, right? So I don't think that the way that Mike's talking about it is we don't want to like borrow from the future to provide those incentives now, if those incentives can be imposed without having to do that. And then secondly, to the point of sort of filling where they drill, if operators already have robust plugging programs that are associated with ongoing operations, financial incentives are already in place for them to plug wells. If that's something that they have to do in order to drill new ones, then, and they're doing that already, to me, that is evidence that there are already good financial incentives for operators to continue doing that. And there's not necessarily a need to sort of, reward that by, again, borrowing from future risk avoidance.
I mean, I hear what you're saying, but I also have heard testimony that indicates that that is actually not occurring from Surface Owners Association or local governments that indicate there are a number of wells out there that are not being addressed. And so this is part of what I'm trying to get my head around, right? So, so I'll leave it at that. I appreciate your answer.
Great questions here. Other questions? Commissioner McGowan?
Thank you. Sorry, this is a last question for me. The slide that you showed, it was at the beginning of your presentation related to the financial health of an operator. And I think it had something like 20 times. It was at the beginning.
I think are you referring to the self-bonding slide or?
Mm-hmm.
Okay.
Is that an EPA rule, or is that an actual statute that requires when they're self-bonding that the operators show that they have net worth 20 times the P&A and reclamation costs for their portfolio?
So there's a couple things here, and I can walk through this and add some detail. What you're looking at here is a combination of what's required by Colorado statute for self-insurance and what's in Rule 701B2 of the December draft. The statute, if I'm remembering correctly, requires and there's quoted language about sufficient net worth to guarantee performance is from the statute. And the statute also requires that demonstration be reviewed annually. So that's a Colorado state statutory requirements. The provisions for audited financial statements and the net worth 20 times P&A costs, as well as consideration of obligations under states. I believe that is actually in the current 701 rule proposed by staff. That's what staff is proposing for to require for self-insurance. And I believe that's actually and the staff can correct me if I'm wrong, that's a codification of their existing practice, which is through guidance. And
Okay.
Tom, the other provisions, if you like, I can go describe the EPA ones too, if that's helpful.
Yeah, you go ahead. I don't know how I missed that 20 times piece when I was reading the rules, but thanks for clarifying that.
Here, what we're suggesting, and this is from the EPA guidance, is that for UIC wells, the EPA guidance requires full cost bonding for every well. But if an operator wants to self-insure, it has to make a showing that it's a pretty involved requirement, but some of the features of it are to require, they have to demonstrate they have a certain high credit rating, so that it defines, AA, BB, so on. There's specific ratios for minimum net worth, debt to equity, liabilities, and net profit, and it actually specifies what the ratios are, so it's kind of a calculation issue. And then EPA also looks at, does the operator have 5 years of remaining economic life on its field, and does it have a good compliance record? And there's some other features as well. So, and all that's in, we've attached that guidance to our November pre-hearing statement. So if you'd like to see it, it's there. I think it's one of the exhibits to our November pre-hearing statement.
Okay, thanks. I've been thinking about for operators who, assuming that we have some sort of tiered approach, and there's still, I don't know if we're going to call it tier 1 or tier 3 or 5, whatever, that allows an operator to have a an individualized financial assurance plan, I've been kind of thinking about what the guardrails should be to allow you to pick an individualized. And for me, one of them is your ability to show your financial health. And, one of those guardrails perhaps could be, debt versus assets, or your net worth versus your liabilities. And so I'm just trying to figure out kind of, are there some things we could put as guardrails to, if you're going to choose the individualized financial assurance plan, you're going to at minimum come to the table with certain things that you have to show us, so that we know that you're financially in a good place. So I think those are maybe some good ideas. Thanks.
Yeah, the EPA guidance, and also I believe Kinder Morgan's proposal, which is derived from a different EPA program, I believe, but they could provide some useful models for doing that. And again, as we indicated, what that kind of a tiered approach amounts to is some level of self-insurance. And so an annual showing by the operators would be really critical to make sure that financial health criteria remains current.
Won't work here, everybody. Any further questions for the panel? All right, thank you both. I don't have questions because of the depth and breadth of my fellow commissioners' questions. Thank you for your time and for your continued participation with us. We do appreciate it, and we will allow you to Zoom away and bring in the affiliated local government coalition.
Thank you.
Mr. Chair,
Thank you.
this commissioner needs 5 minutes, please.
Okay,
you.
it's 10:26. Why don't we just, take a short morning break and return at 10:35. That gives us 9 minutes, and that'll give the affiliated local government folks to get on board.
Thank you.
All right, we are closing in on getting everybody ready. Ms. Peranos and Ms. Burke, are you the presenters for us on this matter?
Yep.
Great.
Yes.
Give us just a sec to get everybody back on board and we'll get going. All right, welcome back, everybody. It is 10:36. Let's get started with the Affiliated Local Government Coalition.
Okay, good morning, commissioners. Excuse me, Kate Burke from Boulder County, speaking on behalf of the ALGC, which comprises Boulder County, City and County of Broomfield, the town of Erie, the city of Fort Collins, city of Lafayette, city of Longmont, and La Plata County. I'm going to go to the next slide, hopefully. While I drink some water. We have worked hard with our local government peers and some of the conservation groups and support many of their comments in general and also in specific. So I'm just going to drink some water while you take a look at that. I think no surprises there. Okay, and then this is the language that got a lot of attention yesterday. I'm very eager to discuss this with you further, having listened to your discussion with Mr. Suri yesterday, and I do hope you have further questions for us. This is an important issue. However, we plan to talk about other things in our allotted time, so that's just my very broad-based hint to ask about it. All right. The first main issue I'm going to speak to is this 80th percentile concept. You heard it mentioned yesterday. I just want to raise it again because I think, again, it's an important concept. There's no magic to the 80th percentile as opposed to the 77th or the 84th or wherever you want to land. But the point is to capture the majority of known costs under that bell curve so that you have that degree of assurance that you have funds on hand or the operator has funds on hand. And this is just in contrast to various parties and staff's use of averages and medians, which will be sufficient by definition in only 50% of the cases. So we urge you to take more than a 50% level of assurance. And we're asking that that 80th percentile concept be applied to single well financial assurances, both for plugging and for reclamation. And then we also propose that it form the basis of the blanket bond amount. So we agree with other parties that the proposed blanket bonds are too low. And moreover, we don't know where the numbers came from or how they were derived. So in the absence of a 100% bonding world, which is pretty apparent not where we live, to improve transparency and trust in the process, the blanket bond should be based on the single well financial assurance amounts. If those are determined adequate, that should be the basis. And again, we'd like those to be at the 80th percentile mark. And then after that point, tier 1 operators can then obtain discounts based on their demonstrated compliance, their financial strength, the size of their producing portfolios. And perhaps other operators can use on-ramps, timing on-ramps or devices like sinking funds to achieve those amounts. But we are proposing that they be based as a starting place. They are based on that same 80th percentile concept. And in general, I do want to echo support for a lot of what Mr. Freeman and Mr. Delahanty were just saying about both tier 1 definitions and about blanket bond amounts. The second main issue is also addresses blanket bonds. In thinking this through, we felt that there should be 2 levels for the shallower and the deeper wells in the same way that the single well financial assurance is set up. Based on those proposed amounts, it appears that staff believes plugging wells deeper than 3,000 feet is significantly more expensive by a factor of 3 than plugging the shallower ones. And if that's the case, then a blanket bond, a tier 1 operator using blanket bonds could very well be either over or under bonding, depending on the depth of the wells in their portfolio. So the blanket bond amount should also be distinguished in the same way. And then secondly, the draft doesn't indicate whether those blanket bonds amounts are for both the plugging and the reclamation. We appreciate that those two things have been separated under the single well financial assurance definition. We think that's an important distinction. But blanket bonds, it's unclear whether they cover both. We presume they are meant to cover both. Administratively, it would be extremely difficult if they did not. And also it would leave uncertainty for the parties. So we recommend that they really should cover both, which means the amounts need to be based on a combined 80th percentile approach of what we consider appropriate for single well financial assurance and reclamation. Yes, so I think that's self-evident what I'm getting at there. And then we feel strongly, like Western Resource Advocates, that the reclamation piece should be measured per acre and not per well. Dr. Alward had much better photos on this yesterday, but I just wanted to demonstrate how different a single well, an older single well setup could be. This is a Boulder County setup where we have a wellhead and then we have an associated tank. There's a flow line between these two. There's an access road coming into just this facility. There's this disturbed area between, and then I'm not sure if this piece is also associated, but if this one well is being decommissioned, this entire surface area needs to be reclaimed. Whereas this is an operator's earlier and now dormant proposal, but it just demonstrates how 36 well heads can and the associated equipment can be, in modern terms, planned so densely. So again, if you were measuring reclamation per well here, that would be kind of an absurd comparison to what it means to reclaim per well over here. And then, as Mr. Sura also mentioned, in our experience reclaiming land after development and after various disasters, the actual work done is measured and the materials needed are measured per acre. So it just is a much simpler way of defining what the operator's obligations are. And then to Mr., I think it was Commissioner Messner's question yesterday, we're not recommending that the same numbers currently in the reclamation matrix be just converted all of a sudden to per acre. We would need, staff basically would need to determine appropriate per acre amounts. But we think the switch to per acre measure rather than per well is critical. And that leads to my turning it over to Elizabeth Pranius.
Thank you so much, Kate. Elizabeth Pranius, I represent Broomfield and the City of Lafayette, who are members of the ALGC. So the first thing I wanted to talk about today are Rules 705A and B, which are the general liability and the environmental liability insurance requirements. The minimum general liability limit, which is currently $1 million in the current rules, as well as in the staff proposed December 7th rules, is $1 million. We think this is grossly inadequate for the following reasons. Property values in ALGC jurisdictions have increased significantly, in particular over the past year. We submitted information in our response statement showing that the median sales price for a home in Boulder County was approximately $1.5 million in April 2021. This represents a 55% increase from the year before. The median sale price of homes in other ALGC jurisdictions also has gone up significantly in that same time frame. Specifically, the median sale price of homes in Fort Collins and Longmont have increased by 16.5% and 8.1% respectively. And the median home price in Broomfield also has risen during that time and currently ranges between $329,000 and $633,000. As you know, general liability covers both property damage and personal injury. So the $1 million limit in the current rules, and as I mentioned in the proposed rules, would just not be adequate to cover damage to many homes alone in ALGC jurisdictions, let alone whether there's any personal injury that occurs with any kind of environmental accident. So we recommend an increase to $5 million to make sure that there's sufficient insurance set aside to cover property damage and personal injury in the event of an accident. Similarly, with respect to the $1 million limit for environmental liability, we think this is also inadequate. I want to stress that we really we support this requirement and appreciate that staff added this requirement to the rules. There is not currently a requirement in the financial assurance rules for environmental liability insurance. However, the Commission's draft October 29th statement of basis and purpose noted that, quote, remediating the most expensive spills of large volumes of hydrocarbons that reach groundwater may cost as much as $25 million. So we think the $1 million limit, again, needs to be raised to at least $5 million. If you could go to the next slide, please, Kate. Thank you. So then I want to talk a little bit about leaks from idle wells and plugged wells. You've heard some of this already today. I just first, again, want to start by acknowledging and thanking staff for adding a requirement to Rule 434 D12, which requires an AVO inspection. That's an auditory, visual, olfactory inspection of inactive wells. We appreciate that staff recognizes that leaks from idle wells can contribute to climate change, in particular near-term warming caused by methane emissions. They can also contain VOC emissions that contribute to regional ozone pollution and contain toxic air pollutants, including benzene, which is a known human carcinogen. However, an AVO inspection is really not the most reliable way to detect a leak of a colorless, odorless gas. We recognize that the AQCC does have an instrument-based inspection that does apply to idle wells, provided they're still pressurized, which we understand would occur in most situations. And that is pursuant to new rules that were just adopted this December by the AQCC that would require an annual inspection of idle wells.
Ms.
However,
Morales,
yes.
forgive me, but your time
Sure.
has expired.
I thought we had 11 minutes, really? Oh, okay.
Yes.
We went quicker than we had anticipated. Okay, I will stop, but if you have any questions about what we're proposing on the leak inspections, I would really appreciate it.
Please, Ms. Pranos, explain further your issues on the leak inspection protocol.
Thank you so much, Commissioner. So in short, the AQCC does require instrument-based inspections. That would be at least an annual inspection requirement of an idle well. However, and what COGCC has proposed is an AVO inspection. As I mentioned, instruments can detect colorless, odorless gases, whereas sensory-based AVO inspections are not as reliable, and this is demonstrated by reports that operators submit annually to the AQCC, where they show that they find very few leaks with AVO, but they find almost all of their leaks using an optical gas imaging camera or other equipment. So what we're recommending is just a simple notice requirement, so that the COGC require operators to provide a notice to the COGCC, sorry if I said that wrong, that the COGCC require operators who are subject to the AQCC instrument-based leak detection and inspection requirements notify COGCC anytime they find a leak and or repair a leak of an idle well. And that way COGCC will know for certain whether any of the leaks, any of the wells that are on the out of service list or are temporarily abandoned or are inactive are leaking, and whether those leaks have been mitigated. And we think this is really would provide critical information to COGCC, in particular, given the lack of specific timeframes for operators to plug wells that are on their out of service list, because the director could then prioritize wells that are leaking or wells that have been found to be leaking, for example, over wells that don't have any integrity problems. So we're not asking for a duplicative requirement, we're simply asking for a notice requirement.
And your ask would be to not have the AVO inspection?
Personally, I think that's redundant
Okay,
because in particular, AQCC also requires monthly AVO inspections. So operators do already have to do those inspections. And the AVO inspection that's been proposed without any kind of record keeping or reporting requirement, of which there are none in Rule 434 right now, I just don't think that's going to provide any additional information to COGCC, nor necessarily any reliable information.
okay, great. Did you have anything further for us, Ms. Pranos?
I was simply going to just say, as Kate already said, that we do support the recommendations by Adams County and the Brighton group that would provide some more clarity to when wells need to be plugged that are low producing wells. And so those recommendations, it's basically a 2-year time frame in which to either plug a low producing well, provide single well financial assurance for the well, or bring it back into a higher state of production.
I believe we're hearing from Adams County next, so we'll look forward to that. Ms. Burke, talk to us about Rule 211 and your perspective, your group's perspective on that.
Yes, I would love to. Thank you. So just some comments from yesterday's discussion, and then of course open for questions. One thing I heard yesterday was questioning your authority and maybe the wisdom of putting the commission in the chair of deciding whether a well is still used or useful. But I just wanted to point out that this is in your Rule 211, I believe, as the proposed Rule 211 already deals with this and gives you the authority to hold these hearings. So the only thing, I just want to make sure it's clear that the only thing we're asking for is not a new proceeding or a new task for you to complete, but simply an ability to bring particular wells to your attention under this rule that you already have. And then that hearing, of course, turns very much on the definition of used or useful. This is what you would be working through in such a hearing. And again, the proposed definition, which we are comfortable with, I think captures most of the issues that need to be addressed. This rule, you'll see, does not have specific numbers or concrete objective thresholds, and I don't know that that's really possible or workable. So no matter what, in these hearings, you are going to wind up in something of a balancing task, which is what quasi-judicial bodies do all the time. And I think the idea that we're interested in is that it's one thing when you have some of the wells that other parties have talked about that they haven't produced anything for several years. That's probably an easier determination. What we are interested in is that a well that does produce for a day or two a year, or produces a slight trickle every day, may be so outweighed in its benefits and detriments. It may be so outweighed by other concerns, threats posed to public health, safety, et cetera, overriding concerns regarding the surrounding land. So as was discussed yesterday, land uses are something I want to point out. In Boulder County, after the 2013 major flooding, the terrain changed and the county and the state worked together to remap. So there are now floodplains and floodways where there were none before. So natural hazards can change and show up where they were not before and encompass a well that was previously not in the situation. So there could be a variety of situations that require greater scrutiny on a well that may or may not be producing a small amount. And your outcome after this hearing may be, we've weighed the potential current or future productivity and benefit of this well against whatever countervailing interest the local government, for example, has brought up to us, and we've determined that it balances such that we consider this well still used or useful. That may be the outcome, or it may go the other way. But this is the task that proposed Rule 211 is already setting forth for you. And what we're asking is that either the local government and the surface owner, who know best, honestly, what's going on the ground, can bring these specific wells to you for this consideration. I'm not sure how else you as the commission are going to find out that well A, B, or C requires the scrutiny, other than those folks who are directly on the ground with that well, bringing it to your attention. So then some of the other things that came up yesterday were burdens of proof and how we were picturing this actually happening. And so these are just some preliminary thoughts. These are my thoughts, basically. We haven't had longer discussions with the larger group. But the way I envisioned it was that there's basically two levels here. The first is the relevant local government or surface owner needs to show that they're entitled to a hearing at all. So they're filing an application or a petition or whatever the terminology ends up being. And they're making a showing in that filing that there are reasons to consider this well, whether it's used or useful. And so, for example, if you so wished, you could set this up so that a hearing officer could take the first stab at this. Let's just say Boulder County brings an application. We need you to look at well A, and here's the reasons why. And then the operator of well A comes in and says, no, this is, you haven't made a showing. This is, frivolous, or whatever they want to say about it. And the hearing officer, for example, could take the first stab at whether the application itself simply shows entitlement to a hearing at all. And that's what we would rather not, of course, go through that preliminary step, but in order to acknowledge concerns with frivolous or numerous meaningless applications arriving in front of you, we are willing to be vetted this way. And then if we are found on the basis of our application to be entitled to a hearing, then we have the hearing. And then as the applicant for the hearing, we would still bear the burden to actually show that this well or location is or is no longer used or useful. And so then we would walk through those criteria that are in that used or useful definition at the hearing. So we would actually bear the burden of proof twice, first to just get a hearing on the books at all, and secondly, at the hearing itself. And then at the hearing, your job would be to walk through the used or useful definition, the evidence brought by all the parties, do the balancing of the considerations there, and make a determination. And I just want to point back to the language that we had proposed and the issues around the land use concerns phraseology that we'd put in there. What that's doing is just tying to this section E here, other relevant evidence. And so while we were doing, if you look at the language we proposed, we were adding the way that red line read, which I'll go back to in just a second, but it says other relevant evidence such as natural hazards, DI communities, land use concerns. This were simply meant to be exemplars of what that other relevant evidence might be. And so those examples are not necessary to the rule, the rule changes we had proposed it. So that's kind of my spiel, and I'm happy to answer questions. I don't know whether it's best to go back to the red line we proposed or stick with some of these slides. So I'll leave that for a moment and let you ask me.
If you could go back to the red line. And so I think in discussion we had with Attorney Matt Sura yesterday, the concern from some of the commissioners was this, I think we're comfortable with the quasi-judicial hearing process over used and useful, because that's within our sort of realm. I think this commissioner is also comfortable with the concept of, if there's a threat to public health, safety, welfare, environment, et cetera, which I think is in the current rule. I think the concern was bringing in in particular, the sort of land use considerations and foisting upon this commission sort of making a balancing act between well that may still, may or may not be economic or used or useful, but ought to be in a subjective manner removed so that we can now have more agriculture or a different use, et cetera, and how that could sort of get interwoven with private contractual rights, et cetera. So what is your perspective on that issue from your group's point?
I think this is a great point, and I will say that even among the broader local government group, that very issue was raised, and some local governments didn't really want to have the land use concern language in there for the very reasons you're talking about. And so we're quite comfortable with tweaking and polishing up this proposal, because I think as you asked questions about it yesterday, it was, oh yeah, it's really not as clear as it could be. The reason that language is in there, what was in our minds was not, I'd rather build more houses, I'd rather have a golf course, I'd rather have a nicer view. It was urgent or really critical land use concerns, such as, because of development patterns, a desperate need for a school and no place to put one, or the well exists on the edge of or in the midst of a DI community, and there's a desperate need for affordable housing, and the well has very minimal or no economics. So it was originally in our first discussions, that said extraordinary land use concerns, because for the very reason you're discussing. So that's how we envisioned that, was not simply a preference for a neighborhood to be there, but something more pressing on this issue of land use. But again, I personally, and I would speak for our coalitions, probably be comfortable with that BB just ending after the word useful there, because that's what it's really all about, is the other relevant evidence to used or useful.
Okay. I appreciate that. I think I like that approach as well. And appreciate your walking through sort of the burden of proof component of all of that. And at the appropriate time, I'll be asking our AAG about that. I think that burden of proof is sort of solidified within the Administrative Procedures Act anyway, and we may not need to sort of, double down and state it in the rules since it's already there, but we'll do that as we get into deliberation. But I appreciate where you were noting burden of proof and that it does remain on the applicant.
Well, and one further comment on that, that's how it was previously for local governments to, get party status, for example, but the mission change changed that. So we now have automatic standing, and I guess what it comes down to is we're not demanding automatic standing here, as opposed to, for example, in the OGDP hearings.
Okay, great. I'm going to minimize the screen share so I can find my other commissioners' hands that may be raised. I see one. There's Commissioner Gonzalez, followed by Commissioner Messner.
Thank you, Chair Robbins. Thank you, Ms. Paraños, Ms. Burke. Appreciate the information this morning. I want to stay where we're at with this Rule 211 hearings under 503G and your proposed language. And I really appreciate you kind of dissecting this burden of proof for us a little bit more than we had yesterday. I want to dig in just a little bit deeper and understand what you envision being kind of the minimum for an applicant to achieve a showing in their application to result in a hearing.
Certainly. So we, as we say in this red line, the first necessity is that a well has been in low producing status for a minimum of 12 months. Previously, it said that it was inactive and zero production for 3 years. And we changed this to low producing for the reasons that I think Mr. Sura talked about, and that you've heard from some other parties too in other contexts, that you can have very minimally producing wells, but not inactive, that have very minimal positive benefit, but might, in the right circumstances, pose some of these other threats or concerns. And so we think it's important that it's low producing is the trigger, not inactive. We also think 3 consecutive years of zero production is too high of a bar, both because it's unusual. Well, I don't know, it's unusual, but it's like there's no other category like that in the proposed rules. This is a new classification invented simply for this. And so that just doesn't make logical sense. But then on a practical level, it can also promote the kind of gamesmanship that we've mentioned, where or maybe it's not even gamesmanship, but it's just a practicality where the well is turned on for a couple of days a year for whatever reason. But really, in a real sense, is not producing anything beneficial. So that's why we changed it to low producing, minimum of 12 consecutive months. And then to bolster that, we added accompanied by the actual production averages. So for example, low producing is less than 2 barrels of oil, or I think it's 6 MCF per day. So if the well is right at that level, that's one consideration for you. If it's at something significantly lower, but more than 0, that's also significant. So I think those 2 pieces together are going to indicate that this well is questionable. It's of questionable value. So that's number 1 showing. And then number 2 showing really does presume that that well has some value to somebody. And so the number 2 piece is, here's why this is the countervailing interest, as I'm calling it. There's some concern or threat posed by this well that we believe outweighs its economic value. So there's 2 pieces that we were willing to have to show. And then, of course, the industry can come in and say, you haven't shown one or the other of those sufficiently.
So, I mean, I guess what I'm getting at is in your rules that really the 12 months is kind of a standard, right? It's the baseline. It's not really a showing. It's more of a, hey, this well's either producing or not for 12 months.
Right.
Clear. And then for the second one, it's basically what it seems to me is just simply a claim that this well is either a threat or is no longer used or useful. And I'm curious, is that all it would take? Is just the claim? Is just the magic words of this well is no longer used and useful? And I'm just trying to envision how we could avoid gamesmanship on behalf of the local governments, saying something like, hey, this is no longer used and useful, then getting a hearing, and that creates potentially a standing or maybe even some presumption, and it could be any reason. I'm just trying to see, how do we sideboard this a little bit better to make it more precise, so we don't just have folks saying the existence of any well is a threat to public health, safety, welfare, the environment. The existence of any well that produces under X amount is no longer used and useful.
These are great concerns, and I think, as Chair Robbins mentioned, probably AAG Davenport is going to be critical on this. But what has happened in the past, and I think is appropriate here, is that in the hearings process, the hearing officer, who I think is the right person, would be applying what we call the rules of pleading. And so the applicant has to plead with sufficient specificity, I think is one of the phrases used. So simply reciting that this is a threat to public health, or there is other relevant evidence here, is insufficient. And there's a lot of court guidance on that, of the specificity that the applicant has to go to. So what I would, to me, that's the safeguard of the commission, is that application. Because, as I said earlier, we're not asking for the automatic standing that we now have, that the relevant local government now has for example, in the OGDP process. We don't have to allege anything. In this process, we're saying we are willing to be required to allege threats and other relevant evidence to the level of specificity that's required under the APA and relevant case law. And so, as an example, in the past, that was the standard we had to meet simply to participate in a, what was it? I guess, DSU hearings, for example. And so we were not allowed to say this poses, or it was insufficient to say this poses threats to public health. We had to be exact about what features, in what way this precise application and the precise project associated with it was going to pose what kinds of threats and to whom. We had to allege all of that at the very front end. And that's how I'm picturing this.
That's super helpful, Ms. Burke. Thank you very much. I think Chair Robbins wants to interrupt me to let Mr. Davenport speak.
Mr. Davenport, would you like to provide some perspective or weigh in on this? It's not normal how we do it, but you're our legal expert.
I'm happy to, Chair and Commissioner Gonzalez. I don't believe that I disagree with anything that Ms. Burke has stated so far in regard to standards. What I think may be helpful to point out is the commission already has, and it's primarily done through the hearing officer, a process for motions to dismiss applications or protests or something along those lines, that an applicant, if there's a protest, can move to dismiss that protest on the grounds that it does not meet the legal standard. Is a case that the Warren case that provides the standard for motion to dismiss. That's relatively commonly used by applicants who request that a hearing officer dismiss a protest. And commissioners, I believe you've seen that before in recent pleadings or recent cases. And I think, so what I'm chiming in to say is we generally already have that process, and hearing officers are familiar with that standard that I think is the same standard that Ms. Burke has been discussing today.
Thank you, Kyle. Chair, I've got another question, not along the same lines. Again, thank you, Ms. Burke, for your response there. I appreciate the discussion. My next question is going to go to the insurance that Ms. Perania has presented on. And I'm really trying to understand this a little bit better because I don't understand how insurance is called upon, how it's used, how it's leveraged, its sufficiency to date. And so I guess the question I have is, as it currently exists, we've got $1 million in general liability insurance for operators in our rules. How has that been used in the past? If you have any examples, and are there any examples of it falling short and then the operator not being able to cover it? What does that look like? How is it used, and how do we determine the sufficiency of it as it's been used to date?
Thank you for that question, Commissioner. So honestly, I have not researched how it's been used in the past. I think, our concern just stems from sort of looking at the limits, as I mentioned before, and in particular that the $1 million general liability limit has actually been on the books since 2008 and hasn't risen at all. And given that it is supposed to cover, were there to be an insurance claim, right, where an operator to need to whether to be some kind of injury to someone's property or personal injury, and the operator relied on their general liability insurance to cover the costs of that claim from, say, a property owner or an injured person, and the injuries exceeded $1 million, there would not be sufficient insurance to cover the damage, or the operator to be found liable if the only amount they're required to have for insurance is $1 million and the home value was $1.5 million, and say there was personal injury, a person was killed, for example. So we're just simply looking at it just strictly from a sort of mathematical basis, and I will say that Brad Gibson, who is a member, he's a citizen of Broomfield. He was on the Financial Assurance Task Force. And this was one of the issues that he raised at the time. And he worked in the insurance industry for over 30 years. And sort of based on his experience as someone who worked for the insurance industry, he looked at the $1 million limit and said, this is just woefully inadequate to cover potential damage to property. He was focused on Broomfield in particular, but when we looked across the other ALGC jurisdictions, we found that there's high property values in other places as well, and I'm sure that's true with other parts of the state, of course, also. And so we're really basing it based on his professional judgment and expertise as someone who worked in the insurance business for over 30 years.
Thank you for that. I can tell you that I can appreciate the theoretical approach to this, but it helped me a lot more if I understood why it's insufficient or if it ever has been in the past, something to tie these changes to. So that's just a comment. I know this is kind of too late for you guys on that, but if I can put anyone who's going to bring this forward to us on notice later in the day or tomorrow, that would be helpful for me to consider this a little bit further. So I appreciate the comments.
Thank you.
Alan?
I'm not sure what you said, but I'm going to pretend that it was me.
Let's say you. Go ahead.
Okay. So following along the lines of what Commissioner Gonzalez was asking, is another way to try to tackle whether or not general liability or environmental insurance is adequate is for a relevant local government to present its concerns or case as part of an OGDP process. So that I realize that's at the beginning instead of already existing wells. But if the local government thought, so I'm going back to the folks from Paonia who are worried about offsite potential ramifications of development, right? Would that local government be able to say, or come to the commission and say, we have a precarious irrigation ditch that's going to require enhanced environmental insurance, and make their point that way in front of the commission? Or are you saying that you think existing wells also have inadequate general liability and environmental insurance? Sorry, it's two questions and it's two different points, but they're two things that I'm thinking about.
Yeah. Thank you for that question. I mean, I think with respect to the first question, my understanding is that yes, the commission does have the authority to add conditions of approval to an OGDP. And so if a local government had a specific concern and they didn't feel like the rules already addressed it, that is something that they could request that the commission review as part of the hearing on the OGDP. That does not, as you just acknowledged, address existing wells, of which there certainly are many that are already constructed in ALGC communities, and they are of concern. So I think that's, while that would be helpful going forward, it also doesn't provide any, regulatory certainty. It's quite possible that operators won't be able to obtain their, new insurance limits sort of at the time that they're submitting the OGDP for the new facility, for example. And it really does just not address all of the existing wells that have already been constructed that simply, wouldn't be subject to that.
And I'll just add one short thing. This would be a good question probably to ask some of the industry folks, but I'm not sure that industry insures themselves per project. I would have assumed that they carry their insurance coverage sort of as an, overall thing. So I don't know that they are going to do it piece by piece anyway. And then just to emphasize what Ms. Pranos was saying about, we do want the existing wells to have those same limits behind them.
Thank you. And then as a follow-up, my assumption is that local governments can also require additional insurance beyond what the commission would require as part of its OGD process. Is that correct? And again, this is for new development, but I just want to make sure that I'm clear about what the local government has the ability to do.
Thank you for that. And yes, I mean, while local governments do have that ability, the concern that we raise, I think, repeatedly in these statewide rulemakings is that, there could be a facility that's right across our boundary and our rules don't apply to the operator of that facility. So an accident that occurs on the boundary of, for example, Weld County and Boulder County, if Weld County doesn't have their own insurance limits that are sufficient to cover property damage and personal injury to someone that's injured in Boulder County, the Boulder County rules are inapplicable and aren't going to help the situation. And so in many instances, when we come before you as local governments, we are asking for statewide rules because of the fact that, we're local governments, we don't control things statewide, but impacts occur across jurisdictional boundaries.
Okay, thanks. Switching gears now back to the 211 hearing process. I I feel like some of the examples that are being brought up or would already have avenues available in our current rules for you to come to the commission and say, this well is a threat to public health or the environment, it's leaking, it's whatever. I feel like there's already avenues for local governments to come, or a surface owner to come to the commission and express concerns about that. So I really think what we're honing in here on is perhaps the definition of used and useful. And then for me, I think it's a sticky wicket for us to get into land use decisions and fights between how land should or should not be used in someone's contractual obligations. And so it might, for me as a commissioner, I think the valuable piece for me is the used or useful piece, and how we will go through that discussion with a local government that's struggling with that particular issue. And I would maybe appreciate, as part of this decision-making matrix, I would want to know that there's been some sort of good faith effort between the operator and the local government about what they're concerned about or what they're struggling with before it comes to the commission. So I'm sure we'll continue to work on this, but my 2 cents.
And if I can respond to that, Commissioner McGann, that's something that you mentioned yesterday, and I forgot to respond to, because I agree. And I think that would be a very fine additional piece, is that require some proof that the local government or the service center has attempted to work this through already. I think that's a great addition.
Thank you, Mr. Chair, and thank you, Ms. Burke and Ms. Baranos. So a couple of questions, and I'll start with the 211 piece, because for me, there was never a question about used or useful. To me, that's the decision fulcrum for this concept. I do have concerns about this commission deciding whether a school is better than a well in a particular situation. I do think that that's outside of our purview. However, I do think it's clearly within our purview to determine whether a well is used or useful. And so I would concur with, I think, Ms. Burke's suggestion that should there be a definition put forward for that, or a suggested language, that it would end after used or useful in section 2. So I'll put that forward. And I do think that there's clear standards and metrics associated with used and useful based on the existing definition. So at least in the existing definition in the proposed rules. I think in the insurance conversation, I understand the concern. I understand the concern of the jurisdictional government versus the adjacent government, and how there is potentially a need for some consistency in insurance coverage. I do concur with Commissioner Gonzalez that it would be very helpful to understand the inadequacies of the existing insurance and how it's being utilized currently, and just a better understanding of that, I think would help in that decision making. I think at one point, and I believe it was a staff person from Fort Collins, and this was a while ago, but had made a suggestion that perhaps different insurance thresholds for both general liability and environmental liability be determined kind of on a populated area versus a rural area in determining overall amounts. I'm going to go back and look at that again, and I can't remember exactly what the specifics are there, but I do believe that there's when you're talking about the value of certain things along the I-25 corridor and the adjacent the adjacent structures that could potentially be affected versus something in other parts of the state, that there could be a difference there. And so I don't know what your guys' thought is about perhaps looking at it from that light, or do you think just a baseline across the state is appropriate with the ability for the local government to increase that should they feel it necessary.
Thank you so much, Commissioner Messner. There was at one point, I believe, a proposal to have different general liability, I don't believe environmental liability insurance limits applied for urban areas versus rural. I think when we talked about that, there were some concerns from some of our more rural members that there still could be very valuable homes that are close to oil and gas well sites in less populated areas. And so, while on the one hand, I think one could make the argument that a large accident that's in a suburban or more urban environment where there's multiple homes, the damage could be, much higher because of the number of homes impacted and potentially people in those homes. I think that the sort of counter argument, or at least the concern, was that, well, there may also be some very valuable property where people also live in rural areas that may also need to be covered by that higher limit. And so we will absolutely take back the commissioner's request to try and gather some information on examples, for example, where insurance hasn't been adequate in the past, and come back to you with that and give a little bit more consideration to some potential maybe ways to divide insurance, across parts of the state. I would just, remind everyone that insurance is sort of the last resort, right? Hopefully we don't have many accidents, and we haven't had many huge accidents. There are a few, which I'm sure people can think of, where there have been deaths, fatalities due to oil and gas accidents in the state, as well as property damage. But luckily, they don't happen very often. And so we are mostly thinking about the what if scenario and trying to make sure that, when something horrible occurs, there's sufficient insurance to compensate the victims. So.
And I appreciate that. And I mean, in a past life, I was an event manager that put on mountain bike races, and I had to get $1 million liability insurance just to put on a mountain bike race, right? So, I mean, I appreciate that it appears that $1 million may not be adequate, but I do need to understand, I need a little more concrete specificity on why that is. And so I do appreciate that, that point. So one question that I asked Mr. Freeman and Mr. Delahunty earlier was this relationship around financial assurance between a local government and the state. They were talking more specifically about the state and the federal government, but there are a number of, I think even your clients have local financial assurance requirements, or are anticipating local financial assurance requirements for operators. How do you see that local financial assurance requirement interacting with a state financial assurance requirement?
I can go ahead and start, Elizabeth. That's good. Two things. One is we are glad to have seen the plugging and the reclamation separated, because that will help us, since the local government authorities over surface impacts, that will help us understand, where the state floor is, so to speak, on the surface level, so that we do appreciate that change. So speaking really just for Boulder County, the thing for us is we do have in our new regulations requirements for financial assurances and insurance, and we haven't implemented those yet. So at this point, it's somewhat speculative how that's going to work. And my memory is that after the mission change, the rules were left such that an operator can come to the state first or the locals first, or at the same time. If I remember correctly, it's kind of open-ended. So what I had envisioned is that by the time Boulder County got to assigning financial assurance requirements, that we would know what the COGCC requirements are, or are very likely to be, given that the rules are laid out, or perhaps they've already, that's already finished at the state level. And so that would be a significant factor we take into account our regs are written such that those assurances will be considered case by case based on the necessities of that particular project, and what the state will be holding in financial assurance would be a significant consideration. So that's not specifically written into the rules, but I think that that's just necessarily the case. I think other jurisdictions may have different rules around that, and there you may have some jurisdictions coming today that have actually walked through that process already and can speak to it more.
Yeah, and that would be my question, is there, should the state give consideration to a local financial assurance requirement in determining ultimately what a financial assurance amount would be for a particular operator?
My personal feeling is that it should be the other way around, that the state should, as we discussed in the mission change, supply the floor that applies to every jurisdiction, even the smaller ones that maybe don't have the resources. And then the local should do the tailoring in relation to what the state has done. That would be my recommendation.
Okay. Thanks for that. I'm not even going to say last question. So per acre versus the per well, as far as looking at reclamation. And I think an example that was given was a 30 well pad. I believe, and I could be corrected on this, but there could potentially be instances where 10 wells on a 30 well pad are going to be plugged and abandoned, or are going to be retired. And how do you anticipate a per acre bond, a reclamation bond, or financial assurance bond addressing that particular situation where you may not have all of the wells on a particular pad retired at the same time, as far as an operator being able to receive that bond back?
And that's just the situation that I had in mind when I put this image up. I don't know if that happens, but let's presume that it might. So let's say they wanted to plug and abandon the one end of this long string. So in my mind, the per acre would work much better than the per well, because it would be measurable. Say, okay, we're going to, and this is very, by the way, simplistic, because I do not work on oil field stuff, but let's say we are going to plug and abandon all of these wells and whatever separators and whatnot are associated with those. And so it would be measurable to say it's going to be this area, or maybe it goes all the way out to here, that will be reclaimed. And so that is literally a measurable amount of acreage. Presumably, flow lines, off location facilities like flow lines and roads would not be at issue, because they would still be servicing the remaining wells.
Okay.
And so to me, it seems pretty simple. But again, that would be a great question for industry, I think.
And that was my question. I didn't know if your expectation is that they would not be able to get their bonding back unless the entire pad was reclamated, or whether there would be some interim allowance there. And it sounds like you would be okay with some interim allowance.
That's what seems sensible to me. Yes.
That's all the questions I have right now. Thank you.
Thank you, Mr. Chair, and thank you very much, Ms. Burke and Ms. Paraños, for your testimony today. And I want to thank my fellow commissioners too, because I think a lot of the questions that I had brewing have now been answered. But I just wanted to make sure, I just wanted to clarify a little bit. I believe in your filings, you had noted that single well financial assurance or full cost bonding is preferred, but if that was not pursued, that then the 80th percentile was what you were sort of in support of, or that general. I know you sort of clarified in your presentation today that it doesn't necessarily have to be 80 on the dot, but something that accounts for the majority of the costs of closure. Is that correct?
I think that's fair to say, and especially for Boulder County, and some of our coalition members, have slightly different takes on this. So I think Boulder County would be very happy with, for example, the proposal Mr. Freeman and Delahanty put forward. However, acknowledging that that has not been the way the draft has been moving, we want to make sure that if that's not what happens, then we do want to capture that majority of the bell curve.
Okay, and let's see, I had another related question on that. And sorry, and I I know you noted, plugging and abandonment and reclamation costs. We've heard some testimony that was proposing to also include remediation costs. What are your views on that?
Yeah, I honestly, I have been assuming that reclamation included remediation, and maybe that was naive of me. So for simplicity's sake, I would recommend that the staff, and maybe in the statement of basis and purpose, or in the rules themselves, make clear that reclamation includes remediation, which in my mind is bringing that surface back to the condition it was in, or the desired condition. If it's not, if it's going to be a third piece, then it's going to need a third piece. So it's going to need another probably matrix measurement of its own. But I'm not sure what activities or tasks people see as being different between reclamation and remediation. So my simpler sense was that they're all encompassed together. But if I'm wrong on that, then yes, remediation is an incredibly important piece, and it's also the tricky one because it can take years to know whether the vegetation has taken and all that kind of thing. So to me, that's one of the significant costs in that matrix. So again, but if they should be deemed as different for reasons that I'm missing, then yes, they would have to be handled that way.
Okay, thank you. I appreciate that. I think my understanding, and I may be wrong and would have to maybe ask AAG Stafford or Director Murphy, is that that has been the remediation in terms of discovering contamination, upon closure, that's separate. So as we're talking with respect to bonding, this is what we're really talking about, is the calculation of what that amount should be. And so that in the event of an orphaning, we've got that full amount. But yeah, I guess my understanding is that it's separate. I see Director Murphy has appeared. So I'll let her maybe chime in, and then I'll continue with my question.
Director Murphy.
Thanks, Chair, and thanks for the question. Ms. Burke, I almost called you Kate. I've been doing this too long, getting too familiar. Okay, thanks. I think that the point that you're making, the overarching point you're making, is that every site should achieve both reclamation expectations and also be clean is accurate. The way that I've thought about these rules is that as soon as a piece of construction equipment hits the dirt, reclamation will be required. As soon as a well is spud, plugging will be required. But only if there's a spill or release will remediation be required. And so to conform to, or to restate what Commissioner Nanjapa said, every site needs to consider plugging and reclamation requirements. Remediation requirements are not necessary at every site. And so thinking about those buckets a little bit differently is what staff's proposed rules do. And it's why the 900 series focus a little bit differently on, and have explored different concepts around insurance versus financial assurance in the event of a spill or release. So sorry for kind of a long-winded answer.
Well, that is helpful, and that does somewhat change my response. My assumption has been that the remediation is the most difficult piece, right? Because we don't know what's under the ground and we don't know what to expect. So I've been looking at the reclamation amounts, thinking they needed to be prepared to handle either ends of that bell curve. I honestly haven't given great attention to the 900 series, so maybe I'm not the most helpful respondent on the question, but it is a critical question, and I think I think Commissioner Matt Jones mentioned it. We've had there've been a lot of P&As lately this last year in Boulder County, and a huge percentage of them have revealed some level of historic spill. So those have been handled thus far. They've been manageable by excavation and removing the contaminated soil, but it's very, very common. So, and I guess that's part of why I thought that they would be kind of built in together. But anyway, so I don't know that I've really answered your question. We would want to be sure that all of those things are captured in that 80th percentile kind of approach. I'm not sure if I'm not sure how insurance plays into that. For example, in Boulder County, if the operators have been responsive and doing what they need to do, so it hasn't been an issue. But if they hadn't, would we have been able to pursue insurance? I don't know how. I don't know exactly how that would work.
Thank you very much. I appreciate that response, and thank you also, Director Murphy, for chiming in there. I think you know, it's helpful to better understand kind of where your thought process is, because again, as we're thinking about this, we're thinking about the bonding level that, you know, ideally an operator is going to cover all those costs regardless, and whether there's a remediation issue, they're going to cover that. But in the event that the well is orphaned, you know, are we accounting for that cost as well? And it sounds like, is it fair to say that that's what you would like to see, that cost is also accounted for as it relates to the bonding level that provides our assurance in the event of orphaning, and then also knowing that we have the orphan well fund as a backstop? Is that fair?
Yes, I think that's fair. And I think that's also explains the kind of wide divergence of numbers that have been put forward from the, you know, the 72,000 that staff had originally proposed, the 300,000 that we had seen from Carbon Tracker, because I think those are trying to capture that huge variation, which really does come from the remediation more than the other two pieces.
Okay.
And so I don't know that, back to the 80th percentile, I don't know exactly what the right data set is to work off of, but whatever it is, that's why we're looking for capturing the bulk of the bell curve.
Okay, thank you. And forgive me if I missed this either in your filings or in what you said today, but are you in thinking of that, you know, either single well financial assurance or at least around 80% coverage? Is that for every well? Is it just for new wells and transferred wells, or and do you see existing wells differently?
And Elizabeth, dive in if you see this differently. I think our hope is that the single well financial assurance will be for every well, and then it's a matter of when it comes into play. So new wells would be, you know, at the start of their life. Transferred wells would be upon transfer, and existing wells is a problem, but we do feel like the bonding needs to be there, and it might also fall into the tier 1 and the blanket device as well. So is that clear enough?
I think so. Yes, thank you.
It's a really hard question, and I don't envy you. You know, we want all wells bonded all the time for everything, but we realize that's, you know, in reality, what we're hoping is that the decision points come into when does the bond come in, what discounts might be applicable to it, and less so which wells, if that makes sense.
Yes. Thank you. I appreciate that. And so then the last question, you kind of made a comment somewhat related to reclamation, as that's more, you know, the surface consideration, and your, you know, jurisdiction is more on the surface. Would you be, you know, kind of in relation to Commissioner Messner's question about how the local rules might, you know, apply, would that be, you know, so if we had to kind of hone in on specific areas of cost, P&A, remediation, reclamation, do you have any views on should we have a greater focus on the sort of downhole and maybe also remediation versus the surface reclamation in terms of determining costs where local governments then might take up more of that bonding? Or is that, am I totally off base there?
No, I appreciate this. And I think this was one of the important discussions during mission change too. And that what it comes down to is we are looking to the state to provide that adequate floor for every jurisdiction, because there are so many local governments that don't have those requirements or don't have the resource, might like to, but don't have the resources to have and enforce them. We have, you know, the classic example of the Boulder County and the Weld County neighbors, where we affect each other, and so and have very different approaches on our local level. So we think it's important that the numbers be correct for all three of those, and then the locals can use their additional authority to fill in where they find it necessary. But we are going to be much more comfortable knowing that there's an adequate floor statewide.
Thank you very much.
Other questions from commissioners? I have just kind of one final sort of big picture question, since I'm not seeing other more specifics. You know, as we did with mission change and as we're doing here with financial assurances, we're trying to implement the bill and implement it in a manner that is, you know, co-productive with our local government colleagues. You guys represent probably the largest coalition of local governments. Are we hitting the right spots? Is this, you know, I know you've asked for edits and some comments, et cetera, and we'll certainly consider that, but, you know, does the framework appear like it, you know, could be workable? Are we missing anything? I just kind of a final softball toss up to hear from local governments.
Yeah, and you're talking about this draft rule,
financial
not,
assurance.
okay.
Yeah.
I think, I guess I'll just speak, it's not something we've discussed, so I'm just talking now, but I feel like overall, in my opinion, that yes, the approach we were pleased with the straw dog and sort of the way it was headed. We were less pleased, of course, with the next draft. We've liked to see the changes. So overall, just as an example, I think that we appreciate the tier concept. We agree that the tiers need to be defined. Tier 1 should be a truly reliable and elite group in order to get the benefits offered, but the structure, the concept, we would prefer that there wasn't actually blanket bonding, but the way it's now having blanket bonding measured per well sort of captures a hybrid that I think we'd probably think is appropriate with, again, the changes that we've recommended. So, and then as far as interaction with the local governments, you know, as I say, Boulder County's not a great poster child because we haven't worked through any yet. But I think the clarity is now here, especially with the separation of the plugging and the reclamation, that will make it easier for us to work our piece either next to or on top of the states. So hopefully that helps a bit.
Great.
Yeah, I would
Anything to add?
second. Not specifically. I mean, I think I would definitely just concur with Ms. Burke, and I think we were pleased with the direction that the most recent draft took. It seems like a lot of our comments and questions were either addressed or are under consideration. For example, as Director Murphy mentioned in her presentation last week, she's aware that a number of stakeholders are concerned with the lack of clear criteria that would govern when an out of service well or an inactive or temporarily abandoned well has to be plugged as a date certain. And so she's working with staff to come up with that sort of criteria or framework. And so that's just one example. The inspection requirements, even though we think there are some tweaks that would make it much stronger, we're very appreciative to see that staff is acknowledging that there are leaks from idle wells. And so in general, I think we feel like we've been heard. Yes, we definitely have some additional recommendations for improvement, but have been pleased with the direction this last draft took.
And the 211 process that we've now created that would allow for the ability to, we've got a problem and we now have an avenue to be able to address it. I assume, again, we've all talked around that and there's still some work to be done, but I think that's a good tool that we've developed that seems to have some consensus around it and something that, didn't necessarily exist before.
Yeah, we agree. And that's one reason that we're so interested in being able to really use that tool. That when the draft came out and had really limited our ability, that's why it was really distressing, because we agree that, it's excellent, but we feel like we and the surface owners together have the best info to bring to you on those. So.
Well, thank you both. Thanks to all of the other colleagues that are part of your group. I know there's a whole bunch more of them that are not participating today, but that have participated in the written drafting and the dialogues that we've had. We appreciate your participation. I think it adds value to the overall process. And again, we'll look forward to probably hearing from you again. So thanks so much for the time this morning.
Thank you.
all of you.
Okay, I'm calling upon Hearings Manager Larson for kind of update of where we are and where we're going. And I know there's been a little bit of reshuffling of some of the deck.
Thank you, Mr. Chair. There has indeed. So we are at 11:52. We have a few options for us. We could proceed with taking Adams County and then taking a lunch break, or we could take a lunch break, come back, take Adams County and City of Aurora, and then we would hear from COGA. COGA has witness availability issues, so we need to make sure that we bring them on earlier in the afternoon today. After that, we would take a break and hear from the Western Rural Local Government Coalition, and then we would hear hopefully from the City of Brighton, Caris, and Evergreen. It's somewhat ambitious schedule, and I've checked in with the parties. They understand City of Brighton, Caris, and Evergreen that perhaps we would need to be calling on them tomorrow if we're not able to take them today. So that is the lineup for the rest of today.
And all the parties are accepting to the revisions in terms of the lineup.
Correct. I have not checked in with Adams County and Aurora at this point to make sure that they're okay. But at this point, we will be taking them in the order that they were proposed. Okay. It's just going to be a little bit later, about 40 minutes later than anticipated.
Okay. Well, to the parties, we thank you for your flexibility to, make some adjustments for relevant to witness availability, et cetera. I don't know. I threw out, why don't we take Adams and then take a lunch break and then start out with Aurora? Let's knock off one more this morning. I see thumbs up, so let's do that. If we could bring in Gregory Dean and perhaps his counsel.
I am looking for our counsel, Meredith Van Horn. Oh, there she is.
Yes, hello.
Great. And by my tally, you have 7 minutes. Is that right, Ms. Larson? Mr.
That is
Dean?
correct.
Okay.
That is correct. And do we
Well,
just get started? I apologize. I'm filling in for my colleague, so.
I recognize you, Ms. Larson. We'll keep track of your time. So go ahead.
Great. Thank you so much, members of the board. My name is Meredith Van Horn, and I am from the Adams County Attorney's Office. And Adams County supports the efforts of the COGCC to consider additions and amendments to the Commission's rules of practice and procedure. As such, the county is requesting changes to the rules. Oops, and I apologize. I am sharing the incorrect. I should be sharing our PowerPoint. And there it is. And here we go. Minor technical difficulties. And Mr. Gregory Dean, our oil and gas liaison, will be discussing the four requests for revisions. And Greg, go ahead, take it away.
Thank you, Ms. Van Horn. In Adams County, there are nearly 1,000 active wells. 50% of those have reported zero production since 2019. And of the wells that are producing, 57% would be classified as low producing by these proposed definitions. Most of these are actually extremely low producing, with nearly 80% reporting less than half the proposed low producing threshold and 60% reporting under a quarter of it. Next slide. So combined, that's 80% of the active assets or 750 wells in the county that are either non-productive or low producing. We know these types of wells, typically older vertical ones, pose the highest risk to be orphaned and have shown to impact public health, safety, welfare, and the environment. We recognize that not all low producing wells have the same risk. However, as this figure illustrates, most of the wells from three of our largest operators, KPK, Painted Pegasus, and Renegade, are either non-productive or marginally producing, with only 7% of their wells above the low producing threshold. Considering only these types of higher risk operators, that's nearly 500 wells in Adams County alone that are realistically a future orphan risk. Historically, companies that predominantly operate these marginally productive wells have been difficult neighbors. Many of these operators are generally non-communicative, uncooperative, and unresponsive regarding corrective actions and mitigating impacts discovered during our inspections. Many have explicitly asserted that the county has no authority over their facilities for inspections. In 2021, nearly all of the compliance issues discovered during our 600 plus routine inspections were from these types of operators. And to date, they have refused to pay nearly $100,000 in invoiced oil and gas inspection fees to us. This demonstrates a pattern by some of those operators that they're not operating in good faith with the county. Next, please. This is critical because as this chart demonstrates, based on COGCC current blanket bonding amounts for companies active in Adams County, these types of operators, on average, have secured only $1,900 per well in assurance, with KPK, for example, only required to submit $890 per well. The recent bankruptcy filing and subsequent motion by Painted Pegasus to abandon 189 active wells, 182 of which are in the county, further emphasizes our concerns. Under current rules, P3 was only required to file $305,000 in bonding, or $1,600 per well. When based on COGCC estimates, it could cost between $50,000 to $85,000 per well, or $9.5 to $16 million to P&A them. P3's wells have been largely marginally or non-productive since they were transferred to them in 2018, most producing less than a quarter of the produced low producing threshold and half reporting zero in the last 2 years. When these P3 wells are added to the orphan well list, it will increase the county inventory to 260, likely the most statewide. This directly rebukes the notion by some industry stakeholders that there is not a current or future orphan well risk in Colorado. We contend that any rapid or expansive increase in orphan wells will likely lead to a disproportionate share in the county. Next, please. We are largely supportive of the December draft with some proposed amendments. First, the county proposes provisions in Rule 434 that will require operators to P&A low producing wells within 24 months. As we have demonstrated already, these types of wells represent the majority of the assets in our county and pose the highest future orphan risk. Similar to Rule 434 for inactive wells, the county recommends exceptions if an operator can increase production such that it's no longer low producing. They can demonstrate that the low producing status is temporary with timelines to bring it back online, and if an operator files a single well financial assurance for that well, regardless of their approved financial assurance plan or tier. We recognize that in some instances, wells near the low producing threshold could be economically viable. However, that does not diminish those kinds of wells' heightened risk. And therefore, we contend requiring a single well financial assurance in these instances is necessary and reasonable, as it allows an operator to keep producing a well while also securing costs should it become orphaned. Next slide. Pertaining to single well financial assurance, the county supports the proposal by the Affiliated Local Government Coalition and the conservation groups that proposes COGCC utilize an 80th percentile of estimated costs as minimums required for P&A. We further support ALGC's proposal to revise the reclamation matrix to incorporate overall disturbed surface area that includes flow lines and access roads, with additional relevant factors in the rules that also consider the age of a facility, the presence of buried equipment, and total liquid storage volumes as examples. And that any operator requested exception for a single well financial assurance require approved third-party demonstration of costs rather than being operator supplied. Next. Regarding the transfer of operatorship, we appreciate the inclusion of the impacts to a selling operator's financial assurance plan for all proposed transfers and single well financial assurance requirements for transferred, inactive, and low producing wells. This will help safeguard against the siphoning off of permits and higher producing wells that simultaneously leaves a seller with higher liability, marginally productive assets, like what occurred with PetroShare, absent near full cost bonding. Next, we propose the provision previously presented that requires a 503 hearing for any transfers involving 30% or more inactive or low producing wells be added back into the rules, and request a relevant local government consultation process in response to these transfers. Lastly, the county seeks clarification or amendments to Rule 218D for the resolution process whenever a conflict arises between the parties as it pertains to the retention of responsibility. These requests are to ensure transferable items, specifically open remediation, unresolved spills, and NOAVs have clearly defined successor and interests on record, and that high liability assets have appropriate financial assurance secured. Next. And lastly, the county is immensely appreciative of the Orphan Well program staff, and we've had a great working relationship with them. We are requesting provisions that would allow a relevant local government to be involved in the evaluation of orphan wells for the sake of ranking and prioritization on the orphan well list. Additionally, we suggest allowing a local government to request a reassessment of an orphan well's priority when surface conditions change, such as a newly discovered spill or release, or if more orphan wells are added in an area. These requests will allow the commission to consider on-the-ground conditions that a local government may be more attuned to, and to ensure orphans with the highest risk for impact to the public and environment are addressed promptly. This concludes our testimony, and we thank the commission, Director Murphy, and staff for allowing us to participate and for their active engagement with us.
Mr. Dean, for your testimony and for your participation. We do appreciate it. It's good to have a local government that, you know, specifies in on issues within its jurisdiction with regard to the number of wells and their characteristics. So your testimony is well informed, and we appreciate that. Looking around to see if commissioners have questions. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you very much, Ms. Van Horn and Mr. Dean, for your testimony. Yeah, I think I was looking forward to your testimony just because I know there's a lot of, you do bear a pretty high burden of the, you know, orphan wells and the inactive wells. One thing I was curious about, and this came up in some of the other filings, a couple of the operators that you mentioned are connected to this Third Creek gas gathering system that was shut in. And as I understand it, you know, to a certain extent, there's little control that they have over, or at least they're unable to return them to activity or to production without some major investments and or, you know, additional infrastructure. I was curious your thoughts on whether there should be any special provisions for circumstances like that, if that would occur, you know, elsewhere and also pertaining to Adams County, or is that just something that if an operator needs to address, it should be addressed in a variance provision? And I have some other follow-ups, but I'll start there.
Yeah, thank you for that question. I think it's a tough one because we feel for those operators where these wells may be producing above the low producing threshold. Were they able to produce them? On one side, we understand that that's the kind of the hazards and costs of doing business and being an oil and gas operator is there could be operational issues. Our proposal to plug low producing wells has an exception in there that would allow the operator to demonstrate that their well is only low producing for a short period of time, or that there are issues like that, operational issues where their pipeline is down, or they're trying to get a contract in place for a gas sales line. That being said, we still believe those wells are a risk to be orphaned in the future. The Painted Pegasus bankruptcy is a prime example of that. While we feel for those operators, we think requiring them to file a single well financial assurance for those wells will give them more time to work out those operational issues, but also protects the state in the event that they can't get them figured out before their funding runs out. And we feel for them, but at the end of the day, it's the county that is in the state that's being left with, in the Painted Pegasus instance, 189 orphans. because they couldn't figure out the gas gathering line in time. And so we kind of need to balance both. And I think the exception process that we built in to our proposal in 434D for low producing wells kind of covers that. Or at least
Okay.
that's our intent, is to cover that.
Right. Okay, thank you. I appreciate that. I think you mentioned, the provision for allowing evaluation of ranking in orphan wells in terms of prioritization for closure. And I unfortunately, I'm also shuffling a lot of different filings here in front of me, so I don't have it directly in front of me, but can you remind me, sort of some of the factors that you might take into consideration, or I can't recall if you specified, but are there particular factors that you're taking into consideration there?
Yeah, so when a well gets added to the orphan well list, it goes through an in-depth ranking by the COGCC orphan well staff. They look at past compliance history, they look at if there were spills in the past, things like that. What we want to be involved in, we don't want to necessarily override the commission staff because we believe they have probably more expertise than I would in assessing the ranking of the priority. We would just like to be involved where we can let them know we have a very robust inspection program here at the county. We've got a lot of equipment to measure impacts. We have our own flare camera. So we would like to just be involved in that process to let them know, hey, maybe you're not seeing this on the ground, or maybe there hasn't been an inspection on that well for 2 years. Here's what we've seen in the last 2 years at this location. Here's complaints that we've received from this location in the last 2 years. Here are some known impacts that we know exist. Or, hey, we've had a proposal for a new oil and gas pad near there, and they presented some high priority habitats in the vicinity, and let them know that that might help assess their priority system when they actually rank it. So we didn't in our filings specify what that would look like. It's more of like a formal conversation before the rankings are released, because it seems like it's kind of hard to change those once they're posted. And so a lot of those PetroShare wells that occurred, so that was 50 wells from PetroShare, 45 in Adams County, they got ranked, but the county had no input at all into what those rankings should be. And a lot of those, for instance, are in very densely populated areas. So we would like to chime in and just let them know, hey, not that it's going to impact you, but there's future development planned over here, or we've got active applications for housing that we didn't even realize this well was going to be orphaned in the first place. Just let you know so that it can help guide their decision making. And then as it pertains to like the change of status on the ground, so let's look at PetroShare. Let's say another operator goes bankrupt in Adams County and 10 more orphans are getting added. It might just be good for them to realize, hey, with these 10 wells and the ones that are already existing, that might change your priority for cleaning these up, because there are now, instead of 5 in this 1 mile area, there's now 12. That might change their prerogative. Or if a community becomes disproportionately impacted, that might also change their prerogative on their ranking or priority for cleaning those up. And it's a good faith in conversation. It's meant to just make sure that we are talking with each other, and not to say we haven't been with the orphan well program, but we haven't been able to explicitly in the ranking or prioritization of orphan wells. Once they're added to the list, the orphan well staff has been wonderful to work with. It's just, we'd like to be involved more in the front end.
Okay.
And maybe that's not a rule, maybe that's just a policy or a practice that changes.
Yeah, no, I appreciate that. I think, those types of conversations are always useful and important. And it actually made me also think, I'm just curious, with some of these operators that have orphaned their wells, or like in the P3 case, are you talking with them? Are you trying to reach out to them as you noted that there were some of your own rules that are not, they're not in compliance with, and are you reaching out to them? Are they having conversations with you? Are they indicating hardships? I'm just curious the level of conversations that have been occurring prior to the bankruptcy or the orphaning.
The short answer is no. P3 refuses, before they went bankrupt, refused to even respond to our emails. They have never paid an oil and gas inspection fee to us. We've tried to reach out to them. In many cases, most of the time we would call them and their phone would be disconnected, and then we'd talk to Mike Leonard at COGCC, and he'd say, oh, here's a phone number I found. And getting in touch with our operators, especially our largest, our third largest operator, should not be that difficult. And then looking at Renegade, Renegade has reached out to us. They're one of our largest operators and explain the situation, but they're also one of those operators that refuses to acknowledge that we have any authority over them for inspection. So they're one of those that they refuse to answer our emails. They refuse to come into compliance with the county's regulations. And we usually have to forward our inspections and our compliance issues onto the COGCC for them to try to build a case for a notice of alleged violation, which we know can take a long time. And so in the meantime, all these impacts are just sitting there. And so these smaller operators, and I'm painting with a very broad brush, and I understand that. Most of them, if you look at one of my slides, has the three that I highlighted in a red box. All three of those would be prime examples of operators that have not been good partners with us.
Okay, thank you. I appreciate just having a little more understanding of those kinds of communications, but also appreciate the suggestion of the additional conversations with the staff and the ranking of the orphan wells. Do you have any opinions on having some sort of option for operators to purchase existing orphan wells if they are, if they were orphaned not due to, inviability?
So I've heard that question get asked a couple of times, and on a surface level, I would say, hey, if another operator wants to buy them, go to town. The issue I would have with that is a lot of the wells that get added to the orphan well list aren't in pristine mechanical condition. I mean, the P3 wells, 97% of them haven't had braden head pressure testing in 2 years. So if an operator wanted to purchase an orphaned well, they would have to bring it up to compliance with all of the commission's rules for mechanical integrity and everything else, A. B, they would have to probably secure a single well financial assurance because I think one of the other parties' points earlier, a well's orphaned when no one wants to buy it. And so if you can find a buyer after the fact, then I think on the surface, we're open to that idea. And then I think it was in the second draft, they introduced the idea of beneficial use, other beneficial use, and we really liked that idea. And I know they're doing a pilot program in the city of Denver with some old shut-in wells for like geothermal energy or alternative uses for using gas to do cryptocurrency mining, that type of thing we're open to. And we asked for some more direction in one of our draft of comments, and then the concept was kind of tailored back in this most recent draft. So on the surface, we're open to the idea. At the end of the day, we want an operator to produce their well as long as they're maintaining it. And we don't plan to weigh in on a land use perspective, like, oh, a developer comes in and say, hey, we want this well plugged and abandoned so we can build homes. The county does not intend to ever get involved in that type of discussion about land use. So if they can use it for something else, that would be preferred. Does that answer your question? Kind of.
No, thank you. And I actually was going to ask specifically about like the geothermal proposal and that those concepts. And in your view, would that be part of the conversation with the staff on wells that were already in the program, or should it also be a conversation for any operator that is just planning to plug?
I think it's both. I think in the second draft, the other beneficial uses were specifically geared towards inactive or low producing wells and not orphan specifically. And the county's comments asked if other beneficial uses terms could be applied to orphan wells as well, because we think obviously not all orphan wells are going to be candidates, but there could be some that are in good condition that, to your point, they couldn't get them connected to a gas sales line in time. And if in 2 years from now, the gas sales line, the Third Creek system comes back online and Renegade wants to buy all of P3's wells on the system and they can bring them up into the right condition, then that would be something we would prefer over them just sitting there for 10 years before they get plugged by the Orphan Well Fund.
Okay, thank you very much. Appreciate that.
It's okay if I go?
Yes.
Okay.
Go ahead.
Thank you, Mr. Dean, and Ms. Van Horn. I appreciate the testimony and always appreciate Adams County's input in these rulemaking hearings. So I wonder if we could go to the slide that had Rule 218D on it. I appreciate how fast you can talk, Mr. Dean. It's like two times on my Audible books on tape, but this one went past me. So I wonder if you could just talk a little bit more about your proposal on 218D.
Oh, the resolution, yes. So, and maybe it's just clarification, maybe, again, I'm not an attorney, so maybe it's a misunderstanding on my part. There seems to be, so 218 is a transfer of assets subsequent. So when transfer of operatorship subsequent, there seems to be some issue in there where the language was a little open-ended, where it seemed like if there was some sort of conflict between the buying operator, the selling operator, or the prior operator, or somehow the list of items that are transferred in the subsequent form were different than the items transferred in the intent form, the Form 9 intent, what would that process look like? If an operator A wants to buy some of operator B's assets, and then through their due diligence on the private side, they say that well is higher liability, we're not taking that one, and then they file their Form 9 subsequent, it's different. We want to know what happens in that case. Does the buying operator keep it? Or what if the buying operator is going through bankruptcy? Or what if the buying operator is saying, no, we're not taking that well, that's not ours. And the selling operator is saying, well, it's not ours either. Well, whose is it? We want to make sure there's a resolution process for those instances. Just to specifically around any sites that have unresolved open remediation projects or unresolved spills or any NOAVs that are still left hanging.
Okay.
And I think it's came up kind of in the or in the KPK hearings too, where, there was the argument like, well, flow line wasn't ours, it was someone else's. And I don't think that should be a question when things are getting transferred. Specifically, you're taking the flow line systems, you're taking these systems, you're taking the production systems, and you're taking the wells. And if there's some sort of discrepancy, fine, but it needs to be figured out then who is still maintaining these facilities.
Okay. No, I appreciate that suggestion. While we're on this one, so you're proposing that the previous provision requiring a hearing when more than 30% of the wells subject to transfer and active and low producing. Wonder if you could just talk a little bit about how you see that working in actual application.
Yeah, so the way I see
the inclusion of the relevant local government consultation.
Yeah, so the way I would see this is a Form 9 intent is filed by either the buying operator or the seller, or I think it's the rule says it simultaneously. And then either the applicant or the COGCC determines that 30% or more are either low producing or inactive. That would trigger an automatic hearing, and that would allow all parties, the public and the relevant local government, to chime in that process, because I think it needs to be flushed out in a public setting as who's transferring what to whom. And again, this is what the consultation with the relevant local government would allow us to chime in and say, just so you know, operator A, who's planning on buying 200 wells from this low producing operator, they're also not in good compliance with the county. They are refusing to comply with the county's rules. They owe us X number of dollars in inspection fees. They haven't been good neighbors with us. It also allows the commission to ensure that both the buyer and the seller are in good standing with the commission. Specifically when you're transferring these higher risk assets, because we want to make sure that the impacts of the financial assurance plans on both the buyer and the seller are flushed out and are detailed. We want to make sure that the operator who's taking on these assets has the financial solvency to plug them in the future. If operator A is trying to transfer a whole bunch of stuff into them and they haven't complied with their financial assurance rules, that needs to be known and that needs to be flushed out in a hearing before that transfer can be approved.
Okay.
Does that make sense? Kind of what I'm getting? Yeah. And again, our consultations our consultation requests throughout our filings are voluntary. So it's the relevant local government chooses to participate. They get to reach out and just say, hey, we want to just give you some extra information for your consideration. It's not intended to be a, we demand this. It's meant to be a good faith conversation with the commission, only because historically speaking, low producing operators have not communicated with us. So a lot of times, the only time we find out that an operator is trying to transfer something to someone else is after the fact. And we like to be able to chime in before it actually happens.
Got it. All right. Other question is that you're suggesting rule 434 that there should be a requirement to P&A low producing wells within 24 months unless they make a few different showings. And I think one of those showings was single well financial assurance for all of the low producing wells. Are you proposing a timeline associated with that, or would that be, I mean, when would that be implemented? Is it upon implementation of the rules, or is there a 5-year timeline for them to come into compliance, or what's your suggestion on that?
That's a tough one. I think 5 years is probably too long, to be completely honest. I would honestly say for that rule or that provision, I might be open to the clock starts when the rules become effective. So within 2 years, if your well's already low producing, your 2-year clock starts now. You have 2 years to file a single well financial assurance or bring the well up into a status such that it's no longer low producing. Wells that are not low producing now, let's just call them high producing. I mean, they're not, but high producing, if they become low producing, then that would have to be, and I'm not certain when in the commission's rules, how long the avenue is. Maybe that would be a year to file a single well financial assurance. And so that one I haven't really fleshed out completely in my head yet. So I'm just kind of spitballing. Another option, and this is based on commissioners' questions to other parties, is maybe another status of low producing. It's like a super low producing. I mean, obviously not, that's a terrible idea, but wells that are producing above zero, but less than low producing, those would have stricter requirements than low producing. Because, Director Murphy pointed out, and other parties have pointed out, that some low producing wells are economically viable. We acknowledge that, especially in our Eastern Plains. A lot of those wells are probably used and useful. Therefore, we don't want to necessarily force them to plug them if they are being used. So maybe creating a lower threshold that than low producing that would protect against those ultra low producers. They're less than zero, but still. Does that kind of answer your question?
Yeah, I see where you're coming from on that.
We're just trying to protect. So the way that the rules are structured, it's inactive or low producing. So it's either 0 or 2 and 10. Maybe there should be something in between to help protect those. I mean, in Adams County, most of our wells are ultra low producing. So it's unfortunate we've got some really high producers, our modern horizontals, but most of our vertical wells are not even close to being low producing. They're the average. If you look at one of my slides, the average well that's producing, that's not high producing, it's 0.3 barrels per day and 1.2 or 2.3 MCF of day. So it's around a quarter of what the low producing threshold is. So maybe there should be something in between. Those are the types of wells we're trying to get single well financial assurance for, and not so much the wells that are producing 2 barrels a day and 10 MCF, or the ones that are producing more than that. It's those ultra low producers. And those are the ones that are going to be orphaned in the future.
Got it. Well, and I think that some parties have suggested a definition for an idle well that would be between those two things. So I'll ask questions around that when those parties present. Last question. Understanding that I believe Adams County has some concerns around orphan wells. I wonder if you would opine on kind of the orphan well program and thoughts around what an appropriate amount is for that orphan well program, and how that orphan well program interrelates with or does not interrelate with kind of general financial assurance for existing wells.
Yeah, so Adams County is a little unique in that we are one of the local governments that haven't been advocating for full cost financial assurance for all wells. It's mostly these low producers that we're the most concerned with. We believe that blanket bonding, I mean, we have issues with the tiers, but having a good tier one and having these prime operators, we're less worried about those types of operators, to be completely candid with you. The way I think the Orphan Well Fund kind of relates to that is we view the wells on a spectrum. We've got some really great wells, and then we've also have these really bad wells who are run by these operators who refuse to even answer our phone calls. We believe that those types of wells are probably going to get orphaned no matter what. If the commission takes no action and doesn't change the rules at all, they're going to get orphaned. I mean, look at Painted Pegasus, they filed for bankruptcy before this even happened. So what we're trying to kind of protect is that middle road, those wells that are, some operators that have, they've got some good wells, they've got some medium wells, and they've got some really bad wells. We want to prevent them from orphaning their wells. And we believe that our provisions kind of try to protect that middle realm. And so the Orphan Well Fund serves those wells that are going to get orphaned no matter what. We would like them not to be orphaned, obviously, but let's be realistic, they're going to get orphaned. My assessment is there are 500 wells that are really, truly likely to get orphaned regardless of what happens in the financial assurance rulemaking. We want to protect against that middle lane of wells. That's the Orphan Well Fund will kind of cover the expenses of those. They're going to get orphaned no matter how you look at it. And then the financial assurance, the blanket bonding, and the single well financial assurances kind of protect against that middle realm. And then the blanket bonding specifically protect against those high producers that probably won't be plugged and abandoned for another 10 to 20 years.
Thanks for that. Do you have an opinion on what the appropriate dollar amount should be? I mean, should it be capped? Should it be, should it accumulate?
That's a tough one. Again, it depends. I really do want to give credit to operators who have a great record with the commission in following the rules and having a very robust plugging program in place. I do want to give credit to those operators. And so that's why we kind of support blanket bonding for those types of operators. The amount, we do support the 80th percentile of costs. Again, is it 75? Is it 85? I don't know if it's 85% or 75% percentile of costs, but we do think that, and I think we proposed a working group for assessing that amount for a single well financial assurance specifically. We do think that the remediation and reclamation costs, and I'm with Kate in that, Kate Burke from Boulder County, that I was under the impression that reclamation and remediation were built into each other. We know that those are the more variable costs, so it's kind of hard to pinpoint. We really like the idea of a matrix, and we also really like the idea of flexibility for the commission and the director to add or subtract from that amount on a site-specific basis. And I think operators should come to the table with data that shows, here's how much we spent on plugging, abandoning, and reclamation. There are 3 orphan wells in Adams County. That's one spent 106,000 to the Orphan Well Fund, one spent 126,000, and one is currently at 180,000 in total closure costs. So what's the right amount? We don't want to overbond. We don't want to drive companies out of business, but we also need to make sure that we're protecting against those impacts.
Okay, thank you very much. Appreciate your responses.
Other commissioners with questions? Very good. Mr. Dean, Ms. Van Horn, thank you very much for your presentation. Again, I think it's really helpful to us because you take practical on the ground stuff that's happening with your own jurisdiction and come up with solid ideas around it. So with that, I believe we are at our lunch break. It is 12:30. We had allocated 40 minutes. If everybody's still good with that, we would return at 1:10. All right, very good. We'll come back at 1:10. Okay, welcome back, everybody. Can you hear me okay? Okay, good. My home office is near the kitchen. The kitchen is being used for lunch, so I'm going to mute. We now recognize Ms. Paranos and Jeffrey Moore from the city of Aurora. We look forward to hearing from you.
Thank
Mr.
you
Chair,
so much.
I'm going to get off camera because I'm finishing my lunch, but I'm here and I am listening.
And
Terrific.
one other procedural matter, Commissioner Nanjapa had a conflict for the next 2 hours, and so she's not with us. She will review the video of the YouTube of all of the folks that she's going to miss to bring herself back into current state. So just FYI.
Excellent. Thank you all so much. Elizabeth Pranos, representing the city of Aurora, and I am going to turn it over to Mr. Moore to present for the city. Take it away, Jeffrey.
Very good. Well, good afternoon, Chair Robbins and Commissioners. My name is Jeffrey Moore. I'm the manager of the Oil and Gas Division for the city of Aurora, and very honored to be able to share our comments and thoughts on this rulemaking with you this afternoon. I want to first take a moment and just thank you and the staff for your diligence in this rulemaking process. It is very complex. There's a lot of competing viewpoints, but I feel strongly that we're making progress with every draft that comes out. I'm very excited about the future opportunities. I appreciate the time you're devoting to this process. I especially want to thank Director Murphy for her outstanding presentation and perspective last week, summarizing the proposed changes to the rules. In Aurora, we have wells that fall into a number of categories, including one well that's on the Orphan well list. So even though our total number of wells is currently smaller than other jurisdictions, we are growing, and we expect to quadruple our well count in the next 5 to 7 years, up to a total of about 400 wells. I believe we've avoided many of the Orphan well issues that other jurisdictions have faced, in part because the majority of our wells are operated by Crestone Peak Resources under Civitas, and they maintain very diligent and safe operations and are proactive in plugging wells, and I really appreciate that. But because of our expected growth, these rules are under consideration, remain very important to us. So why am I here today? Well, I believe that the December 7th draft significantly represents the right path forward for financial assurance in the state. My comments today are going to primarily focus on adding clarity to these rules so that we make sure that we avoid any loopholes that might be able to be found. The first thing I want to do is mention a couple of areas that have been added to the rules that we agree with and think are good ideas. We hope that they will remain. The first is the clarification and the definition of inactive well. The second is requirements that operators provide single well financial assurance for all transferred wells for wells that are drilled after April 1st, 2022. The addition of the reclamation matrix was excellent. The requirement that tier 1 operators provide a demonstration of how they're planning to retire their operations. And then finally, the discretion given to the director to require additional financial assurance if the director has reason to believe an operator lacks the ability to comply with any of the regulations. And we think all of those are excellent ideas and hope that they will remain in the final draft. The first area I'd like to discuss today is the definition of inactive well. In the current draft, inactive well is based on time, and it's i.e. no production for a period of 12 consecutive months. Simultaneously, there's been a new definition, which is low producing well. My understanding of these, how these work together, is that inactive wells will be used for operational rules, such as timing of mechanical integrity testing, and low producing well will be used for financial assurance determination. With this in mind, I believe that further clarification of the word producing and production should be added to the definition. And the rule we discussed earlier in the day, 503 G12, allows a relevant local government to file an application to plug a well, quote, an inactive well that has reported zero production for a period of 3 or more consecutive years. That's in the rules currently. If operators are allowed to file a well as producing and simultaneously report zero volumes of all oil, gas, and water, it could allow operators to avoid having a well classified as an inactive well. We recommend clarification of this. So we would like to see the definition updated to specifically note that wells cannot be file a status code of producing, and in order to avoid the classification as inactive well. The next topic is the definition of low producing well. The way it's currently written in the current draft says that wells that produce less than 2 barrels or 10 MCF of gas over the previous 365 days. We believe the intent of this is to say, add the phrase per day average. So this is 2 barrels average per day over the last year, not 2 barrels per year. But we do want to make that, it is a very important distinction, and I want to make sure that that gets added to your consideration. The next topic is the timing of submission of a financial assurance plan. 702 creates a timing structure for submission of financial assurance plans such that larger operators submit first, while smaller operators submit last. We recognize that the initial review of these plans from every operator in the state will require significant work of staff. However, we're concerned that the smaller operators who have the least amount of work to perform to create a plan and may be most likely to be unable to meet the new requirements have until the end of the year. It would seem more reasonable and protective of public health, safety, welfare, and the environment to flip these and have the smaller operators submit first and give the larger operators a longer period of time. The Tier 3 financial assurance amount. If an operator elects to file a financial assurance plan under Tier 3, we are concerned that the language of the current rules do not specifically require any financial assurance for inactive wells unless they are transferred. More clarity is needed in this section to describe what amounts will be due or what parameters the director will use to determine the amounts due. This is the text in the current draft. The area that's highlighted there is our area of concern. Again, there doesn't seem to be any specific explicit requirement for single well financial assurance under the Tier 3 plan. Finally, we remain consistent in our request that operators be required to post full cost single well financial assurance for all new wells. And we believe that the correct way to do that is to require 50% of the single well financial assurance, or alternatively the dry hole cost, at the point of Form 2 approval, and the remaining 50% within 180 days of the first month of hydrocarbon production. We believe that's a good balance between requiring financial assurance for all wells and allowing operators to draw from their cash flow to post that the single well financial assurance. We strongly urge you to consider this position for all new wells, regardless of the additional rules that may apply to existing wells. Thank you for your time and attention today, and I'm happy to take any questions.
Thank you, Mr. Moore, for the presentation. I do appreciate the perspective that the City of Aurora brings to the table. Looking to my fellow commissioners if folks have questions. Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Moore, Ms. Pranos, for being here today. When I read your pre-hearing statement, I have to say I'm struggling to understand the concern about an inactive well being able to define itself as producing. Does this mean that an operator is, when they're filling out their form, they're recognizing themselves as something that they are not, and there's no checks or balance? I have to admit, I'm kind of struggling with this concept and what we're concerned about. If you could explain that to me a little more, I would appreciate it.
Thank you for your question, Commissioner McGowan. Yes, that is the concern. So my concern is that what, in the definition of inactive well, what constitutes production? And if an operator were to file a status for a particular well as producing for a given month, but the volumes are zero, either because their actual production volume was less than, or rounded down to zero, was less than 1, perhaps it was a tenth of a barrel, it rounded down to 0, or there's nothing coming out of the well, yet they file a status of producing. Does that give them the ability to avoid classification as an inactive well because they're filing it as producing? So wanted to get some clarification on that, and I feel like that's important, so that we don't have operators that all of a sudden start reporting wells as coded as producing, which is the PR code, but at the same time reporting 0 volumes on oil, gas, and water across the board.
Okay, I appreciate that. And maybe at some point we can ask staff to clarify for us how those checks and balances to a operator reporting. And I wonder if one of the checks and balances is, I think there's also a monthly production report that's shows actual amounts. And so I think I need to learn a little bit more about how that all happens, and I appreciate your concern. And then, sorry, another question. For under the current draft tier 3, which is the individualized financial assurance plan, while it doesn't specifically say you're going to have single well financial assurance, do you not think that the commission in its review of an operator's wells would say, these appear to be higher risk, or your portfolio appears to be higher risk, and therefore the commission in reviewing the individualized single well financial assurance would then require some sort of amount of single well financial assurance for some percentage of wells or part of the portfolio or something? Sorry, that is my daughter just dinging and dinging and dinging me. I apologize.
No worries. Thank you. Thanks for the question. I believe, on the tier 3, I think that is my concern is the lack of clarity. It seems to me when I read through the draft there in tier 3 that there are certain categories that are mentioned. There's the out of service wells, there's transferred inactive wells, but again, I don't read a specific amount or requirement for the single well financial assurance as the current draft is written. And I think there should be some more clarity there to either define what that will be for all wells that an operator has if they're a tier 3 operator, or what boundaries or guidance the director would use to make that decision. Right now, it seems like it's a decision the director would make.
Thank you.
You're welcome.
Mr. Moore, as a local government, you've probably heard we've had a lot of discussion around Rule 211 and the ability to call for a hearing for a well that is potentially no longer used or useful. Does your community have any thoughts about that, or the direction with some of the language that we've heard?
Thank you for the question, Commissioner Robbins. I've heard quite a bit of the testimony regarding this rule, and I think that there's a lot of different interesting perspectives. I appreciated what Commissioner Messner said about being careful for the COGCC to be careful not to get into land use decisions. I do think there are some selected opportunities where it would make sense for the local government to be able to initiate those proceedings. And I'm generally supportive of the points that they've delineated in terms of what they would use to analyze, whether a well continues to be used or useful.
Great, thank you. Other questions of this panel? Okay, I'm going to do something strange, Elizabeth. I'm going to put you on the spot. I meant to ask the ALG group a question on the whatever tier it is where you choose your own adventure and you move forward with that. And as drafted, local governments are, as we noted, if you desire to be involved, you get to be involved under our new standing. Is that something that you think that your communities, and this can be for Aurora as well, I'm just trying to ask the local governments, and since I see you on the screen and I forgot, could you weigh in on that?
Yeah, sure. Happy to. Thank you for that, Chair. Absolutely. I mean, I think as you heard in particular just recently from Adams County, I mean, there absolutely will be individual circumstances where the local governments have perhaps different information or particular unique interests that aren't represented by COGCC. And that, we think would be relevant to a determination of an operator's financial assurance plan. And so in particular, I think in tier 3, where there's so much discretion on the part of the director, having the ability of local governments to, weigh in and bring their individual concerns about an operator or their experience with an operator to, the director and the commission's attention, we think will only just enhance the amount of information that's available and make the ultimate determination of the appropriate financial assurance for that operator more accurate.
In sort of a follow-up to that, if you have a large operator and they're coming in for one of these plans, they will likely have locations in multiple jurisdictions. I would advocate that wherever we end up with all of that, that the local government's involvement is to bring the particulars of their jurisdiction into play, as opposed to speaking to other jurisdictions. Does that comport with what you believe your clients would do?
Yes, absolutely. I mean, that exactly. I mean, as I stated, I think local governments oftentimes will have experience with an operator, right, who's been operating in their jurisdiction, and will also have information about, other activities perhaps that are nearby a proposed oil and gas development site that the commission may not necessarily have, whether that's, and so I think it would be the local government's specific experience with respect to the operator that's subject to the OGDP that, where they would be providing the most valuable and relevant information.
Yeah, and to get back to Mr. Moore, you noted that your city has a positive working relationship with Civitas. And so that would be helpful information, I think, for the commission to hear if we were doing a financial assurances plan that is unique to Civitas. Similarly, we heard from Mr. Dean that the relationships may not be quite so positive between that community and some or more of its operators. Mr. Moore, did you want to comment on this line of inquiry?
Thank you for the opportunity, Chair Robbins. Yes, I would agree with Ms. Pranos and her assessment with that. And certainly we could comment on all of our operators. We have only a handful. As I said, most of our operations are under Crestone Peak resources. But we do have some smaller operators, and we've had similar struggles in trying to reach some of them, just like Mr. Dean has from Adams County. And even though the numbers of wells are much, much smaller, nevertheless, when we have wells and we have operators and we can't reach them, it hinders us in our efforts, to make sure that everything's going okay with those wells, and just be aware of what the future plans are for those wells.
Yeah, and I'm sorry, I misspoke. I meant Crestone Peak, but thank you. Okay, further questions for the panel? Well, thank you again for being with us. We appreciate the perspective you're bringing to the table for the financial assurances rulemaking with both your written and oral testimony here today.
You're welcome. Thank you.
All right. I think we are now bringing the City of Brighton group, which is the City of Brighton, Commerce City, Larimer County, and City of Thornton.
Actually, Mr. Chair, we will be bringing in COGA.
Oh, no, you're right. It's the reshuffle.
It's a reshuffle. Yes.
Okay, let's bring in COGA. Sorry.
No, not a problem.
Good morning or good afternoon, Mr. Matthews and Ms. Ryan. Good to see you both. I see we have witness Mr. Gilstrap with us. Are there others that we need to be impaneling?
Yes, please. If you could please allow Gary Septeris to share his screen. He'll be running some slides for us.
Okay, and I also see we have Mr. Bennett.
Yes, he was part of the Extraction Civitas group that ceded time to COGA, but because he provided witness testimony, he's available in the event of any questions, but he's not planning on presenting.
Great. And Ms. Larson, just double checking time allocation here.
Yes, COGA has 40 minutes.
Very good. All right, Ms. Ryan, I believe, I don't see a screen share going yet.
Yeah, yes, Gary, is it enabled for, oh, great. All right, could you just please confirm that you can see that for me if you don't mind?
Yes, we can see it, although it's not in presentation mode, so we can see the next few slides.
Okay. One moment, please.
Is that better?
It's still not in presentation mode, at least on my screen. There you go.
Okay, great. Advance the next slide, please. Yeah, okay, great. All right, sorry for the delay. Good afternoon, commissioners and staff. My name is Julia Ryan. I'm with the Colorado Oil and Gas Association. And this slide presents an overview of some of our key requested revisions. My colleague, Mark Matthews, will be speaking to you all about the tier structure and why automatic full cost bonding is generally a bad idea. COGA's witness, Trevor Gilstrap, will supplement Mr. Matthews' points regarding full cost bonding, explaining why full cost bonding is unavailable in the surety marketplace and the differences between surety bonds and insurance. I'm going to discuss parent subsidiary operator relationships, issues with transfer, and recommendations to make hearings as efficient as possible. COGA would like please to reserve 5 minutes for rebuttal. Next slide, please. So I'm kicking things off with a slide you've actually seen before. This was shown by AAG staffer during staff's presentation last week. Throughout this rulemaking process, COGA and several others have recommended that the Rule 700 series acknowledge parent subsidiary operator relationships and allow for the consolidation of majority-owned operators and their parent operator for purposes of determining tier eligibility and the applicable amount of required financial assurance. Consolidation in this context means that the commission would look at the total well count and well statuses of all the related operators' inventories, and then the parent operator would be able to submit financial assurance that covers itself and its subsidiaries based on the related operator's overall portfolio and other relevant information. The final clause in our proposed language is important and provides protections for the commission. The clause conditions consolidation on the parent company guaranteeing the financial assurance obligations of itself and its subsidiaries. This means that if a subsidiary company becomes insolvent or declares bankruptcy, the commission has an enforceable guarantee against the parent company, pursuant to which the parent company must continue to provide financial assurance for the subsidiary. Under the normal operation of law, a parent company would not have to provide financial assurance for a subsidiary who becomes insolvent or declares bankruptcy. So our proposal means that the commission would have more financial recourse in the event a subsidiary becomes economically distressed. Staff told you last week that they thought this idea was reasonable and made sense, but I want to further explain why this is the case and the mechanics of the concept. Next slide, please. First, for why the concept is prudent, I want to point out that our concept is consistent with how sureties already underwrite for subsidiary operators. When sureties evaluate subs, they look at the parent's assets and business model as a whole. In other words, sureties do what we're asking the commission to do: evaluate the financial health and risk of related operators on a consolidated basis. Because financial health and risk are determined by looking at how related operators operate as a whole, two surety trade organizations have now twice recommended COGA's framework to the commission, and that's reflected in this slide. Second, as to the mechanics, and noted in COGA's most recent red line, the parent operator would submit a single financial assurance plan covering itself and all its subsidiaries, and then financial assurance in the amount required by the approved plan. The consolidated plan would include the parent's required guarantee that I just mentioned, and all of the required plan components as to each of the covered subsidiaries. As noted by COGA and the surety trades, this maximizes efficiency for the commission because instead of the commission or the director needing to review multiple financial assurance plans, the commissioner director could review one holistic financial assurance plan. We also think that this will help the commission better understand how the related operators fit together as one unit with shared operations directed by shared management. The commission's or director's analysis of financial health and risk of the parent company won't be skewed by thinking about one subsidiary's apparently high or maybe apparently low production or plugging rate in a vacuum. One subsidiary's high or low plugging or production rate will be considered against other related companies' production or plugging rates. COGA believes that viewing related operators together provides the commission and the director with a more transparent and comprehensive understanding of what's really happening under the leadership of the same set of corporate decision makers. Next slide, please. This slide contains proposed elements for the parent guarantee. Note that the commission is fully covered in the event of a corporate restructure or the parent seeking to terminate the guarantee, because we propose that a guarantee can only be terminated upon the subsidiary providing replacement financial assurance. COGA's red line contains additional proposed corresponding changes to carry through the parent sub-concept, just one of which I will briefly mention. Next slide, please. And that is that COGA also recommends that related operators be able to submit consolidated insurance policies covering the parents and subsidiaries' insurance coverage obligations. Insurance for a subsidiary company is underwritten the same as in the surety context. The underwriting considers the parents and subsidiaries' assets as a whole. The commission is protected because the insurance policy must name the parent and the subsidiaries and provide coverage in the rules required amounts for each entity the operator seeks to cover. Next slide, please. Switching to transfer, COGA has two proposed revisions. First, COGA recommends that oil and gas development plan, comprehensive area plan, and Form 2 applications that have passed completeness be eligible for transfer. The commission is aware of the time, cost, and effort operators incur when preparing such applications, as well as the efforts made by commission staff in their intense completeness review process. To avoid duplicative efforts of a buy-in operator and staff having to redo work that's already been done, the commission should allow complete applications to be transferred. As COGA has suggested in its written submittals, the SBP could expressly recognize that the transfer of a pending application does not in any way guarantee, suggest, hint that the application will ultimately be approved by the commission or the director as applicable. The application would proceed to be processed under the commission's rules and the act under normal course. It's just that the work wouldn't have to be redone. Next slide, please. COGA's second proposed revision is to make Rule 218B explicitly note that Form 9 intents will be held confidentially until a Form 9 subsequent is filed. At the Form 9 intent stage, a potential transfer is too speculative to be in the public domain, and it's common for transfers to be subject to confidential purchase and sale agreements. Public knowledge about a transfer could cause market upheaval, concerns about insider trading, if someone got wind of a transaction before it had properly closed. Next slide, please. This slide and the next one suggest language to make financial assurance hearings and Rule 211 used or useful hearings as efficient as possible. COGA believes that third-party participation should be limited because such hearings often will implicate confidential business information and almost always will implicate agency expertise about the oil and gas industry. Lay parties simply lack the requisite technical expertise to meaningfully participate in proceedings that examine an operator's business decisions about what types of wells to operate and when to decommission them. Take the circumstance of a well being low producing or inactive. Some parties have argued that a well being low producing should be a circumstance allowing a local government to request a Rule 211 hearing, which essentially leads to the commission depriving an operator of its property right in the low producing well. Some have even suggested that a well being in low producing status for as little as a year make a hearing eligible. But there are several legitimate reasons for an operator to maintain low producing status that do not indicate the wells are at risk. First, as you'll hear from other operators, some operators have business models where low producing wells are viable. But even where that's not an operator's core business model, a lease may require that production be maintained even at a low rate, or an operator may have a long-range development plan that will involve plugging the low-producing well as horizontal development reaches the area. Similarly, a well can be inactive for a host of legitimate reasons. Some of them were brought up earlier today even, such as if a gathering system goes down. So these reasons aren't always obvious to the public, and so COGA believes that it's inefficient to hold a time-consuming contested hearing where an operator's operational expertise and business judgment is challenged by an applicant who may not have that same expertise. Some local governments have claimed that having oil and gas wells in their jurisdictions preclude them from changing the land use where the oil and gas well is, but that argument is uncompelling because there's nothing about it that's unique to oil and gas, which is to say that all new land use has to consider the existing land use. A local government can't shut down a farm to make room for a mall, for example. It's an abusive process to allow local governments or a surface owner to seek to shut down land uses, including oil and gas operations that are operating legally and not posing a threat to public health or the environment, just because a local government or the surface owner might prefer a different land use. The commission should not be making value judgments about use or useful, or that one land use is better than another land use. So this slide proposes revisions to specify the list of entities who may submit an application or otherwise initiate a financial assurance hearing under various rules. Next slide, please. And then this slide specifies what entities are appropriate affected parties to participate in financial assurance hearings or Rule 211 user useful hearings. COGA reiterates that the participation of third parties in technical hearings is unlikely to be helpful, but it is likely to create labor-intensive hearings. COGA believes that the Commission's time is better spent focusing on ensuring that operators comply with the Commission's rules, including the rules adopted in this rulemaking. To be sure, COGA is not opposed to the public being able to eligible to comment upon these issues, and COGA reminds the Commission that third parties who wish to comment on pending hearings may do so under the existing Rule 512. Thank you very much for your time, and I will now turn it over to Mr. Matthews.
Good afternoon. I want to start by thanking the Commission and Hearing Officer Larson for their flexibility in rescheduling our hearing date. We appreciate that a great deal. As Ms. Ryan stated, I will be discussing the problem with requiring single well financial assurance for all operators in Colorado and how the tier structure in the draft rules should be revamped to address these problems while still ensuring that the mandate of SB 19-181 is met. Now, you've already heard from a number of parties advocating for mandatory full cost bonding for all or most wells owned by operators. Missing from these arguments is any convincing rebuttal to the point that requiring such an outcome overstates any problem associated with orphan wells in the state. These arguments also fail to recognize that the determination of what represents adequate financial assurance should be determined by the risk associated with a particular operator and its unique circumstances, rather than the one-size-fits-all solution represented by single well financial assurance. And finally, all of the arguments we've heard for single well financial assurance fail to mention any evidence suggesting that compliance with this requirement is possible for operators in Colorado. Let's just start with some numbers. Assuming plugging and reclamation costs of $100,000 per well, which is rounding up somewhat from the COGCC's prior estimate of $93,000, full cost bonding for an operator with 3,000 wells would be $300 million. A mid-sized operator with 1,000 wells would pay full cost bonding of $100 million. And a smaller operator with only 250 wells would have to satisfy financial assurance requirements totaling 25 million. While operators could reduce this by demonstrating lower plugging and reclamation costs for its wells, even a modest percentage of these amounts would be beyond most operators' ability to satisfy through bonding or otherwise. Now, this is because many operators will be unable to secure surety bonds in the amounts required by a full cost bonding regime. As Mr. Gilstrap will testify following me, the surety market has substantially tightened recently, resulting in the amounts required under full cost bonding or even for high blanket bonding being unavailable for many operators and enormously expensive when it is available. Can we switch the slide, please? Mr. Gilstrap's testimony is echoed by two major surety trade groups, the National Association of Surety Bond Producers and the Surety and Fidelity Association of America. I urge you to review their comment letter, which makes several suggested changes to the draft rules which should be considered. On the issue I'm addressing today, these surety trades opined that to the extent sureties continue to issue bonds, they likely would raise meaningfully their underwriting standards for operators seeking bonds for COGCC obligations based on the draft rules, likely leaving only the largest operators as qualifying for these bonds. And with regard to single well financial assurance, the trade stated, we understand that some parties to the rulemaking proceeding are arguing for full cost bonding for all of an operator's wells, and our comments above apply even more strongly to that scenario. Small and medium-sized operators will not be able to obtain surety bonds for full cost bonding. We believe rules requiring the same would lead to unintended consequences. Even in those circumstances where bonding is available, securing bonds will often be cost prohibitive due to premiums and collateral requirements. Now, the annual premium a typical operator must pay each year is 2.5% to 3.5% or even higher for less capitalized companies, not the less than 1% that you've heard asserted several times already. This means premium payments for an operator with 1,500 wells could be 4.5 million each year or even higher. And in addition, most operators will only be able to obtain a bond by paying collateral to the surety from 50% to approaching 100% of the bond amount. Collateral for the single well financial assurance will be unaffordable for the vast majority of operators, particularly since the larger the bond amount, the larger the collateral requirements. Now, without being able to avail themselves of the bond market by paying collateral to the surety, while not being able to avail themselves of the bond market, operators' only recourse will be to satisfy their financial requirements through a cash bond or some other mechanism that requires full cash payment. And even if operators can borrow or have reserves allowing for this cash payment, it's highly unlikely that after doing so, operators would be left with sufficient money for scheduled plugging and reclamation and remediation, as well as the ongoing and steeply climbing compliance costs after the mission change rulemaking and the recent COGCC rulemaking. Now, the draft rules seek to avoid some of these consequences by providing that operators may provide full cost bonding over time into a sinking fund. But a sinking fund does not fix the problems of full cost bonding. The presumptive 10-year window or a different time period will not make surety bonds more available to operators, because in deciding whether to issue a bond and in establishing collateral and premium requirements, sureties always look to the entirety of the bond obligation over time and not to the bonding requirements for each year. And surety companies are quite reluctant to agree to a surety agreement over multiple years. This means that operators will have to put up cash or obtain a fully collateralized letter of credit into the sinking fund. And this is not a viable solution, because no matter where you put the money, the amount required each year will simply be too high for most operators to afford. Given the huge sums required by single well financial assurance, even paying 10% of the total each year will be extremely difficult or impossible for many operators. Now, finally, I note that many of these same concerns applying to acquiring single well financial assurance for all new transferred wells. It simply isn't a practical solution and risks hindering or even stopping most transfers that could occur including transfers that would reduce the risk of low-producing and inactive wells becoming orphaned. It also flies in the face of the Commission's apparent goal of creating a framework where low-producing and inactive wells are deemed more risky and carry more financial assurance obligations. Obviously, a new well is not inactive or low-producing and will not be for a long period of time. Finally, I'd like to address the tier structure. COGA and every operator supports revisions to the tier structure in the draft rules because these rules, as written, push the vast majority of operators into single well financial assurance. Based on 2020 data on the COGCC website, which is the most recent full year available for analysis, only a very few operators would qualify for blanket bonding under the draft rules. The remainder will presumptively fall into tier 2, which requires full cost bonding paid into a sinking fund, which, as we've just discussed, is a non-starter for most operators. I say presumptively because, as you know, there is also a tier 3 in the draft rules, which allows operators to propose to the Commission a specific financial assurance plan, but the draft rules establish a presumption that full cost bonding is appropriate for most operators by requiring an operator who wishes to operate under a tailored or bespoke financial assurance plan to prove why the exception to single well financial assurance is warranted under its unique circumstances. Slide, please. There are several revisions that should be made to the tier structure to make them feasible as well as protective. First, the draft rules should be revised so that all operators have the opportunity to obtain a tailored financial assurance plan that they can demonstrate at a hearing before the Commission and demonstrate that the proposed plan will ensure that the operator is financially capable of fulfilling all of its legal obligations. In doing so, an operator shouldn't have to overcome the presumption that it should be subject to single well financial assurance by proving an exception based on its unique circumstances. Second, the Commission should modify the current blanket bonding tier in the draft rules to allow more than a small percentage of Colorado operators to qualify. One way to do this is to make an operator eligible for blanket bonding if it meets either a production threshold or satisfies a threshold percentage with respect to the number of low producing and inactive wells in its portfolio, rather than having to meet both criteria as required under the draft rules. And this makes sense because either criterion is indicative of a strong financial portfolio. An operator may be financially strong even with a relatively low average well production because it has so few low producing and inactive wells as a percentage of its inventory. Or conversely, an operator may have strong capitalization and liquidity due to a strong active fleet of wells, even though it has a large percentage of low producing and inactive wells. Under either circumstance, the operator poses little financial risk of abandoning its wells and should be able to obtain a blanket bond for its active wells. Now, as Director Murphy suggested in her presentation, because this tier has prescriptive criteria, an operator must satisfy to qualify. Financial assurance plans under this tier could be approved by the director without necessarily requiring a Commission hearing. This would help ease congestion of the Commission's docket, as would establishment of a comprehensive bond of $30 million, which can be administratively approved by the director, which is advocated by several operators. Finally, the revised rules should create a tier for operators with low average well production that may require single well financial assurance for operators having very low production across their inventory. We heard about some such operators in Adams County presentation today. In establishing the production criteria for this tier, the Commission needs to be careful where you set the standard to make sure you are capturing operators that truly represent a risk of orphaning wells. COGCC suggests in particular that the Commission pay very close attention to the presentation of responsible smaller operators such as own resources in deciding where that production demarcation should be established. I'll now pass on the camera to Trevor Gilstrap.
Good afternoon, everyone. Can everybody hear me okay? Perfect. Okay. My name is Trevor Gilstrap, and I'm employed by Assured Partners. In my current role, I'm a senior vice president and lead the national energy vertical within Assured Partners. I've been in insurance for many years, having started my career in Oregon on the claims side of insurance. After moving to Colorado in 2011, I started working for Siskin Company, a local brokerage firm, insurance brokerage firm in Denver that was primarily focused on placing insurance and surety programs for upstream and midstream oil and gas service contractors and operators. My role with Siskin Company was that of an insurance producer or salesperson, and I specifically targeted the oil and gas industry. Siskin Company was sold to Assured Partners in 2015. At present, Assured Partners is the 5th largest privately held property and casualty insurance broker in the country. I continued with the same production role for 2 years and was then asked to develop and lead the energy vertical within Assured Partners. While I intentionally branded the vertical as energy, the vast majority of our clients are still directly tied to the oil and gas industry. And here in Colorado, we provide the insurance and surety placements for a few dozen E&P companies. I want to start with a brief summary, and then I can go into more detail and, of course, answer any questions you may have. My primary concern with the proposed bonding changes is the feasibility of implementing them. In the decade plus that I've worked as an insurance broker, primarily focused on placing insurance and bond programs for oil and gas companies, I've never experienced a harder surety market. The days of zero collateral seem light years behind us at this point. Unlike an insurance policy, a bond is not a transference of risk. Instead, it's simply a guarantee of payment. In the event a bond is called upon, the surety will immediately seek reimbursement from the principal or E&P company. With that, sureties look to underwrite for zero loss scenarios. One of the primary facilitators used by sureties for zero loss scenario is requiring collateral that is tied to the bond amount. While there's no formally written guideline that I'm aware of, my experience over the past several years in particular is that sureties are looking to see financial statements from the principal, excuse me, that evidence working capital of at least 25% or more of the bond amount to even contemplate terms with limited associated collateral. As a general statement, the lower the working capital on hand, the higher the collateral required by the surety. In many instances, we're seeing sureties require collateral of 50% to 100% of the bond amount. Should the proposed drastic increases in surety requirements for the state of Colorado be enacted, my fear is the exact opposite of what COGCC is trying to avoid will take place. A situation will be created where once stable operators can no longer afford the costs associated with operating in the state of Colorado. And instead of decreasing the number of orphan wells, we will see a precipitous increase. I also believe the rules create implementation issues regarding the short period of time within which operators have to obtain the bonds. So again, in my current role, I work almost exclusively with oil and gas companies, and we're seeing in the vast majority of circumstances that sureties placing oil and gas bonds are requiring 50 to 100% collateral. In addition to the associated collateral amounts, sureties also charge an annual bond premium for placing that bond. Again, specific to these types of bonds, typical annual premiums range from 2.5% to 3.5% or more of the bond amount. To put these costs into perspective, an operator with 150 wells that is subject to full cost single well financial assurance of up to $100,000 per well would be facing a P&A bond obligation of about $15 million. In most situations, the operator should anticipate a bond collateral of at least $7.5 million, on top of an annual bond premium that's likely going to range between $375,000 and $525,000. An operator with 1,000 wells that is subject to full cost single well financial assurance of up to $100,000 per well would be facing a P&A obligation of $100 million. In most situations, the operator should anticipate a bond collateral of at least $50 million on top of an annual bond premium of somewhere between $2.5 and $3.5 million. These amounts will simply not be achievable for the vast majority of small to mid-sized operators in the state. The typical non-surety alternatives to meet financial assurance obligations are posting a letter of credit or cash with the applicable regulatory agency. Going this route, there's no potential discount on the assurance amount, meaning 100% of the associated bond amount would be tied up through a letter of credit or cash. Referencing back to the previous example, an operator with just 150 wells that sought a non-surety alternate would be forced to put up $15 million in cash or $15 million via a letter of credit to satisfy that obligation. There's been some discussion of a sinking fund that operators could pay into over time. The issue here is that surety providers, in establishing their collateral requirements, will look at the entirety of the bond obligation through the period of the fund, for example, 10 years, and not the bonding requirements of each year, thus getting back to the same collateral issues previously discussed. Sureties prefer to bond over short periods of time because company performance and economic fluctuations are more predictable and stable over the short term. A company's financial stability as well as the overall economy can change substantially when time periods exceed more than just a couple of years. Within these rules, I'd also like to see a timeline or time frame for the commission to release financial assurance after the operator satisfies the conditions necessary for release. As previously mentioned, in addition to large collateral requirements, operators are also subject to annual bond premiums. Typically, sureties will not cancel a bond until the original bond has been released by the obligee and is returned to the surety with a letter of release. The bond will be formally canceled with a pro rata return of premiums effective that date, with the first year of premium fully earned. The longer the bond is in place, the more premium the operators have to pay. The same is true for the associated collateral being held by the surety. Its release falls under the same guidelines. Operators should be granted a formal timeline for a bond's release so that they can in turn prepare for when their premium and collateral obligations with the surety will cease. There have been some discussions in regards to limiting bond riders. In my experience, we typically see a request for a bond rider when there is a subsidiary entity being added to an existing bond, or when additional assets are purchased and the number of wells increases. Therefore, the bond amount needs to be adjusted to comply with the legal requirements. Riders should be allowed when subsidiary entities are added and or the bond amount needs to be increased to cover both the parent company and the subsidiary, or because additional assets are purchased and more financial assurance is required to comply with the regulations. Excuse me. Lastly, regardless of where COGCC lands on their final rulemaking, the rules need to allow for more than 30 days to implement the revised financial assurance plan. For our clients, we start their entire insurance and bonding renewal process at least 90 days in advance of their renewal date, which seems to be fairly standard for the insurance industry. That allows time to gather updated exposures. In this case, that's updated bond requirements, financials, banking data, reserve reports, etc. Submit that information to underwriters for review, address any questions raised during the underwriting process, schedule calls between the insured and the surety, negotiate the terms with the carrier, and deliver those final terms to the insured. Once the final decision is made to proceed, the bonds are typed and executed by our office, mailed to the insured for execution, and then mailed to the obligees. Mail delays alone would make the 30-day time frame impossible to meet. In conclusion, I do not believe the vast majority of small to medium-sized operators would be able to comply with the currently proposed draft rules. Some of the unintended consequences of full cost or at least drastic increases to bond amounts could include increased bankruptcies, increased orphaning of wells, increased bank debt, less capital on hand for normal plugging and abandonment operations, new drilling, workovers, routine maintenance, etc., and operators exiting Colorado to pursue exploration in more favorable states. Thank you very much for your time today.
That conclude the presentation?
Yes, it does. Thank you.
That concludes our presentation. Thank you.
Okay. Before we move into questions, and I know we all have some, let's get a time check from Ms. Larson.
Thank you, Mr. Chair. COGA used 31 minutes and 30 seconds, so they have 9 minutes and 30 seconds remaining.
Okay. All right. I've taken notes and I've highlighted the places that I have questions, so I might just start out, if that's okay, and just walk through some highlighted questions for the folks. It's kind of in order of the presentation. I was wondering, Ms. Ryan, and you may have put this on slides or may have this in red lines, but how do we know? How do we know if there's a parent subsidiary relationship, and then we would rely on that? Like, did you define there was a lot presented here and there's a lot in all the filings, so I apologize if this has already been determined, but could you refocus on that point?
Yes, absolutely. So if operators want to take advantage of this opportunity for consolidation, they would have to notify the commission as part of their financial assurance plan. And the financial assurance plan would explain the relationship of the related entities, and it would also include the guarantee. And so the guarantee would, as part of the recitals, it would have to make sure that the operators meet the rule criteria. For example, the parent operator would have to be the majority owner or in majority control of the subsidiary operators. So that's how the commission would know it'd be part of the financial assurance plan application.
Okay. I appreciate the point you made about third-party participation relevant to the two types of hearings before us. But I wanted to know, we had a lot of discussion on 211 and the commission being asked to determine used or useful. And then I think there was some agreement amongst commissioners that that is acceptable. And I at least appreciate creating that opportunity for the relevant local government or the surface owner. However, for you, you had a concern about a 12-month timeline. What would an applicable timeline be? Question number one. And question number two, there was some language from some parties that spoke to other aspects like land use considerations or BI or whatever. What is COGA's thought about that component?
Sure. Well, taking your first question as to time component, 1 year is just not enough time. The December 7th draft rules suggested 3 years. COGA in its remarks actually suggested an even longer period of time following what, yeah, that's what North Dakota does. So to the extent parties want to have the time frame shorter than staff's draft, COGA's opposed because there are so many reasons why a well would be inactive for over a year. And so we think it would just, the applications would often be premature. Well maintenance, offset, lack of gathering lines, perhaps there's an issue with disposal capacity. There are just so many reasons that a well could be inactive that a year is not the best snapshot, we don't believe, because a year is not a very long period of time for how long wells may need to be shut in. And then on your second.
So are you still advocating for 7, but you'd take 3?
We're still advocating for 7. We think 3 is certainly better than 1.
Okay,
I may answer that way. And in terms of your second question, I do agree that it's appropriate for the commission to determine used or useful, but I think it needs to be tied to the criteria of used and useful. And COGA actually also, not as part of today's presentation, but did have a few suggestions on some other criteria that might be explicitly added to used and useful, recognizing that there is that catch-all of other relevant information. But we did have a few more suggestions on what might be used and useful. For example, thinking about the estimated reserves left with that particular well, looking to see if maybe that well is part of a comprehensive area plan or part of long-range planning, perhaps lease terms associated with that well. So all of those things the commission can look at, but the inclusion of land use, we don't believe is appropriate because it puts the commission in the business of deciding what's a subjectively better land use than another one. It does run into contract problems that I think you referenced. If there's an SUA that exists, that right is there, and an operator does have a vested property right in that well that's producing. So we don't like the idea about land use. If more generally, the fact that DI communities would be considered, I think considering DI communities is always incredibly important, and that to me is makes more sense in the context of prioritizing wells to be plugged on an out of service plugging list. But I'm less clear how that concept applies to used and useful.
So you would potentially add in some of these additional criteria to the current definition of used and useful.
Yes.
And strike the concepts of, I think it was BB, which was the additional information from one of the previous speakers, which included the land use. Okay. Mr. Matthews, I've got some specific questions, but since you spoke to single well financial assurances and bonds, et cetera, can you provide COGA's perspective on the assertion that if we were to allow the use of blanket bonds, that would be illegal or inconsistent with SB 19-181?
Yes, thank you for that question. That entire argument presupposes that SB 19-181 requires full cost bonding, because you have to assume that SB 19-181 requires full cost bonding, which it certainly doesn't, to then make the leap that only X% of an insurer of the obligee's obligations would be covered by a blanket bond, and the rest is illegal self-insurance because it doesn't meet the self-insurance criteria. So I think that argument falters from an improper premise. SB 19-181, as you have pointed out, Commissioner Robbins, I believe, does not require full cost bonding. It asks to make sure that the commission require operators to meet their financial obligations under the Act. Financial obligations of the Act do not speak to full cost bonding. And there's a lot of problems with full cost bonding, some of which Commissioner Gonzalez has already spoken to. So I do not believe that because SB 19-181 does not require full cost insurance, there's no illegal self-insurance going on whatsoever.
Thank you for your perspective on that. In one of your slides, it was the slide that was the quote from the surety company. I forgot whom it was, and I don't need the slide. I can tell you what I'm about to ask about. And this might be a better question for Mr. Gilstrap, but it's quote, raise meaningfully the underwriting standards based on the draft rules. Do you recall that component of that quote?
Yes, sir.
What's the basis for that quote? Like, they didn't tell us why. It was like there was a reference to, if we adopt these rules, then the insurance surety standards are going to go up, but it didn't say why.
Yes, thank you. And that was just because I didn't want to put their entire letter into a slide.
Can you just summarize?
Yes, I can. Yes, I can. One of those is the substantial increased financial assurance requirements represented by the draft rules. The two trades, which I note parenthetically represent 98% of surety and fidelity bonds issued in the United States, pointed out, as COGA did, that under the current draft rules, the vast number of operators in the state will fall into a single well financial assurance regime. And because of the amount of assurance required, collateral requirements and perhaps premium requirements would be increased as well, as Mr. Gilstrap pointed out. Collateral requirements tend to increase with bond requirements, bond assurance amount requirements. In addition, they talked about two relatively obscure points, Commissioner Robbins, which is why I asked the commission to reread the letter. One is to the delisting, if you will, I think under Rule 705 of assurance providers who the commission deems are providing an inadequate product, or that delist an operator, list an operator's assurance for less than what the commission views as kosher reasons. I think the surety trades believe that will have a queering effect on assurance coverage in the state. The other rather obscure point they made had to do with contingency reversionary interest. And this has to do with some of the issues explored by Commissioner Gonzalez in the difference between a surety and an insurance product. For a surety bond holder does not have a contingent reversionary interest in the surplus once the bond is paid. There is simply the bond amount. It is not an escrow pool of funds that can be drawn from. So those are the three different issues mentioned in their letter that served as a predicate for their statement. And I do apologize in retrospect, that was a bit unclear. We sort of jumped in the middle of the fray there.
Thank you. So a couple of folks have noted a potential concern, and this isn't something you necessarily touched upon. You did touch upon transfers, but what is your suggestion to the problem that may happen where an operator transfers a low producing well to a buyer, and then the buyer since it appears that we can't regulate that not occurring because that's a business decision, but we have a rule that says the buying operator needs to then full cost bond, but the buying operator can't. They don't have the capacity to full cost bond. What do we do? Or how do we regulate that? How do we solve that problem?
Wouldn't that be caught in the transfer process itself, Commissioner Robbins? And maybe I'm misunderstanding the issue. It just seems to me that in the transfer proposal to the director and the commission, the terms of the transfer would be made quite clear. And by the way, I wholeheartedly agreed with the Adams County comment that it should be quite clear in these transfers what is being transferred and what is being retained before the transfer is approved. There should be no ambiguity on that score. That's just a recipe for litigation down the road if there's any ambiguity. So there should be quite clear what is being transferred and the terms of that transfer. And I think that under a lot of circumstances, transfer of low producing wells will automatically be covered by single well financial assurance. There are a couple of carve outs that are noted in the current draft rules and that COGA has elaborated upon. But generally, single well financial assurance will be required in those kinds of transfers for low producing wells.
So do we just draft a rule that says in that instance, the transfer doesn't happen?
If the buying obligation, let me put it this way, because I want to make sure I understand the premise of your question. If the buying operator has agreed to take liability for these wells and then refuses to post the requisite financial assurance, whether it's increasing its blanket bond amount that already exists or increasing its single well financial assurance amount as required by the current rules, it shouldn't be allowed to accept the transfer.
So we would cover that somehow within the to be determined rules that business transaction has to undo itself, because oftentimes these things already happen, right?
Could they happen before the transfer is actually approved?
Yeah, in other words, the sale takes place.
Yeah.
Then they come to the commission and they want to get the operator switched through the Form 9 process.
I see.
In that instance, the buying operator says, oops, I don't have the capacity to do a full cost bond. That's the concern I'm trying to figure out.
I understand. That's a legal issue I haven't considered, to tell you the truth, about the commission's authority to unwind a business transaction. So I can't give you a definitive answer now. I perhaps could give you an answer down the road. I think some of that could be avoided early on by making the transfer requirements crystal clear. But if the transaction has already occurred, that won't help. I don't know if Ms. Ryan has a thought on this.
Yes, if I may. No, I don't believe the commission can't unwind the business transaction, but I think the recourse that the commission might suggest is that it would make it extremely clear to the buying operator that upon the transfer, if there's not adequate financial insurance in place, COGCC is going to file an application for a hearing and request that the commission revoke the buying operator's Form 10 certificate of clearance. It might also order the operator to immediately shut in all of its wells. It would be out of compliance with the Rule 700 series rules, so there could be an enforcement hearing. There's a suite of things that the commission could immediately do. So the buying operator would be on notice that fine if you transfer these wells. Be aware that day one, there's going to be a hearing application at your feet with all of these different proposed
Yeah,
penalties.
and-
I realize it's maybe not the most efficient.
Yeah, and it's all sort of after the fact. So I would appreciate, I think this is a very important component of what we're trying to accomplish. This transfer issue is one of the issues that's got us into the pickle that we're in. And I think it's incumbent upon this commission to come up with a solution on this front that, as you mentioned, Mr. Matthews, is crystal clear of the obligations that are going to be required so that the sale doesn't take place on the front end with us having to pick up the pieces on the back end, and especially picking up the pieces with these other sorts of things, which, Ms. Ryan, I realize it's kind of all we've got right now. But I would like some attention paid to that. I guess I say that to all 136 people that are listening in. It's something that is, I think, critical, super critical to one of the fundamental goals, which is to halt the problem that arises on transfers. I also would note that I am aware that one business model in the state is you have one operator and there's a joint operating agreement, and other operators may be mineral interest owners. And when the one operator decides it's time to plug and abandon the well, the other operators through the JOA have an ability to say, nope, I want that one. And then all of a sudden we're back into this same sort of, yeah, but that other operator might be not a good operator, not have the ability to do it, but they're using their private contractual rights to get around our rules. So I throw that out as something for everybody to think about. I think that's an issue that we need to recognize. I understand that's prevalent, and I want to come up with solutions around that. Okay, commissioners, bear with. I'm getting through my questions. Getting to the tiers, Mr. Matthews, with regard to the bespoke plan, love that term, or the choose your own adventure, or the come to the commission and prove up that you've got a financial plan that is viable. What sorts of sideboards does COGA believe should exist for that? Do you know what I mean when I ask that question?
I think the notion is that only operators that meet certain criteria or qualifications should be able to enjoy your own adventure.
That, or what are the defining criteria for commissioners as we deliberate whether you've met the mark on a financial assurance plan?
Oh, well, I think it's a suite of information, and I do think that there should be some robust applications submitted for these hearings that include issues like liquidity, like the asset retirement plan in place that the companies already have, their history of P&A wells in the state, their compliance history, a suite of financial and historical information, if you will, to demonstrate that this client is able to satisfy its obligations under the proposed plan. I don't think there should be any guardrails precluding a company from pursuing the go your own adventure route. I do think operators with very low average well production have to contemplate the notion that single well financial assurance may be imposed upon them as a result of the hearing under this tier 3 that we've come up with. But I view the go your own adventure as the commission considering, and the director and staff considering a great deal of information that is provided by the operator and confirming that the operator is able to satisfy this plan.
Okay, I'll need to think about that. So you spoke to a 3-tiered program, the bespoke, the tier 2, which had the production threshold and low producing threshold, and then tier 3 for a undefined subset of low producers or no producers that may need to be required to do single well financial assurances. Just to be fairly, blunt about it. Well, let me ask this. I'll start here. What's the tier 3 numbers? from COGA's perspective?
Yeah, we proposed 10 MCFE and I believe 2 BOE a day. West Slope COGA proposed the same. I note that Own Resources and Evergreen Resources propose lower thresholds. I believe 5 BBL a day and 6 MCF a day, so they aren't energy equivalent numbers. But I think that those are the kinds of numbers that you need to make sure that a company that is perhaps going to have single well financial assurance imposed upon it is not an Own Resources with a strong compliance history and a robust program for plugging and reclaiming its own wells and no history of transferring poor wells, versus a Painted Pegasus, which has extremely low production and had a poor compliance record. I think there's a pretty clear demarcation there between those operators that should be subject to single well financial assurance and those that shouldn't, so that you avoid some of these unintended consequences that Mr. Gilstrap spoke about.
Okay, and I agree. I think we need to box Own over into a different category. They're kind of atypical. But so if we were to define this third tier and we use your numbers 2 and 10 or some other numbers, I mean, isn't there a asset group that should be bonding up with single well financial assurances? And if not, they, are going to be exposed, as some folks have said, as functionally orphaned already?
By asset group, sorry,
I'll let you answer that question, then I've got a follow-up question.
Well, by asset groups, do you mean operators?
Mm-hmm.
Oh, yes. I think that there is no doubt that there are operators in the state with extremely low production that don't have an active well fleet to provide a BOE that's meaningful, an average daily well production value that's meaningful, and that have a disproportionate number of inactive and perhaps what Commissioner Mesner would call idle wells. Those assets represent a risky proposition. And I think that in those circumstances, single well financial assurance may be something that you want to consider.
What about the concept that's been floated by a couple of commissioners of some form of amnesty program, without getting into the details of what it might look like, but between effective date and 6 months, you can give us the keys to your wells, you can give us all your financial assurance, you sign a pledge that you'll never operate in the state again, and we take advantage of the fact that we've got federal funds coming in and we use that to plug and abandon those wells.
Yes, well, I haven't surveyed the entire COGA membership or even a meaningful number. I will say that the concept has facial appeal. I do want to point out the issue that Mr. Sura raised, which may be the only time I say this in this entire rulemaking, that you need to make sure that there are significant consequences for the operators that do exercise that amnesty. As you said, Commissioner Robbins, they really should not be allowed to participate in the state again.
Okay.
Because to some extent, they are getting a bit of a free ride despite giving over their financial assurance. And who's going to pay for that free ride? Well, federal government will through its 94 million, I suppose, but so will operators.
Yeah, and again, I'm not in favor of free rides, but I'm also cognizant that if what we do is going to end up with us having to default against a subset of operators, there is some positive benefit to not having to go through the enforcement process and all that entails, as opposed to just go ahead and calling an apple and let's figure that out.
But I think the virtue of focusing on those asset groups, as you call them, those operators, is it does what financial assurance should do, which is look at the operator's unique circumstances and risk value. That's how financial assurance should be set. It's misleading, I think, to talk about an impending orphan well crisis based on the number of inactive wells and the number of low producing wells without looking at the operators themselves, Commissioner. Because as you know, a number of those inactive wells are owned by large operators with a robust average daily production. And as you also know, there are a number of low producing well operators in the state that are at around or even under 2 BOE a day, own resources, that doesn't pose a risk of orphaning wells. So you need to look at the specific operators to catch the painted Pegasus of the worlds before they declare bankruptcy. I'm sorry for that polemic, but.
No, it's okay. That's what we signed up for. We heard today from some of the local governments, Ms. Paranos in particular, and I appreciate hearing from her on the issues she speaks to because she is well versed. The concept of 1 million for environmental insurance and liability insurance is too low, and she advocates for 5. Any thoughts you'd like to provide on that from your membership?
Well, Mr. Gilstrap is an expert on insurance, so I can let him answer.
Yeah, that'd be great.
Sure, happy to. So I guess one clarification that I'd like to make is I think that sometimes, or at least as written, it creates in the insurance world a little bit of confusion. Usually when I hear environmental liability, I'm associating that with a gradual pollution coverage. And within the draft, I think it says environmental and then sudden and accidental. I think the intent here is to focus on sudden and accidental pollution. To answer your specific question, most general liability policies that are issued to an E&P company or a service contractor for that matter are going to include what's called sudden and accidental pollution coverage. This general standard within most of your reputable insurance carriers is that sudden and accidental is going to be subject to 30-day discovery period from when the incident occurred and 90 days to report that to the insurance carrier. So to your question, is $1 million too low? I would tell you that from my experience, the vast majority of E&P companies in Colorado typically carry a general liability policy as well as an umbrella policy. So an umbrella is going to provide you an additional layer of limits of insurance. And typically we see that most operators carry between 5 and 10 million already. I don't think that setting the threshold at $5 million for sudden and accidental pollution coverage is going to fall outside of fairly normal expectations for what a lot of industry is already carrying.
Would you mind finding out how to get a hold of Ms. Paranos and talk with her about it, and y'all come back and talk to us collectively about the right answer there?
Sure.
Excellent. Mr. Matthews, one final for now question back to the amnesty issue. I'm a lawyer, never say it's your final question. What about the concept that was floated by some of kind of partial amnesty, which would be a vehicle for an operator that potentially is kind of like on the edge, but they could take some of their portfolio, amnesty it, and then use that to make the rest full cost bonds or whatever it may be. And I'm catching you cold on that. And if you want to think about it and come back and rebuttal, but it's another way of thinking about the pros and cons and also not giving kind of a complete free ride.
Right. That has some merit. I do also recommend, the goal is to have operators provide meaningful financial assurance without defaulting. And I do know that there are 6 or 7 proposals made by, I'll just say own resources again, that have some merit in a circumstance where you have an operator, as you said, on the edge. And there may be a circumstance where that operator can commit to single well financial assurance over a sustained period of time, a sinking fund over a sustained period of time, a plug and play scenario, which I note Mr. Freeman rejected earlier today, that allows an operator to actually get credit for plugging its wells in terms of the amount of financial assurance it has to submit. And then, of course, demonstrated costs rather of plugging and reclamation instead of the matrix. I think that for operators who are on the edge, these tier 3 operators, if the goal is to make sure they don't default and still can plug their wells, I wholeheartedly support us investigating these 6 or 7 different parameters that can be worked into a schedule to make sure that these operators don't orphan their wells, but still are plugging their wells and have some meaningful financial assurance. That's what I would view as a partial amnesty program. Tier 3 that is extremely flexible. I think that has a lot of facial appeal. Anyway, I didn't quite answer your question, but I thought at least that's what I think is a more compelling answer.
Okay, thank you all. And my commissioners, I apologize for dominating the initial part of Q&A, but hopefully that was some of the things you might have been asking about, and you can now fill in the edges. So who wants to go next? Commissioner McGowan, then Commissioner Messner.
Thank you, Mr. Chair. And I have notes all over the place, so I'm going to kind of be all over the place. So bear with me, please. I'd like to start with the comment, I think, from Mr. Gilstrap that the bonding world has become more difficult for operators to be in. It's become more expensive. And I'm wondering if that's because oil and gas operations has become more risky over time. And so therefore it's become more expensive to become bonded. So you really haven't explained why it's become more expensive over time. And I'm wondering why that is.
Sure, very fair question. So it's like anything, right? When a hailstorm rolls through and it damages houses in your neighborhood, even if your house wasn't damaged, your property premiums are typically going to go up. Within the surety market, there have been a handful of massive losses that have really triggered this rippling effect throughout the entire surety market. The most recent prevalent example would be Fieldwood Energy's bankruptcy in Texas. So Fieldwood alone had about $1 billion bonding program in place, had a lot of offshore production. When they filed bankruptcy, the surety markets were immediately hit with $500 million of losses, with another $500 million currently reserved. That figure might be a little bit skewed. It might be more paid out now, but they're going to face $1 billion of losses. There's no individual bond or surety market out there that has capacity to take on $1 billion of risk. So nearly every surety that has an appetite for oil and gas bonding has experienced loss from that singular bankruptcy alone. So it's really some of these massive shock losses that have created this rippling effect throughout the market. Again, a bond is not a transference of risk. These underwriters are in the business of never having to pay that money out without being able to recoup it from the operator. In instances like Fieldwood, they're just out that money.
Thank you. And then I'm wondering if you could explain to me, I'm not sure I'm understanding the concept that you brought up, which was if an operator has started some sort of a sinking fund or a trust that they're putting into each year, that the surety bond agent wouldn't look at that and see that as reduced risk because they actually have assets that they're starting to set aside that grows over time, which would make the surety bond, I think, more solid in covering the difference for an operator. And then you said they're only looking at it on an annual basis. And so I'm not sure I'm understanding what you're trying to get at there or why the connection with the surety bond and reduced risk for an operator that's also starting to build up a sinking fund or a trust.
Sure. So it comes down to a multitude of issues, one of them being capacity issues. Excuse me. So the surety, if we were to do something like a sinking fund, the sureties going to want to get a sense of what's the overall exposure that we're looking at, right? I get that maybe each year it's going to grow by $1 million or 10 million, whatever it is. But over the lifespan of this fund, what is the total exposure that we as surety are facing with? The reason being a singular surety is not going to want to take on more than X amount of exposure. And that amount is going to vary by surety, right? Someone like Indemco might be comfortable going up to 10 million. Sampo, maybe it's 100 million, but they're going to want to get their heads around what does my long-term exposure look like over this? Because of that, and again, because sureties are always in the business of never experiencing any losses, they're more than likely going to say, okay, you're looking at a fund that you want to set up over the life of 10 years that you're expecting to have $100 million worth of financing in there. That's our exposure. Sure, it's not our exposure today, but that's the exposure that we're looking at over the course of 10 years. Not only do I anticipate seeing pushback from the vast majority of sureties being interested in something like that, but I also think that they are going to charge, oh, sorry. Did I lose you? Okay, sorry about that. I had a call coming in and everything went black. So they're going to look at substantially higher collateral requirements, right? Especially if we're talking about this huge penal sum. And again, I think the massive uncomfort level for most sureties is they don't like these long-term big pool exposures, because again, it's hard to predict what particularly something that's cyclical, like an oil or gas commodity price, is going to look like 10 years down the road. We've looked at options like this in other scenarios before and never had any interest from sureties to take on this sort of exposure. They want something that they can wrap their head around on an individual operator basis, understand their assets that they own, their financials, any sort of hedges that are in place, et cetera. It just helps them, I think, in their perspective, to de-risk that bonding scheme.
Okay, I think I might have to think about that a little bit. Jumping around, this is maybe for Mr. Matthews or Ms. Ryan. I'm wondering what your thoughts are about requiring single well financial assurance for new wells, and just and why an operator wouldn't fold that into their authority for their AFE, because lots of other costs are folded into the AFE up front. You let the shareholders know this is what it costs to find the mineral owners and rent the equipment, and also the cost to provide financial assurance for this well. So why wouldn't we fold that into the AFE costs up front?
Well, I think there are a couple of answers. One is the one that I think Commissioner Gonzalez has identified early on. Forgive me, Commissioner Gonzalez, if I'm putting words in your mouth. That money is a small percentage that is folding into its AFE up front, as you were stating, but it's not going to have access to that money for the entire life of the well. I mean, that money is going away. Whether it's in cash collateral, whether it's in a letter of credit, or whether it's in a surety bond, that company is not going to have access to a substantial sum of money for a prolonged period of time. I think too, Commissioner McGowan, this goes back to the rather gratuitous comment I made to Commissioner Robbins, that when you're doing when you're looking at financial assurance, you need to look at the operator. If an operator is a tier 1 operator with robust production values, with little risk of orphaning any of its wells, why have single well financial assurance imposed on it for a new well? By contrast, if an operator is on the edge and its production is extremely low, it's a tier 3 operator, perhaps single well financial assurance for a new well is appropriate in that circumstance. But why have a one-size-fits-all solution, such as single well financial assurance for all new wells, when operators run the gamut from Painted Pegasus on the one hand to Chevron on the other? It doesn't make sense to me, and it sort of flies in the face of what financial assurance should do. And yes, it's a drop in the bucket for the revenue of that well, but it's money that operator isn't going to have to plug and abandon its wells or orphan wells. It just doesn't make sense to me for those two reasons.
Okay, so but over time, the balance sheet for that operator, right? Your debt at the end then starts to shrink. So your company looks more healthy because you've anticipated the end of life of that well. And I guess I am trying to understand how sustainable the process that's being used right now, which is I use a new well that's producing a lot and bringing in income to try to deal with my older, lower producing wells that I haven't saved for. And it doesn't seem very sustainable over time to me. And so I'm trying to figure out at what point and at what balance do we decide this is a good time to require a higher level of assurance or bonding or sinking fund or trust fund or what have you. And I'd very interested to hear what you have to say.
I'd like to gently push back on the notion of sustainability. Under the draft rules, Commissioner McGowan, even as revised by the operators, and the operators are largely in agreement here, blanket bonding amounts, an operator that is eligible for blanket bonding, that amount covers its active well fleet, but it still has to pay single well financial assurance for a substantial portion, 90% under the current draft rules, of its inactive wells. The blanket bond only covers 10% of the single well financial assurance for its inactive wells. So even a tier 1 operator is effectively paying single well financial assurance for the vast majority of its inactive wells. In that respect, it is quite sustainable. Inactive wells that are on the out of service plugging list are not going to be brought back into production and are going to be plugged pursuant to an agreed upon schedule. So they aren't a problem either. I think the current draft rules, as revised by the operators, are an extremely sustainable model, particularly with the $94 million in federal funding coming into the Orphan Well program. At least that's my perspective. I'm really sorry if I missed the point of your question.
No, I'm just trying to everyone has a lot of ideas and I'm trying to work through a lot of that and get different perspectives and different answers. So I'm curious to know if we're looking at, I'm going to go back to something I think Commissioner Gonzalez said, which I totally agree, which is that it seems like there's two different kinds of risk that we are concerned about. And one is the financial risk of an operator, potentially, what their financial or fiscal health is. And the other is the risk of a well and the health of wells and the portfolio of wells. So if we're thinking about at what point someone tips over into red flag, we're concerned about what's happening with this operator and before it gets too late, because I've been thinking a lot about both ends of the tiers. One, which is creating your own individual plan and putting guardrails, and I've asked this question before, so I'm sure you're not surprised. What guardrails should exist so that we know you are in the upper part of the bell curve, you're a high performing operator, we're not worried about either of those things for you. And then conversely, at the other end of the bell curve, but before it gets too late and you're just handing wells over to the commission, what are the red flags that we need to look for where we say, we need to up your single well, you have moved to a different tier, we have concerns. And so for you and in your perspective, what should those guardrails be? And I think I heard you talk about income to debt ratio, compliance, compliance history, production value. I'm wondering if there are other things that we should be looking at.
I mean, I think that's one of the most important questions here, because to my way of thinking, as I said earlier, you need to separate Painted Pegasus from the own resources to have a meaningful financial assurance program without unintended consequences. So what are the guardrails to do that? I will say, I think compliance history has to play a big role in that after listening to Adams County testimony today. I mean, the fact that you have operators with extremely low production values, a very high percentage of inactive and idle wells who aren't responding to calls, who aren't allowing inspections, is frankly somewhat outrageous to me. And I think that sort of history needs to be baked into the guardrails used to come up with that very important demarcating line. That's what I've come up with so far. I think again, the history of their own plugging program. I mean, and Commissioner McGowan, as you've raised on several points in the past, what does their asset retirement program look like? I think those are both very important questions as well, that I would want to know in sitting there making a determination about whether an operator is tier 1 or tier 3, or whether a tier 3 operator needs to be ratcheted up to something close to single well financial assurance, perhaps under this passive mitigation plan that we were talking about, or can just pay, 70th percentile of single well financial assurance, or whatever it is, the number that you've come up with.
Thank you. I think this might be my last question, but I will stick to the rule of don't make promises you can't keep. Could you explain to me how you all came up with 60 BOE, 90 MCFE, or 30% low producing wells for tier 2? I've been asking folks in conversations when they've been talking to me, like, besides like this felt right, what data are we using to know that this is an amount that puts you into tier 2 or tier 1 or tier 0, whatever we're going to call these tiers? And I'd like to know like what kind of data is behind it, or what the justification is, and why you all want to change it to or instead of and why the commission should think that that's an appropriate change.
Well, the second question is somewhat easier to answer than the first. And perhaps Ms. Ryan has some views on the first question you asked. In terms of the second question, based on data that we have done, based on 2020 data on the COGCC website, making it and instead of or would allow an extremely small percentage of operators to qualify for tier 1 bonding. That to me is an unacceptable solution, especially under the current draft rules, because it pushes everybody else, 95%, 96% of operators, into a single well financial assurance regime. That was the starting point for going from and to or. Also, as I indicated, I think both, and COGA has actually done the analysis of which operators would meet, and I think a number of operators have, which operators would meet which of those standards. Both are indicative of an operator's financial health. I will admit they're somewhat crude indicators, but we've all been struggling with decent parameters to define blanket tiering, which I think more than anything else suggests the wisdom of the go your own adventure route, because it is so hard based on the individual circumstances of an operator to figure out adequate financial assurance. But if you're going to have crude indicators of blanket bonding, and I think you do need a blanket bonding tier, what better ways of measuring it than average production values per well using BOE or MCFE, and percentage of low producing wells, which includes inactive wells. Now, as I've said, there are a number of operators with a vast fleet of low producing wells who are responsible operators, but that still is an indicator of, I think, of the financial rectitude of a client, of an operator. How much of its fleet is above 2 BOE in terms of average daily well production? In terms of how we reach those numbers, I mean, I think they were largely in discussions with the director, and we were also using her numbers to some extent. Ms. Ryan, perhaps you have a greater clarity on the issue of how those numbers were arrived at, but my memory is we were primarily using COGCC numbers.
Yes, that's right. Staff draft had 60 BOE. We took a looked at it, and it's 4 times what's traditionally considered a stripper well. That's the 15 BOE. So that sounded like a reasonable amount of protection to the commission, 4 times higher than the stripper rate. But it was based on staff draft.
And perhaps I misunderstood, but I think staff draft has that as a tier 1 and you all have it as a tier 2. Am I misunderstanding?
We have elevated tier 1 to the what Commissioner Robbins calls the bespoke plan, so because we think it's the most important.
Okay, your flipping is not a tier 3 anymore. The individualized financial assurance plan is now a tier 3. Tier 1, a first choice for folks. Tier 2 would be you fall into the blanket bonding if it's now this definition. Got it. Yes, thank you.
And Commissioner, one final word. I think COGA is somewhat agnostic on the issue of whether there should be 1 or 2 blanket tiers. I note that West Slope COGA, to represent the somewhat unique circumstances of the gas play in the Western Slope, has 2 tiers. We don't object to having 2 blanket bonding tiers, but their first tier, the bespoke, and the final tier for extremely low producing operators remains the same.
Okay, thanks. I'll stop for now and see if anything else comes to mind.
Commissioner Messner, you're recognized.
Thank you, Mr. Chair. Thank you all for the presentation. And thank you to my fellow commissioners. Asked a lot of the questions I was going to ask, but of course I've got a few more. So related operators, I want to dig into this just a little bit, because I think one of the concerns that I have is that, at least the way that I read it, and correct me if I'm wrong, but it would give an operator the ability to pick and choose what subs may be considered related. So you're not taking all of your subs, you can take some of your subs. And so what keeps gamesmanship out of that to ensure that you consolidate all of the subs that have the highest producing assets and then group all of your low producing assets into another sub in order to be able to game the different tiers within any proposed financial assurance mechanisms?
That's an excellent question. To be honest, it's one that I had not considered, because members who have spoken about potentially trying to avail themselves of this opportunity would include all of their subsidiaries. And so because those are the examples I had top of mind, I quite frankly just never thought of that happening. I think it would be fairly easy to build in language in the rules or SBP that says that you have to make it all or none, but I hadn't considered that. I apologize.
No, that's okay. I'm not opposed to the idea, but I am opposed to creating loopholes. And so,
Sure, it makes sense.
yeah. So I would appreciate like looking at that and making sure that it is solid. My next question, and I think Chairman Robbins kind of addressed this, but I mean, I just want to confirm. I mean, you do feel like this commission has the authority to have a 211 hearing to determine used and useful. That's not something that you're challenging, or is that something that you're challenging?
Correct. We're not challenging the commission's ability to have a 211 hearing. We are just opposed to certain party requests to expand what's put forward in staff's draft to expand the circumstances under which a hearing could occur.
Okay. And Commissioner McGowan asked the question because I was curious about the different elements that may create the situation where rates are raised. But I do want to ask a little more about that. So this is probably for Mr. Gilstrap, but my understanding is that, at least what I'm hearing you say, is that surety companies are asking for, at a minimum, 50% collateral, if not 100% collateral. I think we heard from Commissioner Gonzalez in some of his conversations that there's very few surety companies that are asking for less than 100% collateral. And so if there is no risk to the surety company, because they are asking for 100% collateral, then why would the rates be significantly higher? Because in essence, because you're asking for that collateral, the risk is significantly lower.
Great question. So again, I've heard hearings on and off over the last day and a half, and I've heard some people throw out other figures like a 1% bond rate. The only industry I work in is oil and gas. That's 95% of the clients that I touch. So it's possible that there are lower bond rates out there for other industries. Within this particular industry, this type of bond, 2.5 to 3.5% plus is very standard. Now, to answer your question though, Commissioner, if the surety is requiring 100% collateral, I'm going to do everything in my power to get that bond rate down to the 2.5%. Because to your point, we have significantly de-risked that surety at a loss that they're not going to be able to recover. Typically, you're going to be seeing a higher bond premium the lower the collateral amount. So if I'm able to get a bond done, but for zero collateral, which I haven't been able to do for years, but if I were to get that done, I'd probably be looking at an annual bond premium in excess of 3.5%. Typically within that 50 to 100% range, which is what we are seeing, the normal bond premium percentage is 2.5 to 3.5%. To your point, lower, the higher the collateral amount, the more I'm going to try and shove that premium down with the carrier, and usually can do it successfully down to about 2.5%.
Okay, thanks for that. So this is a probably for a couple of you, but so I think that there's some. What I'm hearing is that there's some interest in this choose your own adventure route, and for opportunities for operators to be able to have individualized financial assurance plans. But understanding from Mr. Gilstrap, at least I'm interpreting it a little bit, but I mean, it's a little bit fatalistic in the approach in saying that there may not be the opportunity for any surety bonding for some significant majority of operators in the state of Colorado. How even in a choose your own adventure route can we create a financial assurance plan if a surety bonding company has no ability to provide bonds for 50% of the operators in the state?
I can clarify. I think Mr. Gilstrap was, and when I made the similar assertion, Commissioner Mesner, were speaking about a single well financial assurance regime. So I think our point was that the financial assurance will be unavailable or enormously expensive for operators that face single well financial assurance. The bespoke route is not that. Operators would not be proposing single well financial assurance. They'd be proposing some percentage of it. So surety bonds may be available in those circumstances. If not, operators can use a trust fund or a letter of credit, which requires almost full cash collateralization. Mr. Gilstrap, did I
Yeah, that's
correctly interpret your testimony?
Yes, and I do want to clarify, Commissioner. Bonds in general, I can get a bond for anybody. It's rare that I can't. However, it is rare that, or in those situations where it's problemsome, I'm going to have to find the 100% collateral from the client, right? That's where the issue occurs when we're talking about these big limits. I don't think that the vast majority of your small to medium-sized operators have that cash collateral on hand to pony up $15 million in collateral on that type of bond. That's the issue. Not that the sureties won't issue it, it's that they won't issue it for less than 100% collateral that I think a lot of these guys are not going to be able to afford.
Okay, well, let me dig into that a little further then, because even if it's a lesser amount than single well financial assurance, I'm assuming that there's still a significant dollar amount associated with financial assurance. It's not going to be the $100,000 that we see today. So what is the threshold for low producing operators, medium producing operators? What is that dollar amount where a surety company is going to be able to secure bonds utilizing even 100% collateral for these companies? What are the dollar amounts we're talking about here?
I think it's going to vary by operator. And I can't give you a blanket statement that says you pick this amount and it's going to work for everybody, because everybody's individual situation is going to be different. I can tell you that as proposed, I don't think it's going to be anywhere near fathomable. I know that the end result of this is the amount is going up, right? And it's not going to go up to $105,000. It's going to go up significantly. I wish I could give you better direction on this is the magic number that would create a win across the industry. Admittedly, I don't have that, because underwriting is so individually based on each company, their financial assets, their reserve reports, et cetera. So honestly, I don't have a magic number for you.
But Commissioner Mesner, that, to my way of thinking, is only a small portion or a portion of what the bespoke process would look like. It's not just whether an operator, under what terms it can obtain a surety bond. It's what if it can't obtain a surety bond? What about if it can get a trust fund? And then based on demonstrated cost, it can show that a blanket bond of X is adequate for its active wells, and some different number may be required for its inactive well fleet that aren't on the out of service plugging list. Maybe that's paid not over 10 years, but if it can demonstrate a 20-year average remaining life of its wells, maybe that's the period of the sinking fund. When you're talking about some of these operators, that's what's going to have to go into the bespoke plan, not just, oh, you can't charge me this amount, I can't get a bond.
That's fair. And let me ask how potentially, what would it look like for a surety bond company to have an operator that had a mix of financial assurance mechanisms that included a trust fund and an ask for some percentage of whatever their financial assurance obligations are in a surety bond? How does that trust fund negatively impact how a surety bond company would look at the financial health of that company?
That's a good question. Admittedly, I haven't run into that situation before. So I would honestly have to talk with some of the surety markets and see what their perspective would be on something like that.
Okay. I mean, to me, that's an important question, because I do think that irregardless of what we put forward here, I think that I'm a big fan of allowing a number of different mechanisms, financial assurance mechanisms, to be utilized to be able to ultimately meet whatever the financial assurance obligations are. And so that could be, a combination of, and I'm making stuff up here, but a letter of credit, a surety bond, and a trust fund. And so, but I don't know how these things interact. And I think that's probably important to know before, so I at least know what I'm proposing. So I'll just throw that out there. And I think, Mr. Matthews, I heard you indicate that I was going to ask you about what COGA's thoughts were around West Slope COGA's suggestions around additional tiers than I think what COGA is suggesting. And I think I heard that you like it, or at least that's palatable to you, or?
I do like it. I mean, I think it's creative. I think it reflects the needs of gas operators in the Western Slope. I don't think it diminishes the protectiveness of the tier structure at all. And I think that West Slope COGA's proposal for 2 blanket bonding tiers is very creative and something that the commission should give a lot of thought to.
Okay, I appreciate that. Now, what about the Kinder Morgan suggestion around some qualifications for being able to qualify for I guess the current tier 1 concept?
Yeah. Well, I want to be clear about the context in which the Kinder Morgan made that suggestion. I think it's been a little bit taken out of context, and then I'll answer your question. It didn't come up in the most recent version of the statements. It was in the pre-hearing statement in response to the earliest draft rule. And it was the final tier. And so Kinder Morgan adopted West Slope COGA's top 3 tiers, which included, I believe, 2 blanket bonding tiers and perhaps a bespoke plan. I'm not sure. But then the 4th tier, Kinder Morgan proposed that an operator who didn't meet the prescriptive criteria of the blanket tiers could still move into those tiers by demonstrating financial rectitude based on these 3 or 4 complex factors. So we have to recognize that it came up in that context. It's not something that is required for a tier 1. Now, having said that, I think there is a place for those factors. It does unduly, or not unduly, but it does complicate your deliberations. But this entire discussion, I think, highlights how complicated it is to determine an operator's viability and likelihood of having orphan wells in the future. And those factors mentioned by Kinder Morgan that Matt Sura emphasized are factors that perhaps should be in your quiver. If an operator doesn't meet the blanket bonding requirements for what we call tier 2, instead of being presumptively tier 3, perhaps it can waive into it if some of these other standards are satisfied. So I think there's a role for it.
And if I may just quickly, but so as Mr. Matthews was explaining the context, I just want to reiterate that COGA is against having it be an and for blanket bond criteria. It would just be another on-ramp if you don't otherwise meet the criteria. The presentation you heard from Mr. Sir and others would have had those financial test elements as part of a blanket bond criteria itself. We oppose that. We like the blanket criteria as it is, with our suggestion of making it in this disjunctive. This would just be another path to obtain blanket bonding, but not additional criteria.
Why? Let me just ask a little further. Why would you oppose it as far as being a criteria to qualify for a blanket bonding amount? Understanding that, particularly with the current draft of a tier 1 blanket bonding amount, it's significantly less than what a single well financial assurance would be. Let's just say that. Do you not feel that it is appropriate to have some sort of financial health qualifiers to be able to have the advantage of that lower blanket bond amount?
We do, but I would suggest that the criteria itself is is relevant to the financial health. So by having very high average daily BOE, that is indicative of financial health. So we think the criteria in the draft rules itself, that's the financial health criteria. So the other information is just a different set of criteria. And so we think you can use the BOE criteria instead of that criteria.
But I mean, you're also suggesting, and I don't know as I disagree or I'm thinking about it, but you're also suggesting that an operator could qualify for the existing tier 1 blanket bonding by having a less than 30% of their low producing wells criteria. And so that may or may not indicate a certain level of financial health, like perhaps an overall portfolio of 60 BOE.
Sure.
And so how do those two things comport?
Well, I believe in Kinder's version of using that criteria. So, sorry, backing up. So in COGCC's proposal, if you are qualified for the blanket bonds under the criteria, it'd be eligible for administrative approval path. If you were trying to use this other criteria, my understanding of the Kinder proposal is that that's something that goes to a hearing. So the operator would be able to say, well, we didn't meet the blanket bonding criteria as written because of specific operator circumstances, but we have all of these other things. And that's why we think we should be still eligible to the blanket. Now, really, that kind of
and I understand Kinder Morgan's proposal in their concept. So I do understand that. And I don't mean to cut you off. I think my ask is to kind of opine on why shouldn't that be utilized as a criteria, as some of the conservation groups have suggested, to qualify for a tier 1 blanket bonding mechanism versus a choose your own adventure.
I mean, I think there are two quick answers. One is you need easy to apply prescriptive determining average well production for a well and number of low producing and inactive wells is a number that's easily determined and can serve as a surrogate for director approval. To be frank, the second answer is we haven't really studied those terms because they were dropped early on in this proceeding.
Okay.
So what we're trying to avoid, and I'm just being transparent here, but I think this is important, is a scenario similar to what exists in the draft rules now, where blanket bonding is available to a very small percentage of operators and everybody else falls into a single well financial assurance, Commissioner Mesner. And we haven't studied those factors to make sure that if we do make an and to the or criteria that we're already advocating, if it isn't prescriptive in the sense of significantly limiting the operators who should be able to employ blanket bonding because of their financial rectitude, but can't. So that's the answer, really.
That's fair enough. So let me move on a little bit because I do want to
look at it. Excuse me, I interrupted you.
No, I apologize. Continue. I didn't hear what you said.
I apologize, Commissioner Mesner. We're certainly willing to look at that.
Okay. Appreciate that. So I'm going to poke a little bit here at the choose your own adventure, just to kind of like work around some of the unsaid, has been said, but maybe not worked out criteria around it. I think Chairman Robbins had talked about, what are the bookends? What not necessarily to qualify to be in the choose your own adventure, but what are the bookends to, what is the starting point for this commission to determine what's an appropriate amount of financial assurance? And I did hear your answer, but I guess I'm a little concerned. I mean, I remember back to the mission change rulemaking and COGA having concerns about a standardless standard, right? And so having no starting point, having no bookends inside of kind of a choose your own adventure financial assurance plan review seems a little bit like a standardless standard. I feel like there's got to be some starting place or some criteria for us to start to evaluate the efficacy of the plans that are being presented in front of us. So I don't know if you guys want to opine on that or just think about it, but I'm struggling with that one a little bit.
Well, it is, and I'm struggling with it too. It is a messy adventure, but it's not messy because it's ill thought out. It's messy because of the nature of determining financial assurance for an operator, which is enormously complex. And yes, We raised the standardless standard, for example, with regard to substantial equivalent, with regard to setbacks, not to rehash that issue. I would argue that what we're talking about here is somewhat different because of the inherent messy nature of determining financial assurance for an operator. But there should be, I think, 5 or 6 requirements that an operator must submit to you as part of a plan, which would include some of the elements that I discussed in my colloquy with Commissioner McGowan that are very important that you need to consider. And then I think it will become apparent what the appropriate financial assurance will be. It'll be messy in the first few hearings, but I think there will become standards that are enmeshed in your decision-making over time. I really want to avoid guidelines to the bespoke adventure precisely because of the difficult, I mean, look at the difficulty we're having, Commissioner Mesner, establishing prescriptive criteria for blanket bonding. It is tough. I mean, you mentioned the Kinder Morgan factors, in addition to percentage of low producing wells. There's a potential infinite number of factors that can be used there. The best I think we can do is come up with what needs to be submitted to the Commission for the financial assurance, and then you all deliberate. I really hesitate to put guidelines on that. And for the lowest producing operators in the state, single well financial assurance should be on the table.
Fair enough. Fair enough. So just a couple more questions. I want to talk quick about the Orphan Well program, the Orphan Well funding mechanisms. I've asked this question to a number of people. I'm curious as COGA's thoughts on Orphan Well funding mechanisms, the interaction or lack of interaction between the Orphan Well program and determination of adequate financial assurances for existing wells. And I mean, I've read your pre-hearing statements that pretty clearly indicate your preferral for a cap on what the Orphan Well program should be. But in light of some of the discussions that have happened over the last couple of days, I wonder kind of what your thoughts are about ensuring that there's a robust Orphan Well fund
right
moving forward.
Well, I think our answer, just like the directors, has changed with the massive contribution that is anticipated to be made by the federal government. And I listened very carefully the other day to Commissioner Nanjapa's point about how the commission can most effectively use that amount of money. I mean, how many drill rigs are there to actually allow P&A wells? And I think you'll hear from individual operators about their robust plugging program and how many drill rigs they already employ on a near constant basis in order to P&A those hundreds or thousands of wells they do each year. All of which is to say there is an implementability issue. I think it's facile to say that if there's money there, demand or supply will follow. I think that's too facile in this circumstance. So you have $94 million that we didn't account for in our earlier comments. And we have a limited number of rigs available to actually P&A the wells. So I think COGA wholeheartedly supports the direction that Director Murphy is taking now of capping well fees at an amount to allow administration of that 94 million and then seeing what happens and reserving the right to raise and put an orphan well charge on new wells. To your second question, I don't think that the two can all be viewed separately. I think that this influx of money to the Orphan Well Fund has to be viewed in the context of your setting financial assurance regulations. It would be foolish to put blinders on. The fact is there will be this amount of money that was not previously available that will take care of a substantial portion of the orphan wells that currently exist and that will exist over the coming years. You have to take that account in establishing financial assurance. You want to make sure that existing active wells and existing inactive wells are taken care of, but you're not looking to build up an enormous pool of funds to take care of orphan wells that don't otherwise have funding. So I think you need to view them, I hate this word, in a holistic manner. And your financial well assurance deliberations have to consider the 94 million coming into the state.
Well, and let me take that just one step further too, because there are certainly some that are of the thought that the bigger the orphan well program, the more palatable lesser amounts are in a blanket bonding scheme and or a bespoke scheme and or a whatever scheme is from a financial assurance model. So if there is this big, robust orphan well program that isn't the bare minimum, but rather does grow and actually is a significant general backstop to general financial assurance, that those two things should be looked at holistically and kind of be a check and balance to perhaps a lower general blanket bond financial assurance concept.
That is a more articulate version of what I was trying to just say, Commissioner Mesner. Now, I differ from Mr. Sura, for example, in thinking that you need to charge $300 in registration fees so you have a robust orphan well program. You're going to have $94 million or up to $94 million. How much more does the state need to plug this relatively small orphan well population? What would it do with the excess funds?
Sure, fair enough. I mean, I think it has to be a way to show the utilization of it, but it would just be another trust fund or sinking fund mechanism for all operators throughout the state versus this ask for a single well financial assurance sinking fund for individual operators. So this is at least what I'm hearing some folks contemplate, right?
Well, and I'm contemplating it from a slightly different perspective. I think the 94 million should absolutely inform the amount of your blanket bonding and single well financial assurance asks. I absolutely do. I think it changes the game entirely.
Okay, no, I appreciate that. Last couple of questions. I've asked this to a couple other people, so I want to ask it to you as well. Should there be consideration in meeting financial assurance obligations? Should there be consideration given to an operator's P&A line item or demonstrated P&A activities over the previous year, as far as giving some credit, whether it's 50% credit or something like that, off of whatever the financial assurance amounts determined are?
I really think there should be, and I think that the current draft loses something in two respects by not making plugging ratios part of the tier criteria. I hate to invoke tier criteria again, but it just shows how messy it is. Why wouldn't an operator showing that it is P&A'd over 2 wells for every new well it's spud over the last years, why wouldn't that be indicative of tier 1 status, of its financial rectitude, and also that it's solving the problem? Similarly, when you're ponying up this single well financial assurance amount for inactive wells, because remember, blanket bonds only cover a very small percentage of those inactive wells, why on earth wouldn't that be reduced by an operator's robust plugging program? It just seems to me that that is, in some ways, the most direct criteria of the operator's financial health, and also what it is doing to solve this problem. So I'm glad you raised that issue. And I think the current draft loses something by not considering the plugging ratio in those two circumstances.
Appreciate your responses. I don't currently have any further questions. Thank you.
Gonzalez.
Thanks, Chair, and thanks to all my other commissioners who have asked almost every one of my questions, questions this whole time. Thank you to Mr. Matthews, Ms. Ryan, and Mr. Gilstrap for being here and for your testimony. I appreciate it. And I've got just a couple of questions I'm going to walk through. I think I'm going to direct them to who was covering the topics. This first one is to Ms. Ryan. In regards to, we're going to come back to 211 hearings again. You know, I understand your concern about kind of the inefficiencies that may arise with having hearings that are brought to us by folks who may not have all the information, right? You know, an operator's plans, an operator's reasoning, and perhaps there's the risk that we're going to be wasting our time with just a bunch of protests in that regard, or a bunch of hearings brought to us. And so my question is, because this is an idea that Commissioner Robbins had put up that has been sticking in my mind ever since, is, you know, if we have a requirement, you know, and when I'm not talking about the time frame for, you know, what triggers this, but just about the participation, if we have a requirement for a relevant local government to have to make a good faith effort to consult with an operator. That way they're going to receive all the information. The operator is going to have an opportunity to have an offline, non-public conversation with them, go through maybe some important borderline confidential information to work it through. Would that help alleviate some of your inefficiency concerns?
I think that, so to make sure I understand your question, so you're saying that under your proposal to be a staff's draft, and then you'd be adding an additional process layer to require local government as a prerequisite for filing an application to consult with the operator?
Something like that, yeah.
Then yes, I support that.
Okay. Yeah, I was just trying to, maybe that's a piece of low-hanging fruit we could pick up on. And I appreciate the discussion on 211 that we've had today. Let's see. Okay, so this next one I'm going to stick with you, Ms. Ryan, about the parent-sub relationships. And I know Commissioner Robbins kind of asked some questions about this, what types of operators they are. I'm going to be a little more direct. Could you just give me an example of what operators in this state are parents and subs that may fall under this?
Sure. Well, there's been some M&A activity recently that'll probably also pick up. So for example, Civitas is an entity comprised of 4 subsidiary companies. That might be a company interested in parent subsidiary relationships. There might be others in the state.
And I guess to clear that up a little bit, these would be parents that have a certificate of clearance Form 10 and a sub that has a certificate of clearance Form 10.
Yes.
Okay. Okay. That's trying to think through that a little bit further.
Commissioner?
Sure.
Can I add one piece there? So in my world, a lot of times what I'll also see is operators will set up different LLCs, right? So I'll have an LLC to be my holding company for the assets. I'll have an LLC that's the operator of record. I'll have the LLC that houses my employees and financials. So a lot of times from a surety perspective, maybe the operator of record is different than where the real financial pool is coming from at that executive level. So we want to ensure that all of those entities are contemplated to make them look best on paper to try and drive that collateral down.
Yeah, and I've seen that before. I've seen kind of a company, and then their operating arm is who's the operator in the state. But when I think about that almost leads me to the kind of the same concern that Commissioner Mester was bringing up. Within the same parent and LLC arrangement where you just have operatorship housed, or a certain other type of operation, or type of work within that organization housed in a different LLC, there seems to me like there could be some interaction there. So I'm just trying to think of what sideboards could exist there. So I appreciate that distinguishing of additional types of relationships. Still wrestling with that one in my head a little bit. So appreciate the additional clarification there, though. And I guess, Mr. Gilstrap, I'll stick with my next questions for you. How many other companies other than Assured Partners are in this surety bonding business for oil and gas?
Hundreds. So to be clear, we're an insurance broker. We are not a bonding company, right? So when I go out there to a Civitas or whomever it is, and I get their underwriting information, we're then taking it out to a multitude of different surety companies that we're appointed with. So I think your question is kind of twofold. There's hundreds of insurance brokers out there. In Colorado, oil and gas specifically focused, there's a handful of us. From a surety perspective, the actual folks that are providing those bonds, couple dozen that are really active in this space.
Okay, yeah, I was trying to get a handle on how big this, how accessible this market is, right? Are you the only guy that does it, or is there, a handful of folks that people can go in and choose from and kind of, see what they can work out, understanding that as a broker, kind of you're all tying back to the underwriting companies, the underwriting agencies.
For any operators listening, I'm the only option in town, so they should call me.
Fair enough. Do surety companies allow for the collateral that's supporting a bond to be invested?
To some degree, and it varies by surety. A lot of times, surety is going to ask that you just deposit that money into their account. There are some sureties that will make an exception and let you do it in an interest earning account, but it's usually an extremely low APR tied to those. You are not allowed to just set the money aside in escrow and invest it on your own. It has to be planted into an account. Some sureties will allow you to gain the APR, again, at a very low amount, on that collateral while it sits there.
Okay, thank you for that, Mr. Gilstrap. And again, thank you for sharing the information on sureties and filling in all the gaps that I missed in my speculation in previous answers. So I appreciate that. Mr. Matthews, I've got a question for you. In regards to the tiers that were offered, I'm still trying to reconcile the proposal between tier 3 and tier 1 as COGA has presented it. You know, to me, they kind of read very similarly, with tier 1 being for higher producing operators and tier 3 being for lower producing operators. But otherwise, it's pretty wide open on how they operate. How should we be thinking about distinguishing those in your proposal?
Yeah, that's a really fair question and one I've struggled with. I think that as we've set it up, and the best I've come up with so far is for those operators that are below the thresholds that you all established for this tier 3, that single well financial assurance is on the table as an option. And it may occur, it may in fact be the remedy for the majority of operators in that tier, subject to some of the mitigating conditions that we've talked about the length of the sinking fund, the pay or plug option, the demonstrated cost aspects. For operators in the tier 1 that have viability via some of these prescriptive methods, there really should be no need to talk about single well financial assurance for its active wells. Now, for its inactive wells, it's a different circumstance as we've discussed. That's the best distinction I can think of right now. But both will require, I think, both bespoke and this low producing tier, so the non-blanket tiers, will require consideration of numerous factors by the director and by the commission, and will require a hearing. So they are very similar in that respect.
In your tier 1, the bespoke option, are there qualifying factors to be able to apply for that? I'm not quite sure if I remember that from your filings, and I don't think I heard it in your testimony today.
Yes, I'm pushing back on that. I've been asked that by a couple of commissioners. In terms of obtaining a bespoke plan, and really tier 1 and tier 3 are both bespoke plans. It's just the tier 3 may include single well financial assurance.
Okay.
I'm pushing back against criteria. That is appropriate for blanket bonding. But because, as I just said to Commissioner Mesner, or I intended to say, because this is such a messy deliberation, we really want to avoid prescriptive requirements, like you have to meet some BOE requirement or have a percentage of low producing wells to be eligible for the bespoke option.
I think we also want to try and eliminate subjective application of financial assurance, I guess, regimes or what we're asking for with a bespoke option, which is why having some sideboards and some determining factors could be helpful there. But my next question is with regards to your tier 1, with regards to the drafted tier 3, why would an operator just go under a blanket bond? Why wouldn't they just try and get a little bit more of a benefit through a bespoke plan or a choose your own adventure plan?
A bespoke plan and a choose your own adventure plan, I've been meaning is the same thing.
Yeah, same. I'm meaning it the same way. My question.
Okay, I just wanted to make sure. So the question has to do with blanket bonding versus bespoke plan. I think that some operators may want the assurance of blanket bonding because they will be able to figure out ahead of time what they owe using the formula of blanket bonding and calculating the number of inactive wells that they're not putting on the out of service plugging list that they're required to pay single well financial assurance for. Some operators may well want that blanket bonding tier for that. I'm using assurance, and that's a dangerous word to use in this context, but I think you know what I mean. They know what they're going to pay ahead of time. Other operators, though, and I've heard this from operators, will want to go on your own adventure because they think that they have certain circumstances and maybe incredible liquidity. It may be a very low percentage of low producing wells that they think speak to a financial assurance plan that is better tailored to them. To your words, they may get a better deal. Or in my words, it may be more appropriate for their particular company. I think you're going to see operators who qualify for blanket bonding not necessarily choose blanket bonding in all circumstances, at least based on what I've heard.
Okay. I've got a question for, I'll stay with you, Mr. Matthews. This has nothing to do with anything you testified for. It's another kind of bridging a gap on something you heard that seems like low-hanging fruit to me. Do you have any comments on the use of the AVO inspection versus the measurement inspection that was proposed by several parties here, and that is apparently part of requirements under the AQCC rules?
Right. I think you're going to hear plenty about that from individual operators, and I do want to defer to them because they have real life experience. Also, I just want to say at this point that I think it's very dangerous for the COGCC to regulate in this area when that AQCC rulemaking came up with an incredibly complex regime for how to regulate leak detection, and did so, I understand, after a year of rulemaking, considering a multitude of factors. I think you want to be very deferential to what the AQCC decided and not come up with your own regulation. But I really do want to defer to what other operators say about that.
That's fair. That's something I'm bringing into this conversation. I left field. I fully respect that. Another left field question I'm going to ask, and I think this might be my last one. Are you aware of any maximums or caps for financial assurance in other states?
Yes, I think that, and Ms. Ryan may have an opinion about this too. I think California has the highest cap of 33 million for comprehensive bonds. My understanding is that bond covers everything. I think in addition, Alaska has a comprehensive bond of 30 million, which serves as a cap. Other states are I understand they're much lower than those numbers, but those two states come to mind. Ms. Ryan, do you want to comment?
Yes, that's right. And then for California's 33 million, being a little bit higher than Alaska's, I just wanted to point out that the actual presumptive blanket bonding amount, even in California, is $3 million, but you can get up to 33 with a discretionary 30 million. Just want to point it out that it's not even automatic.
Okay, so but the way you understand in Alaska and California, those operates as maximums to financial assurance.
Yes.
I think that's all the questions I have for you guys. Thank you very much, and thanks to all my commissioners who asked before me and carried a lot of the water for it.
Very good. Appreciate all the discussion and the questions and the answers from the panel. I have one follow-up. We've had Nathan Bennett with us this whole time. Did I understand that he is not going to be testifying with regard to Civitas, and that he's here to answer questions in case we had questions?
Yes, that's correct.
Is he still with us, or is that just a?
So actually at 38 minutes ago, he had to step out just for a moment, but he can be in front of a camera if he needs to be, if there are specific questions for him.
I just was going to give him an opportunity to explain a little bit about his testimony. I had read it and had a question or two. But if he's not available, that's fine. We've beaten you guys up quite a bit this afternoon. So with that, any further questions, Commissioner McGowan?
Thank you, Mr. Chair. And just related to the question from Commissioner Gonzalez about a total cap for bonding, it's my understanding, and you can correct me if I'm wrong, when we look at our current bonding structure and having put in extra financial assurance for inactive wells, we have some operators who are above the $30 million cap for bonding right now. Is that correct?
I think that is true, yes. I'm not sure, but I think that's true.
Thank you.
I see other commissioners shaking their head, yes.
Okay, final call. And I note for the record that Commissioner Nanjapa joined us during the latter part of the discussion. Good to have you back, and you'll have a great time going back and looking at the video of this. For everybody's purposes, the videos are being posted approximately 24 hours following each day's testimony. So just as an FYI. Okay, with that, we will let this party go. Thank you for your participation with us. Very informative. It is 3:40. Let's take a 10-minute break and be back at 3:50. And at that time, we will proceed with testimony.
Thank you very much.
I believe we are all here and a recording is in progress. And we have before us the Western and Rural Local Government and Garfield County Coalition. And good afternoon, Mr. Wen. I have you down for 10 minutes. Does that sound accurate to you? We need you to unmute there, Mr. Wen.
That sounds accurate. And I'd like to ask Ms. Larson to flag me with 2 minutes left. So I'd like to reserve 2 minutes for closing. And I'll decide at that time if I want to keep rolling or actually try to save it.
That sounds good. We will make sure Ms. Larson does that. And with that, I see that your slideshow is up in presentation mode, so you are good to go.
Excellent. Thank you very much, Chair and Commissioners. Appreciate the opportunity to participate in the rulemaking today. I'm Kirby Wynn. I'm the Garfield County Oil and Gas Liaison and also the Western and Rural Local Government representative to the rulemaking. Just a refresher, we represent 23 local governments covering 31% of the state and 45% of all active wells. And with that sort of credential, we feel like we've been there, done that with navigating the good and the bad of oil and gas. And so we feel like we have some substantive views to share. Again, we have all those Western counties you can see there that are all full of lots of oil and gas, as well as the far eastern part of Colorado. Our overriding theme is our concerns for economic impacts. We absolutely support and we do see the need for increased, improved financial assurances, but our local economies and our funding to support essential services for our WRLG governments and special districts, especially as compared to urban front range governments, are disproportionately dependent on continued economically viable oil and gas production paired with right-sized, necessary, and cost-effective, reasonable regulations. We lack the luxury of indifference to impacts to the oil and gas production of the other local government parties that so far we've seen plainly have stated zero concern that you leave a viable industry out there on the heels of this rulemaking. And a key thing we want to just sort of key on is, you're not working in a vacuum. You've had your own rulemakings, but from 2018 to 21, the OGCC and Air Quality Control Commission rulemakings using your own state provided estimates of costs of regulatory compliance have conservatively piled on $264 million to $340 million in new annual regulatory compliance costs across all operators across the state. That's not insignificant, and every bit of rulemaking adds something to it. Just in the last month, in December 2021, AQCC piled on their estimate of $64 to $140 million of recurring annual regulatory compliance costs in the greenhouse gas rulemaking. That's a part of that figure I cited. So we hope that you agree that your decisions in this rulemaking will surely serve to pile on an extraordinary annual cost burden that's new, and that it's critically important for you to adopt reasonable and necessary financial assurance rulemakings as you figure out what's the right size and what's really necessary to actually address the problem at hand without going overboard. Federal well exemptions are needed, I think, for now is the way I'd say it. We disagree that there's any kind of broad consensus among parties for applying most of the draft rule provisions to federal wells. Consensus that so far, that in all the pleadings that I've read so far on double bonding and fees for federal wells, seems to be limited to parties that we've seen in every other public venue. Though a lot of those same parties seem to be fighting against any type of oil and gas development, not just right sizing it or regulating it to a certain degree. And so no matter the protections and mitigations that we place on the development. So it's a concern to us that we ask you to really look closely at what people are offering and what's the genesis of those offers. We ask you especially just one thing, wait until the federal financial assurance rulemaking that BLM is going through this year. Make sure that's completed later this year to make informed decisions on any actual or perceived federal, state financial assurance gaps that you may see that you need to fill. WRLG supports limits on local government intervention in the plugging and abandonment process, specifically the Rules 503 and 211 hearing process. Local government should have a moderate threshold to cross before intervening into your process. Waiting until 36 months of no production is absolutely appropriate, and it's not especially onerous in our view. We've been there. Low producing status is a red herring in our view, and that proposal should be rejected on its face as a criteria for local government to intervene. Local land use planning criteria, as I've heard you all deliberate, and I've really heartened to hear your questions about why you would try to wade into that. And we agree that local land use planning criteria is not appropriate to shove into your rule. It's just going to have a bad unintended consequence. Also, local governments have and they should exercise all sorts of options before wading into your authority to manage inactive wells. So in summary, the COGCC and the operator, we believe, need a period of time to sort out if a well can be productive and useful before local government intervenes. 36 months is a blink of an eye to go through that sort of a process. WRLG concerns for economic impacts. We had a pre-filed testimony exhibit 2. I already spoke to that topic already. Now going on to our tier structure, the December 7th tier structure, we believe absolutely needs revamping. Again, I've really appreciated a lot of the creative thoughts and ideas that have been going on in discussions in the pleadings, but just a quick review of the staff draft. The tier 1, I'd call it the ultra exclusive and inequitable access to blanket bonding in quotes option. It unfairly penalizes and excludes nearly all natural gas producers, if not all of them, and over 90% of all operators. And it seems to exclude almost every financially strong operator that you would otherwise say, well, they're probably financially strong, they might qualify for that. So there's something wrong with the filtering. Tier 2, the do it to yourself before they do it to you option, or also the, I guess I'd say is the, we believe that it provides certainty, but it's going to do so at a crushing economic cost. It's strikingly punitive. Single well financial assurance, full cost bonding for most every financially strong operator as the default, who we believe should, by any reasonable measure, qualify for blanket bonding if they are financially strong, and a bunch of them are. So then there's the tier 3. I'll call that the sing for your supper, or a lot of people call it the choose your own adventure option. Almost every operator committed to not being bankrupted by the certainty that be provided by tier 2 would be compelled to absolutely develop a financial assurance plan and jump into tier 3 and look for commission approval. We think that that just shows that this is not a robust enough tier structure. The proposed tier structure from West Slope COGA, we believe, injects needed equal treatment of natural gas producers among other benefits. Tier 1 would be that same sing for your supper or choose your own adventure option, only now it's be placed in the first default position. All operators would be offered an opportunity to develop a financial assurance plan for commission consideration at hearing. This is fair to all, and you could absolutely reject it for operators who are not appropriately belong in that sort of a tier. The new tier 2 is a blanket bonding. I'll call it level 1. It has the most stringent qualifiers and lower blanket bonding amounts that would be required, and be lower than what I'm about to talk about as a new tier 3. It would require director approval, but she could always kick it over to the commission. And the thresholds are greater than 60 BOE, and I want to emphasize, it's barrels of oil equivalent. We've got to have the equivalents in there to make sure we're fair to natural gas operators and crude oil operators alike, and those who produce both. So greater than 60 BOE, or 30% of their wells are low producing, or especially if you're a gas operator, if you produce at least 90 MCFE and 25% of your wells are low producing, you could fall into that new tier 2 blanket bonding level. Tier 3, it's another blanket bonding level. I'll call it level 2. It's a little less stringent, but it still has stiff qualifying criteria and higher blanket bond amounts required than the above tier 2. It also requires director approval. The director could also kick it to the commission. Here's where this difference is the thresholds: 2 to 60 BOE instead of greater than 60 BOE. And also the or on that one would be 30 to 45% low producing. So it's a little more lenient on that. And then also if it's a gas operator, 10 to 90 MCFE or 25 to 45% low producing. And if they
Mr.
fall into that tier, they're going to have to bond up with some greater dollar amounts.
Mr. When you
Fair
have
enough.
gone past 8 minutes.
Okay, thank you very much. So then the tier 4 identifies circumstances when a conversation regarding financial assurance up to including single will financial assurance is appropriate, requires a commission hearing to approve that financial assurance plan. So that tier structure, I won't go into it. It's in my file. It's also what's file as far as the actual final red line text. This is just a clean version of it. And this is the tier 3 and 4 part that I just talked about as well. And it'll be available on PowerPoint that I'll be submitting to you. And the proposed blanket bonding for the new tier 2 for proposed West Slope COGA has these bonding amounts. Again, it's in our filings. And also my filing is for the new tier 3 that again has higher amounts for it. Financial assurance for new wells and transferred ownership. Just in short, we believe that new wells and wells that are transferred should trigger a discussion, not an automatic default single well financial assurance requirement. We also believe that you should limit parties withstanding at financial assurance hearings. We liked what we saw that the Oxy Noble PDC folks did that limited that to CPW, CDPHE, or relevant local government with respect to those locations. We also believe a cap is needed for the annual well registration fee. We think you're on the right track on that, hearing what we heard from Director Murphy and some others on that. Closing remarks, we really appreciate the opportunity to present. Wish we had a bit more time, but that's what I have for you today.
Okay. Thank you, Mr. Nguyen, for the presentation. I have a few questions and would like to get back to sort of the tiering slides, if you could. You talk almost as fast as Greg Dean, and you covered a lot and I didn't catch it all. So I want to give you a little bit of an opportunity to express what, and part of this is that one of your assumptions, one of your premises, and I get it, is that the tiers that are in the current draft are not workable for the West Slope and gas operators. So I want to hear about that because this is the first time we've had a chance to engage with the West Slope folks about this. Look forward to engaging with West Slope COGA on it as well. Hear about the concern, hear about the alternative that you and West Slope COGA think is more appropriate, or at least is more workable for the West Slope with regard to tiers.
Absolutely. I very much appreciate that. And really the point was in the staff draft, and I mean, it was a good effort, but it just lacked the kind of sensitivity and refinement to find and identify and group most financially sound, secure operators into the same grouping and then apply an opportunity for things, more beneficial things like a blanket bonding that's appropriate to them. So a lot of people are left out in the cold, and the natural gas operators absolutely are left out in the cold with the staff draft version. I don't think staff was trying to do that, but it just is because the tool wasn't shaped right. So what we've got here, it just makes sense, is this, what we have here is a new 2-tier blanket bonding level. Well, first off, I can start with that new tier 1, which is the old staff draft, exactly the staff draft tier 3. That's, sort of sing for your sumper, choose your own adventure. I mean, if an operator doesn't belong there, you're going to kick them out of there pretty quick. But if an operator wants to go that option, there's no reason not to let an operator give it a go, and you can accept it or reject it. But the tier 2 is really the core of it. Blanket bonding, I call it blanket bonding level 1. If a natural gas, and I'm talking about the natural gas piece to keep it concise. If an operator's, the wells are producing an average of 90 MCFE or more, or they're sort of, by a lot of people's measures, that not that many of their wells are low producing, say less than 25%. That's a pretty high threshold. We've got a lot of operators that have a lot of low producing wells, but we also have some here, and also in the far eastern Colorado, there's gas operators out there. Some of them will qualify for this. And if they otherwise demonstrate that they're financially sound and they're not constantly having a problem, this tiering also requires them to demonstrate for you what their plugging and their well plugging activity has been, what their 3-year plan is, what their retirement plans are. There's a lot more to it, and it's in the draft redline rules there. But we think that this is a fair way to let oil operator with a greater than 60 BOE or 30%, that's going to be more of the crude oil folks probably, and then the gas operators to have a ready, an identified access point. We can niggle all day long about whether 90 is the right number or 25% low producing is the right number. But I just think that this is a much more refined, much more flexible and simple to apply rule. So then for the new tier 3 blanket bonding level 2, again, it's really as simple as what I've got in green there. So you're an operator that has wells that are more mature, and so they're really producing less than 90 MCFE, but more than 10 MCFE, and you have a higher percentage of low producing wells. If you can otherwise show that you're responsible and that you've got a good financial plan, and there's just, the red flags aren't there for you, it gives the director an opportunity to approve that plan for some blanket bonding, or to kick it over to you to see if you want to give it a second look to make sure you're okay with it. I think over time, you'll have an opportunity to really realize and get comfort with it before you just put black and white, really restrictive criteria. You open these things up, you make your judgments on it, and you'll find out maybe in 4 years, the thresholds are a little bit different or the tiering are wrong, but this provides more equity that we think is absolutely critical if you're going to fairly create new rules across the state that's going to include all operators and the differences in operations.
You have numbers associated with your tier 4?
And the tier 4, I do. Let me pull that up. And again, that's where you would identify circumstances for a conversation. And let me see, I've got that. If an operator's per well average daily production is equal to or less than, if you're in that 2 to 10 MCFE, if you're less than 2 BOE or less than 10 MCFE, okay? So that's, everybody's saying that's somewhere in there, that 10 MCFE, talking about gas. That's, people are centering on, well, maybe that's a low producer, And so the idea is that an operator would at least have an opportunity to file financial assurance plan that meets the criteria of Rule 702D4. And concurrent with that, they will file an application for a hearing pursuant to 503G11. And so that's going to go, that tier 4 is going to you, the commission, not the director. And that's appropriate. But again, this gives these low producers that, you heard this stuff from like Own Resources and some others around Colorado. Their bread and butter is these low producing wells, and they've got these wells that are inactive, and their business plan, and I think Evergreen was that way too, especially maybe it's Evergreen. Their business plan is to have a bunch of wells that people have been sitting there stagnant, and they rework them, and they're making money off of them, and they're producing like this. So this is a place where these lower operators have figured out how to efficiently keep a lot of low producing wells going and not leave the state holding the bag, has a place where they can come up with a plan that's not the single well financial assurance. And it might be a blend of that, but it might be, again, it's something where they get an opportunity to try to come up with something.
Mr. Nguyen, getting back to the federal well issue, your county, Garfield, would anticipate has the most federal wells. You're asking to do nothing or at a minimum wait. Can you provide us some perspective on how the federal well bonding is working, not working, what you anticipate might change or not, since you've been involved in this for over a decade dealing with the BLM? Can you just provide us some perspective on that?
I want to make sure I understand the question. What I feel, what I'm thinking about, what's being proposed for applying to federal wells, or what I expect to see come out of the BLM process. I want to be clear.
It's kind of all the above.
Okay.
Right now, the staff draft does not apply to federal wells. We've heard from a lot of communities that we should apply things to federal wells. And then we've heard others say you should wait and see what the feds do. I'm just kind of an open-ended question. You dealt with the feds and federal wells and the interplay between state and federal wells for a long time.
Yep.
I wanted to hear you out on that.
Sure. No, I appreciate it. So again, I mean, in Garfield County, we've got a ton of federal wells. I don't know if we have more than anyone else, but we've got a lot. And a lot of our jurisdictions do. Those federal wells provide a mountain of revenue and otherwise resources for our special districts, our hospitals, et cetera. So that revenue we're looking at is extremely important to make sure that something doesn't happen that is otherwise unnecessary to cause that production to just disappear. So as an initial point, again, we believe that you can and should wait to see what the feds do and dovetail with that. You may not need to do anything. I mean, our position is you likely shouldn't have to do much, but I'm not going to sit here and tell you you're in the middle of rulemaking. Oh, you have a right to do something on federal law. So we'd ask that you at least hold off, and then consider if you need to add something or not. And then the 2020 IOGCC report. I mean, it showed that there's only 36 orphan wells on federal lands in Colorado. I mean, that's nothing. That's a minuscule problem. And I don't know if all 36 of those have landed in your lap or not yet, but maybe some of those are still in the Fed hands. We agree that the federal government should be responsible for financial assurance on the land. We look forward to participating in that rulemaking and making darn sure they have strong assurances. For one, why embolden or cause a reason for you to step into that federal domain? The double bonding issue, again, I think a lot of folks are just stridently saying, you just need to apply it just to make sure you have it. Well, for us, that's just kind of a double bonding. It's a wasted resource, even the annual well fees. I'm glad to hear that staff is recommending not to include federal wells, but we knew full well going in today that, and I've read all the pleadings, many parties think you just should load up heavy on federal wells. We think that that's just a false narrative and kind of a red herring. It's not necessary. Your staff stated plainly the orphan well liability to the state right now is minuscule. You're certainly making plans to make sure it stays that way, as you should. So and again, we think that a lot of folks are wrongly sort of insinuating or directly stating that the federal wells, they might become orphan to the feds, and somehow that if there's a problem with the federal well, it's going to immediately drop straight into your lap, and you have the financial responsibility. And I think we all know that there's a lengthy federal process that's going to go along to make sure the feds are going to have their crack at trying to hold people accountable, and they do make them accountable. We see it. I think you can hear some great testimony from Kara, some different folks talking about exactly that. So that's what we see, and we just see an important rulemaking from the feds coming.
Okay. I don't know that I've heard from others that they want to pile up on the Fed wells. Pitkin County's proposal seems like it's somewhat nuanced and tries to address the double bonding perspective. And there's a lot of folks that have gotten behind it. So I'll give you a shot at taking that one apart, or if you want to comment further.
Yeah, we just didn't agree with it. We just think is wrong-headed. I mean, they're trying to solve a problem that we think doesn't currently exist. They try to create some sort of refinement to it. But again, I'm sorry, it's just a lot of the same parties that are lining up behind that are the same ones that in any other venue next week, last year, different venues than here, they're not talking about thoughtfully managing oil and gas. They're talking about preventing oil and gas development. And so again, I guess I would just suggest you need to prove for yourself with hard data and not conjecture that there's a problem you need to solve right now, especially before the feds complete the rulemaking. So we'd ask that you hold off. We think the data shows that there's ample reasons you can hold off and not put the state at risk of liabilities.
Okay, fair. I read in your testimony and heard again today, you kind of led with the economic impacts, intended or unintended. How does this commission address that concern, given that that's not, I mean, if you go read the financial assurances section of Senate Bill 181, it doesn't really expressly or implicitly speak to economics.
It doesn't. It speaks to what reasonable and necessary, I believe, is.
Those words are used quite a bit. Mm-hmm.
Yeah, and so, and actually, I think I heard you asked somebody yesterday. I don't remember who you asked. Well, so what's the difference between reasonable and necessary and feasible, financially feasible, or some sort of whatever the rule used to be. Reasonable and necessary, I think that's pretty straightforward. Are you requiring? Let's just talk about in terms of the cost of compliance. Are you going to lay on to operators a cost to comply with financial assurance that's a reasonable level and that is necessary to without going overboard, protect the state's interests to avoid orphan wells overall, but also the state's financial liability to clean up those orphan wells. And so what we're asking for is that you, again, you've got 100 parties going for everything. And one approach would be, well, here's a middle ground. These guys want this, these want that. And, the middle is here. Well, maybe the middle is the wrong spot to land. All we're asking is that you thoughtfully choose and apply the provisions that are necessary to solve a known orphan well problem at a reasonably estimated cost of what the cost burden you need to make sure could be coming, and that it doesn't land on the state to have to cover it. And so we just think that there's so we're just asking you to be wise about that and not try to make everybody happy, but use the data and to please, if 60% of the parties demand something that's wasteful and is excessively exceeds the cost necessary to actually solve the problem, well, don't make 60% of people happy. Just pick the levels that will achieve what you need to achieve. And if you need to adjust that in 3 years, great. But as you know, you've got, 90 something million, $100 million of federal funds coming in that are going to do a lot. And 10 years is a long way from now. You have a long string of a large pot of federal funds that you have to back up. If you got it slightly wrong, you're not going to have a problem. You have so much money coming in from the feds and some of these other sources, I think.
Well, I will agree that I don't think we're going to make anybody happy or we're going to make everybody sad. It's the devil of the duty here. Appreciate your being with us. I think that concludes my questions for you. Look to my other fellow commissioners for questions. Commissioner Messner.
Thank you, Mr. Chair. I gave everyone else a chance first before I jumped in there. I just want to point that out. But, just a couple of questions. So I want to talk a little bit about the tier structure that's being proposed by Western Slope COGA, and I will ask them as well. So I understand that perhaps you may not be as knowledgeable as they are as they wrote this, but do you believe that there should be a qualifier to be able to be eligible for tier 1? Because my question is what I heard you say is that you're concerned that with the existing draft rules that all operators are going to just apply for tier 3 in the existing draft, or tier 4 in the existing draft, tier 3 in the existing draft. Although I see no changes in the language in this particular proposal that would indicate to me that it solves that problem. It still seems to me that the majority of the operators are going to just apply for tier 1.
So tier 1 is the choose your adventure, right? That's existing staff tier 3, right? That's what we're talking about.
That's correct. Because I think what I heard you say is your concern was with the existing draft is that everyone was just going to apply for tier 3 in the existing draft. In this draft, it just appears to me that everyone's just going to apply for tier 1 because it's the exact same thing.
I disagree. I disagree. And you're going to hear from the regulated community even more coming up, and you've already heard from some. And so you should listen to what they have to say about where they might land. That's a perfect question for them. But these new tier 2s and tier 3s, I think those will be used a lot. If you qualify for tier 2, that's you probably might come out better than if you were to try to wing something in tier 1, perhaps.
Oh, so your point is that you feel like the tier 2 and tier 3 options are appealing enough that some significant majority of the operators would choose to go into tier 3 or tier 3, so therefore tier 1 does not need a qualifier.
That's my belief and my understanding. Because the thing is, some operators are just going to want certainty. Certainty is tier 2 and tier 3. If they land there and they get that and they're done, the certainty, they don't have to spend all the resources to create a custom plan and all that sort of thing. And they're satisfied with it. It meets their constraints that they see for hitting this new tier 2 and tier 3 that have some good levels and refinement to them. But again, there are going to be a lot of operators. They're going to say, you know what, that tier 1, that's where I'm going. My primary point today on these tiers is that forcing all the operators to go to the staff draft tier 2, which is just, in my view, a dead on arrival. It's full cost single well financial assurance that so many operators absolutely are being relegated to that. They're financially sound and they're being relegated to that right along with those operators we've been hearing about that are neglecting things and are a financial problem. They shouldn't land as a default tier 2 single well financial assurance. This plan resolves that.
So who is the operator that would want the tier 1 plan in the Western Slope COGA proposal? Because right now we've got tier 2 being 60 BOE or 30% low producing or 90 MCFE and less than 25% producing, which is some significant portion of operators. Tier 3 has a lesser threshold. Tier 4 covers kind of low producing operators. So who is the operator that utilizes tier 1?
The operators of tier 1 are for sure going to be the operators that fail to qualify for 2 and 3. In addition, some operators that do qualify for tier 2 or 3 may, for unique reasons of their own that you're going to have to ask more operators that. There's going to be some that are just going to say, I know I qualify for 2 or 3, but it makes sense for me, and here's why. So I'm going to go for the tier 1 option. But everybody who doesn't qualify for 2 or 3 is going to take a hard look at tier 1. Because
I guess I still struggle a little bit, because the only ones that don't qualify in this proposal for tier 2 or tier 3 is if you have 2 BOE or less and or 10 MCFE or less. As the only people that don't qualify for tier 2 or tier 3, unless I'm reading it incorrectly.
You're not BOE, but I'm talking again. The issue that I'm mostly trying to crack the nut on is this inequity to the natural gas producers, the stuff in green. So you can talk to some of the Eastern, and you've got them coming up. So Eastern Colorado, 2 BOE oil producers, not gas producers, and ask them about that. But this 10 to 90 in that 3, I think that's an important distinction, because it covers if you're a crude oil operator on the left of my slide, and if you're a natural gas primarily operator on the right side. And those natural gas operators, the inequity problem was that a lot of these natural gas operators, they co-produce condensate, oil, and things, and they were not getting credit for that minority produced stuff the way the staff draft was drafted. But this largely, I think, addresses some of that.
Okay, I'll ask. I mean, I wasn't, I guess my question wasn't the difference between the two, or I don't have any issue with differentiating the two. My question was more, it seems like blanket bonding level 1, blanket bonding level 2 covers every operator in the state except for operators that are either 10 MCFE or less or 2 BOE or less. But then tier 4 already covers those. So it seems like tier 2, tier 3, tier 4 covers 100% of operators. And so that was just the question, is who's utilizing tier 1. But I'll ask other operators and try to get to the bottom of that one.
Very good. I appreciate the question. I really do.
So I guess the only other question that I've got is, I think I heard you say, but I just want to confirm it, that with the 211 hearings, you're comfortable with local governments being able to have the opportunity to request a hearing. You're comfortable with the utilization of used and useful as a determining criteria. But you want to see it maintained at 3 years. That's the main catch there, is that it's the timing of it.
It is. That 12-month proposal doesn't make any sense. I mean, we've seen enough over here. We see what operators do when they temporarily abandon a well and they're trying to figure out what they're going to do. They might figure out that actually it would be economic injection well. They might figure out that they in fact can produce gas or oil from it. And it takes some finagling and it takes some time. It takes your staff time to work with them and to work through some options. 12 months is just nothing. 36 months is really not much. I think I don't know if it was one of the industry folks, was it COGA said, 7 years or something. We're good with the 36 months. Our bottom line is that local governments mostly shouldn't be in this realm. You guys are the downhole folks. You're the experts on the downhole. And we support you guys doing that, and local governments interfering when it is just a glaring and probably extremely rare problem. Y'all are more than capable of sniffing out if an operator is fiddling around instead of trying to figure out if a well is going to be economic in the future or not. And we should let you do that. And the key thing there is this low producing status. I mean, that's the most egregious proposal of all. That's got nothing to do with this, and the local government should be looking at it. For the same reason we're talking about those tiers and things. There's people producing less than 2 BOE. I don't know how they're making money on it, but it's their business model and they're doing it. The local government shouldn't be able to go in there and just try to stomp on that and go, well, it's low producing, so well, let's see if we can just.
So you're not okay with low producing 3 years?
No, not at all. 3 years. Low producing is a red herring, and that shouldn't be a criteria at all. The land use planning criteria as posed by some is, we believe, completely inappropriate and places y'all in a precarious position.
So now I'm confused, because I think my understanding of what you said is that you were okay with the 211 hearing being utilized by local governments as long as there was a 3-year timeline associated with it. And I think that's what you said, that you're okay with that.
No production. Commissioner, I'm sorry.
You want to know production
of zero production,
okay,
as written. We support the staff draft as written. No production, not 36 months of low production, 36 months of no production.
Okay, that's where I misunderstood you.
As drafted by we absolutely support the staff draft on that.
Okay. Those are the only questions I've got. Thank you.
Thank you for clarifying that. I would hate to be confused that issue.
Commissioner McGowan, Commissioner Gonzalez, any questions? All right, and just on that last point, Mr. Nguyen, I mean, I understand that you're speaking from the perspective of the communities you represent, but if it was a 3-year, or if it was a 1-year no production or low production, that's just discretionary to each local government. I mean, it wouldn't require any of your communities to ask for a hearing after a year. In fact, it's discretionary all in. You don't even have to ask hearings, right? Or am I missing something?
This is true. But again, who's going to pay those taxes that are lost by all the special districts? There's a lot more impact than just to that local government's issue. The local government shouldn't be able to absolutely drive it in a vacuum, say, well, because we're worried about being low producing, we demand that we really think you should just force them to plug and abandon it. Then you leave 14 special districts with 200 wells maybe that were producing great income for them. That is in a lot of the special districts out in rural Colorado, not just Western, but Eastern, 90% of the funding that pays for these special services and libraries and hospitals and emergency services, it comes from a lot of these these oil and gas wells, and a lot of it's low producing. So there's unintended consequences. It just doesn't make sense. Y'all are more than capable as a staff and a commission to hold the keys by and large on whether a low producing well is in fact not an economic well, and it has problems that you should force them to plug and abandon it. We think that's your downhole role. We just don't think we belong there, and there's economic consequences to people that the individual relevant local government may not care about or may not appreciate.
Very good. Well, listen, I think the commissioners appreciate the perspective that you bring from the rural parts of our state that are important for us in our consideration. of finding the appropriate balance for financial assurances. We teed you up, and we've got some of the folks that are operators from your communities that are going to go next. So, and then we'll hear from West Slope COA. So again, I sort of like the way we've got this teed up so that we can hear from like-minded parties at similar times and advance the discussion. And so I want to thank you. You did a good job of kicking off this part of the hearing for us.
Thank you. I really appreciate the opportunity. I'm sorry that I'm leaving you just when the sunlight comes to the window, just made me look pretty instead of glaring.
Excellent. I will
Thank
look
you.
forward to your closing with the time that you have left. Thank you very much.
Okay.
Commissioners, just checking in procedurally, we are going to try to accommodate Harris, Evergreen, and Kinder Morgan in the remaining part of the afternoon. If we do that, we will likely go past 5, and I'm trying to figure out if we have hard stops that I need to be aware of. Everybody okay? Okay. So that is going to be Karis is 7, Evergreen is 3, and then Kinder Morgan is 2, irrespective of questions. So with that, hearings manager Amaro, if we could bring Karis to the panel.
Yes, Mr. Chair.
Good afternoon, commissioners. Let me just pull up my screen real quick.
Ms. Hill, do we need to find anybody else, or are you going to be presenting?
Just me. And I do want to say that if I have any extra time left over, I'd like to cede that to West Slope COGA.
Okay. Not reserved for rebuttal, but if you have time, we'll attribute it over to West Slope COGA.
Yes, please.
Okay. Ms. Hearings Manager Amaro, if you can make a note of that, that would be great.
Yes, Mr. Chair.
Okay, 1 more second, trying to figure out the screens here. Okay, hopefully you can see my screen.
We can.
Okay, great. Good afternoon. I'm Holly Hill. I'm the regulatory manager for CARES. We greatly appreciate being here today to talk through these financial hearing rules. We would first like to start off by thanking the director for her recommendation to reduce the annual well registration fee to $20. We support this. Today, I would like to go further into current bonding on federal lands and the upcoming federal rulemakings, and then finally discuss our request for an exemption of federal wells from the annual well registration fee. So here's a timeline of federal bonding and policies currently in effect. I'm going to walk through them pretty quickly and then hit some components further on. So in 1988, bond obligations were established for leases, units, and operations on federal lands. About 10 years later, the rule that really is the rule for the federal government right now established criteria for what bonds could cover and gave the BLM the authority to hold all interest owners in a lease jointly and severally liable. So this is where they can work through the chain of title to find an operator to plug orphaned wells. In 2001, additional financial guarantees were established, and they put together prescriptive requirements for reclamation cost estimates for projects on federal lands. Operators have to submit these and gain approval from the BLM before commencing construction. In 2009, an instruction memorandum was issued, which established prescriptive guidelines for when the BLM and how the BLM could approve reclamation costs. And these became these spreadsheets that go into each sort of component project on federal lands. In 2013, there was an instruction memorandum that established 6 points of criteria for determining bond adequacy and potential risks posed by operators. And finally, there's a memo, it's an instruction memorandum 2019-014, which is going to supersede this 2013 IM. And it increased and modified the criteria where BLM could reach out to operators and request more bonding. So the 2009-153 IM goes into the reclamation cost estimates that are required from operators for projects. And this is the maximum cost of reclamation for the greatest area of proposed disturbance. And basically an operator has to put these costs together as though the BLM were going to hire a third-party contractor to take over all of the reclamation. Included in these costs are costs for plugging wells, capping, and potentially plugging any monitoring wells of any sort. The 2013-151 IM gave the BLM some authority to review bonding for operators. And these are the criteria listed here. You'll note the operator, number 3, when an operator submits an APD and BLM does not think they have adequate bonding, they can request additional bonding at this juncture. The 2019-014 IM that supersedes the previous one brought in a lot more criteria here for when the BLM can request additional bonding. And I've highlighted the components that were modified or added. So you'll notice that they have established a criteria for if an idle well has been out there longer than 5 years. Again, if there's an operator has submitted an APD and the BLM has not reviewed that bond adequacy, they can request additional bonding. And I think very interestingly, they have a criteria number 10 that if an operator's production is exceeding a certain threshold, they will review your bond to reduce it. So CARES has recently increased additional bonding on our statewide bond for Colorado. And this was as a condition of approval that was added on our APDs that we had to come into compliance with criteria 6 under the 2019-014 IM. These are the costs that CARES secured recently for our federal wells that are upcoming. And as you can see, they vary. The costs are probably most indicative of cut and fill on a pad, possibly including an access road or a pipeline. So it doesn't dissect down to a per well basis or a per acreage basis. There's several components that go into determining what that appropriate cost would be. All of our future development planning so far will occur on federal lands, and we do expect that we will have to come into compliance with this bonding. That being said, as you've heard, there is upcoming federal policy and rulemakings. There was an instruction memorandum released in 2020 that did state that the BLM does plan to issue guidance on orphan wells in the future. And then in the Office of Management and Budget agenda that was released in December of 2021, the BLM announced that it does have plans to initiate a rulemaking in May of 2022 to address rental fees, royalties, and bonding requirements on federal lands. We expect that there will be a 60-day public comment period that will conclude in July of 2022, and then we would expect the rule to be in effect by year end. This is, of course, our best guesses at this time. So there is federal regulation and jurisdiction over bonding and federal wells. Finally, based on all of these criteria, CARES is requesting that the commission exempt federal wells from the annual well registration fees. The BLM has a very robust process to come after operators in the chain of title, and we have bonding placed for any future development on federal lands. So we believe that the orphan well program for federal wells should be left to the federal government and the operators in the chain of title. That concludes my presentation.
Very much, Ms. Hill. We appreciate your being with us and presenting. This time we have an opportunity for questions. I have a few, but I'm not going to go first. Who would like to go first? Commissioner Messner.
Thank you, Mr. Chair. Thank you, Ms. Hill, for the presentation. And I appreciate the overview of your experiences with the bonding on federal lands and kind of an overview of the bonding requirements that you've had to deal with. Just one clarification to your presentation, just to make sure I understand. I think you had indicated that you're anticipating having to come into compliance with kind of the bonding amounts that you had indicated. but not, so you're not required to as far as the 2019 rule, or is that gray, or kind of maybe explain that a little further?
Sure. Sorry if it was unclear. All of our future development planning will occur on federal lands. So we expect to have to secure more bonding for those federal well pads. So we
Like
expect to
that.
see, yeah.
Okay, that makes sense to me. So I guess in light of that, and understanding that there are currently, and one can fairly anticipate that there will be continued federal financial assurance requirements on federal land. I guess I still struggle to understand the heartburn around having language in our rules that would require some sort of showing of substantially equivalent or substantially similar financial assurances, because at least in the testimony that I've heard from operators on federal lands, I think the general testimony is, hey, federal government's already got us at least what you're anticipating to ask for in financial assurance. So I guess what I'm still trying to understand just what the heartburn is there, as far as, requiring some sort of showing of substantially equivalent, and should there be a gap, closing that gap. But it doesn't sound like there would be any kind of significant gap, although I guess we don't know that yet because we haven't finished our financial assurance rulemaking. So I appreciate that, but maybe talk me through that one a little bit.
Sure. So, and I think maybe what you're referring to is the Pitkin County language that was introduced. And where we have heartburn is it's not a simple subtraction and addition equation right now, because as I understand, Pitkin County proposed that it would be on a per well basis, that you'd kind of subtract or add or figure out what the remainder amounts would be. And with the reclamation cost estimates that you submit to BLM, they're project-based. So it could be on a giant master development plan or a well pad that has an access road and a pipeline. So you're pulling in all of these components. So the costs just don't equate. And that's really where our heartburn is. West Slope COGA and those of us who belong to West Slope COGA have been working on some language or possible ideas on that. So I think I'll defer to Ms. Gutierrez when she presents on that.
Okay. Do you feel like that should there be language that didn't necessarily specify dollar to dollar, but had a substantially similar or substantially equivalent standard, that may lessen your heartburn?
I think I kind of still get stuck on that substantially similar. I think that's kind of where we'd need to figure out what that looks like. It's not, like I said, just a simple equation. There's a lot that goes into that.
Okay, fair enough. That's my primary question. So thank you.
Yes.
Other questions for this witness? So Ms. Hill, you spoke a little bit about the Pitkin proposal, and you said it's not easy math that you're looking at it project wise. I'm not saying I'm going here, but if we were to have that language, is there a route to compliance? Or would you suggest that that's difficult? I guess I'm trying to figure out what that would mean.
So you're saying is to kind of fold in the federal bonding so that operators basically get credit for that.
Yeah.
And or maybe have to come to the table with more bonding. I think there is a way. I think as West Slope operators, we're contemplating that right now. And I think Ms. Gutierrez is probably going to have something to show for when she comes up to present.
Okay, I'll reserve that question for Ms. Gutierrez. Did you have any, this is completely out of left field using Commissioner Gonzalez's parlance, but did you have any thoughts about the Dr. Allward matrix yesterday for computing single well assurances?
I missed that part of the presentation, so I'd have to go back and look at that. I don't know if I'm prepared to respond to that. I know that in the single well financial assurance, we had proposed maybe some different cost structures and on a per acre basis in that definition.
And then finally, and again, this is not foreshadowing what I'm thinking because I really don't know what I'm thinking on the federal well piece, but another approach would be to acknowledge that we want to address the federal well piece and that 181, is applicable across the state, but to put into the statement of basis and purpose, just sort of language that it would be, it's not a prudent idea to try to address that issue now. We should wait and see what BLM does and then potentially revisit. What are your thoughts about that?
I think Karis would absolutely support that notion. I think revisiting the federal well rulemaking, or the orphan well and financial assurance rulemaking is worthwhile. I think we're going to see a lot that comes out of there that could really impact operators' financial assurance plans that they would have already submitted to COGCC. So we would very much support language in the SBAP.
Okay. Thank you very much for participating with us this afternoon. I generated some more questions. Hold on. We got Commissioner Messner and then Commissioner Nanjapa.
Thank you, Mr. Chair. Just one question, because I forgot the well registration fee. I mean, irregardless of whether there's a fixed dollar amount or whether there's a fixed total amount associated, in the account. Let's say that just for argument's sake, that there's a required $10 million annually to go in the account. Should we exempt wells that are on the federal land and still need to get to 10 million? I mean, do you acknowledge the potential issue of having to charge more for private wells in order to get to that 10 million? And so there's potentially a no net gain to Karis?
So first, our well count right now, currently as it exists, is heavily fee. The future production that we'll bring on is federal. So we would be paying into our fair share for that account. And I think second, we're getting a lot of money from the federal government for our plugging program. So I think we're going to be utilizing some of those funds. I don't necessarily look at it as we would basically be getting kind of a free ride. I look at it more as a principle. I think BLM should be responsible for finding the negligent operators to plug those orphan wells. I think that should be left to their jurisdiction because they do have that unique right to reach through that chain of title.
Yeah, and I wasn't suggesting that you were trying to look for a free ride.
Sure.
Don't assume that. I think I'm just acknowledging that depending on how Orphan Well Fund gets addressed, and should it be a fee on wells with the goal of developing $10 million annually in there, separate from the federal funding, that if you exempted federal wells, that could mean that those without federal wells would have to pay more than $200 per well in order to be able to ultimately get to that $10 million. And so what's the impact of that, I guess?
I'd probably have to kind of take a comprehensive look of all of the wells in the state. I really feel like this is probably a very limited situation with the federal wells being mostly in the Northwest and Southwest portions of the state. So I can't really answer that, I suppose, but I do support a $10 million cap. And I do think we would be paying into our proportionate share with our fee well count, which is significantly high.
Okay. I appreciate that. Thank you.
My question was answered. Thank you very much.
Any further questions? All right, seeing none. Again, Ms. Hill, thank you very much for you and your company being with us and providing the perspective on the West Slope. As I mentioned, this is sort of the West Slope part of our hearing process, and it's important to hear from you folks, from the operators out there. So thank you very much.
Thank you.
If you had any time remaining, we will make sure that it's seated over to West Slope COGA.
Thank you very much.
Okay, where's my cheat sheet? We now are bringing on board Evergreen Resources, I believe.
Yes, can you hear me?
We can.
Perfect. Now let me get this going. Hello, how are you guys?
We're great.
Good. Good to see you all again. Thanks for having us. Let's get. I guess, can you see that in presentation mode? No,
It's not in presentation mode, but we can see it.
let's try. Then
Cute dogs.
oh, shoot. Okay. It's not that one.
I bet the little fluffy one beats up on the other one.
That's mine. Yeah, she's a quirky thing. Let's see. It always goes back. All right. Is that presentation?
There you go.
Well, I'm glad you guys enjoyed those pictures of my dogs. All right. You guys let me know when.
You are ready to go.
Cool. So first, thank you all for allowing us to be here today. Evergreen Natural Resources, LLC, is a pure methane gas capture company, as you guys know, based out of Los Animas County, Colorado. My executive team, I'm joined here by Mark Sexton, and my field team believe in the importance and necessity of a fair and equitable financial assurance program. We do have 5 things to discuss with you today in a short amount of time, so we will get going. 1, we were notified of a typo in the definition of a low producing well in the red line draft after the pre-hearing statement deadlines. This typo or the changes more than triple our low producing wells in ENR operations, or the wells that are considered low producing. Therefore, ENR recommends that the low producing well standard for natural gas wells be defined as 6 MCF per day over the previous 365 days. Point number 2 is that the proposed
You need to advance your screen.
Oh, thank you. I can't do it all at once. Thanks, Mark. Okay, there's that. And we can come back to that. Point number 2 is that the proposed regulation 702C1 states that to qualify for tier 1, an operator must produce a per well average daily production volume that exceeds 60 BOE, the equivalent of 360 MCF per day of gas production. In the past 2 decades, the average daily production from now ENR producing wells in the Raton Basin has not exceeded even 220 MCF per day, let alone 360. Evergreen requests that this rule be amended to a daily volume more representative of today's active operators in the state of 5 barrels of oil or liquids or 15 MCF of gas per day. Alternatively, we request a minimum threshold production volume by operator of 20 million cubic feet of gas per day total sales. Point number 3 is that our inactive low producing wells are an opportunity for a coal bed methane producer. In 3 years, Evergreen has moved 29 wells that were left in a quote inactive and low producing status, or what you guys would deem that today, for up to 13.6 years prior to us getting them back online and back to a producing status. Those wells are capturing over 1.5 million cubic feet of pure methane gas today. These wells were never considered a burden or threat to the state, the county, or the landowners, but rather an opportunity to be reworked by a new operator, Evergreen, with a new vision to gain landowner revenue, severance taxes, and freshwater byproduct. We have landowners repeatedly requesting that we rework existing wells on their properties. Number 4, the application for our methane capture operations is entirely different than other gas operators in the state. We produce gas that can be used in your house tomorrow. We produce water that can be used year-round by wildlife and livestock. Through our methane capture program, we, as a company, have reduced naturally occurring methane emissions to the atmosphere by 97% in the Raton Basin since 2001. And point 5, my last point, is that nearly 100% of Evergreen employees are Colorado or Raton Basin residents who care immensely about where we work, live, and play. We are local, 70% of our employees are minorities, and we are the largest tax-paying employer in Los Animas County. Evergreen and its employees urge the commission to view Evergreen's methane capture operations as a partnership where we work to meet Colorado's goals of reducing greenhouse gas emissions together. Thank you for the time.
Unmuted. Thank you for the presentation and presenting
Thank you.
to us and being with us. We appreciate getting all of the perspectives from the various operators. And you are somewhat unique, and so we appreciate hearing from you. Do commissioners have questions? Commissioner Gonzalez.
Thanks, Chair, and thank you, Ms. Smith, for your presentation. I've got a question about the low producing well threshold that you're suggesting. Are you suggesting two different definitions for natural gas wells and for oil wells? Or are you suggesting that the single definition include this threshold for natural gas wells at 6 MCF equivalent?
So first, thank you for the question. We are recommending that initially, as shown here on the screen, we had seen in the red line definitions that it was 10 MCF per well in 365 days. That was corrected. That statement was corrected after pre-hearing statements were due. So this was not addressed in our pre-hearing statement. This is our chance now to address to you that if we had known that prior, we would like to adjust that volume to 6 MCF per day per well, rather than 10 MCF per day per well.
Okay, so just adjust the gas component, the gas measurement component of that definition.
Sorry, say that again.
Just to use, so you're just suggesting that we amend the gas measurement component of that definition.
Yes, I do not feel comfortable speaking on oil, as that's not what we produce.
Fair enough. Thank you.
Thank you.
Questions from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. And thank you for presenting this list so late in the day. It's very appreciated.
Oh yeah, thanks for having me.
So I'm trying to, I cannot find in my notes, so I know I'm going to mess this up. I think I read in your statement that you, that the average production in the Raton Basin is 45 MCF.
Yes.
No. Yes.
Yes.
Okay.
So
45 NCF, and yet I felt like what you were asking for as part of a consideration for a low producing well was significantly less than the 45. And so I'm wondering if you could walk me through. I think that's what I saw. I cannot find it in my notes. I want to hit myself, but so could you kind of walk through that and explain that a little bit for me?
yes, absolutely. So initially, again, in our pre-hearing statement, we did not make amendments to the definition of low producing wells. What we did amend was in congruency with OWN resources, or OWN, in line with their 5 barrels of oil or 6 MCF per day. What we've done now with this second look at it, if you will, with the change in definition, is say that we would prefer that 6 MCF be applied to the low producing well definition. And we've upped, as you can see here, the requirement for tier 1 status, which I believe is what you're referencing, to 15 MCF per day of gas production. Yes, it is significantly lower than 40 MCF per day, which is what we're doing currently. However, it's more representative of what a responsible operator in the state can afford to produce at and still be considered financially stable.
In a coal bed methane type play.
Thank you.
Yeah. And this is where we start to realize that there's some very individual kind of circumstances all across the state. And so I think for me, the discussion, if we're going to stick with tiers, right? And in this instance, tier 1 is, I assume that you're not talking about tier 1 as an individual financial assurance plan, but a tier 1 that automatically provides blanket assurance, or no? I can't remember. I apologize.
Yes.
Which one?
The blanket assurance.
Okay, so meaning I think the way that it was originally drafted and Director Murphy and staff's thought was tier 1 is an operator that's doing really well, good financial health, good well health. So again, I'm trying to figure out if the average that you all are producing is 45, but tier 1 is set at 15, it seems like a pretty big discrepancy for me. So I'm hoping that maybe I'm missing something and you can connect the dots for me.
So what we've done is, because we have a multiplier of 2 BOE in the low producing well, to hopefully change it to 6 MCF per day, that's a multiplier of 3. Since we're not sticking with the BOE equivalents of 6 MCF per barrel of oil, we went down and we used that same multiplication factor of 5 barrels of oil or liquids to 15 MCF per day.
I think in answer to the commissioner's question specifically about financial stability in reference to financial assurance, we were simply showing a graph that says, the average well was never more on average than 220 or so MCF a day, and the current production on a couple thousand wells is 45 MCF a day, and it's a very stable, it's a very viable plan. And in our opinion, we could go down as low as 15 million a day and still have that same financial stability, 15 million or 15 MCF a day, pardon me, and still be a qualified tier 1 operator. And then we threw in and if the individual well issue gives people heartburn, or simply, it's not been really suggested or talked about, we're simply proposing put a minimum total gas sales threshold out there. And while somewhat arbitrary, we thought almost any operator could demonstrate financial assurance and viability with at least 20 million cubic feet a day of total gas sales. Did that answer your question, Commissioner?
I think so. So I wonder, I'm talking about the individual financial assurance plan, and what you all might think might be some good parameters or guardrails around what you would have to show as an operator to put yourself into presenting an individualized financial assurance plans, and what things might kick you out of that situation where we force you into a blanket situation or a single well financial assurance. And so it's a question I've been asking a lot of folks, and I would like your input as well.
Yeah, no, absolutely. Thank you. So first, I would like to start off by saying that we are, as I mentioned, wholly different than normal gas operators. Myself as an engineer, having worked in several other states and basins, this is unlike anything I've ever seen. So it needs to be taken into account that because what we're doing is reducing methane emissions to that would naturally be going to the atmosphere, we can't be considered, yes, we are a gas producer, but we are a methane capture company. More importantly, we every single day are reducing the potential emissions to the atmosphere. And so when you look at that, again, it's going to have different qualifications that meet, what is considered tier 1, tier 2, tier 3. But some of the things that have been mentioned today that I personally support are things like advanced AVO programs, methane leak detection programs. Methane is what we work with every single day. We have vast knowledge in technologies like that, where we would be happy to help you guys and inform you more so on what those technologies do and how helpful they are. But daily operations, I think, in my mind, is what can help us determine, or you all determine, what makes a more financially stable company than another. How involved their employees are, how involved their upper management is, track records for COGCC, write-ups, stuff like that.
Thank you. And you just triggered a question for me, which is, there has been some discussion today about whether or not AVO is actually a really very meaningful way to test a well that's, inactive. Sorry, hold on one second.
I get it. I'm lucky that's not.
It might just be a little barking. So under Reg 7, which is for an inactive well or an idle well, whatever definition we're going to use, it sounds like there's already a requirement for operators to do kind of LDAR or some type of testing that way. Are you comfortable with submitting whatever the results of that are instead of an AVO, an annual AVO, just sharing that information so that our staff kind of knows what condition those wells might be in?
Yeah, absolutely. So I'm actually working on pulling it up here. We have, since Evergreen took over in 2018 of this asset, we have had an extensive LDAR and FLIR program in place. that the previous operator actually initiated and we kept up with. It involves annual leak detection at locations, quarterly at compressor stations, disposal sites, AVOs monthly. So yes, absolutely. We're more than happy to kind of, I guess, as you said, submit to you all kind of what that program has looked like for us and how it's helped shape our daily operations for our not only lease operators, but our regulatory team as well.
If it helps, please consider us a beta test site for these type of programs, how one is actually working and how one could be put in place in other areas.
We're actually considering like the use of drones with LDAR detection and FLIR detection as well right now. So.
Okay, thank you so much.
Questions from commissioners for the panel? Commissioner Messner.
Thank you, Mr. Chair. Thank you, Ms. Smith and Mr. Sexton for being here with us after hours. Just a quick questions because I'm just trying to understand a few different things here. There have been some proposals that would indicate that an operator may be able to qualify for a tier 1 or a tier 1 blanket bonding mechanism should their wells be should less than 25% of their wells, if they are gas producers, be low producing. Understanding, I think what I'm hearing you say is that your average daily production is 40 MCF, could get as low as 15 MCF. I assume that less than 25% of your wells would be classified low producing. Is that correct?
Barely. That is, we are at 24% the way that the regulation reads right now.
With your suggestion, if should it be dropped to 6?
Yes, sir.
What does that do?
19%.
Okay. And so that means that you must have quite a few that are significantly higher producing in order to be able to average out in that 40 some MCF range. Is that right? So some that are quite a bit up here and then some that are quite a bit lower.
Yeah, we have two factors that play into that. This is an old field. And some wells were drilled as early as the 70s. The other part that's playing into that, which is really helping our average MCF per day increase, is our reoptimization program. This right here showing this dive, if you will, every time this dives, it was the last time a well produced according to the COGCC website, at which point it was either deemed shut in or TA status by the previous operator. In 2018, Evergreen took over, and this is how quickly we've been able to get those 29 wells back online, not only producing, but taken off both the inactive, if it was in effect today, the inactive and low producing list.
Yeah, I was just trying to understand just the operations and how low producing and averages play with your operation. So I appreciate that. That answers my question. Thanks.
Yes. I believe that yes.
Man, my computer's telling me I'm muted. Other final questions? Commissioner Najapa.
Thank you, Mr. Chair, and thank you both, Ms. Smith and Mr. Sexton, for your testimony. I just had a quick question on the same slide. Given the success of your reoptimization of these wells, what's your projected lifetime for these wells that were initially labeled lower producing?
So
or would have been.
Right. It had the regulations, as they are today. So our economics calculate at least out 50 years for each individual well. That being said, we had to date, we're on well 100 today. We started the program at the end of 2019, and there's over 1,000 wells that have this potential. Maybe they're not all on the low producing inactive list today, but, without any intervention, they eventually will be. Obviously, their time on that list would hopefully be shorter because they wouldn't deal with changing operators and such. But that being said, once those 1,000 wells are done, then come the next 1,000 wells. We have huge plans for 2022 as far as our reoptimization program and getting wells done. And we've worked with COGCC staff. Every time we have to file a continued TA status form, it's with the assumption that, look, we have plans for these wells, and this shows that. So
The macro answer to the question, though, is at the current rate at which we're gearing up, we're going to have another 10 years of just reworking the existing 1,000 wells, and then another 10 years to rework another 1,000 wells after that. This field life, because of our rework and reoptimization program, will be going on for another 40 years.
Okay, thank you. Those answered my follow-up questions about, the status of the other wells. And so given that, and give it, just based on your graph here, that it was, quite a major spike up in production, what's the sort of decline curve? Like, when would it get down to that? Was it 6 MCF that you were suggesting for the low producing, or am I conflating that with the other?
Mac, would you put the field-wide decline average curve back up?
Okay, I'm sorry.
You can see that the field is on roughly a 7-8% annual decline from where it's at right now if we do nothing.
Okay, yeah. So my question, though, is if you rework all of these wells, as you were just discussing, how quickly does that field decline to that low producing level that you were, I think, I'm trying to remember now if you said, that the 15 MCF was for the tier 1 for the blanket qualification, but the 6 MCF was for the low producing, correct? So given, this initial spike in production with the reworking, and knowing that there's at least 40 more years or so, do you have a sense of approximately when you get around that low producing level?
Yeah, well, if we did nothing, you could simply continue to decline the average, as you see on this curve, and see when you get there. And it's still more than 10 years out in this case. The wells that come on have a different kind of profile. If you to answer your question, and I'm going to get into the weeds just a little bit, but I'll try to oversimplify it as much as I can. The wells that if you open up existing pay and just make it better, you'll get more production, and it'll immediately be on the mature decline profile. If you get up into opening up new coal that is interbedded in the existing coals, because we're going after, with more precise techniques, we're going after recompleting coals that are interbedded inside the existing coal seams. We're actually seeing, in many cases, an uptick where the production inclines for about a year to get to peak rates, and it appears to be, according to our model, will level off for about 3 years and then go into that mature decline phase again. So if that peak rate is, and I'm just doing this off the top of my head, the engineers will hate me for winging it this way, but I'm just trying to give you a feel for the answer to your question. The new well coming on would peak at about 100 MCF a day and then start declining. So, that well, in order to get down to 6 MCF a day, is, going to be producing for another 30 years.
Okay. All right. Thank you very much. I appreciate it.
Thank you for the question.
Further questions? All right, seeing none, thank you both for being with us and bearing with us late. We appreciate it.
Thank you, Mr. Chairman.
It's our pleasure. Thank you, guys.
Thank you,
Good
Commissioner.
luck.
All right, I think we have one more party, Kinder Morgan, and they have a couple of minutes to present to us this evening.
Nice dogs.
I bet.
Good evening, commissioners. Can you hear me?
Yes.
Great. And do we have Mike Hannigan in with us as well? I think he's maybe just joining.
I don't see him yet, but
Okay.
let's give it a sec. There he is.
Oh, there he is. Okay, let me screen share while we work that. Okay. Is everybody able to see my screen as well?
Yes.
Oh, okay. Now we've got the picture bubbles are in front of my notes here. Get this over. Okay. Good afternoon, I should say evening, prepared for afternoon, commissioners, staff, and other parties. My name is Ana Gutierrez with Hogan Levels, and I'm here on behalf of Kinder Morgan CO2 Company. I have with me Mr. Michael Hannigan. He's the EHS supervisor for Kinder Morgan CO2. We will be very brief in our presentation, addressing just one particular issue that's unique to Kinder Morgan as a carbon dioxide producer. For quick context, and as you know, Kinder Morgan CO2 operates CO2 source fields in southwestern Colorado and is a leader in the production of that product. Kinder Morgan CO2 supports a reasonable tier structure. It is important, however, that any tier criteria include MCFE thresholds. As it impacts Kinder Morgan CO2, there are two primary reasons for this. First, the product that Kinder Morgan produces is gas. It's measured in MCFE and not BOE. Second, CO2 does not have a BTU content, and therefore BOE, barrels of oil per day, can't be readily calculated based on BTU of gas. That was the earlier suggestion from staff that has since been pulled from the SBP language, but now we're at a state where the rule is silent on conversion from BOE to MCFE, and this question, frankly, is just too important to leave for post-rulemaking discussions. To resolve the concern, Kinder Morgan CO2 respectfully requests that the commission include reasonable MCFE thresholds as tier criterion. The company does adopt and incorporate by reference the proposals from West Slope COGA. And this is one just brief topic. We advocate for a tier whereby one could come before the commissioners unilaterally for individual conversation. We've had discussions about that. And then I will just conclude my testimony as we've ceded the remainder of our time to West Slope COGA. I do just want to state for the record that other parties have misrepresented Kinder Morgan CO2's prior proposals regarding the EPA criteria. So if the commission would be so inclined, I would be happy to answer questions on that particular point. Thank you.
Thank you. So I'll ask the question. Talk to us about the mischaracterization.
Sure. So several of the parties suggested Kinder Morgan proposed the EPA criteria from the UIC well program as criteria for tier 1. That is not where that particular set of criteria came into play. I think Ms. Ryan correctly described where we presented that, which, as many drafts as we've come through, it feels like 2 years ago, but this was in response to the original draft in our pre-hearing statement where staff had proposed 1, 2, 3 tiers, and then a tier 4 that said, if you think you fall into tier 1, 2, or 3, but you, by these criteria, don't get in there, tier 4 would allow you to do that. And staff had left sort of a discussion point of what would the criteria be to show that you may qualify for the tier 1 and tier 2, and then you'd fall into that blanket bonding structure. So we had proposed one component you could look at as some of those criteria presented earlier, and that EPA has looked at regarding Moody's ratings and different liability structures. So I think a very different context than proposing it as a tier 1 blanket bond criteria in and of itself.
Okay, thank you for that. We appreciate the explanation. Do commissioners have questions? Commissioner Messner.
Thank you, Mr. Chair. And thank you, Ms. Gutierrez, for your testimony. So in talking about that and understanding it was for a previous draft, but I mean, do you see applicability to that? I know that West Slope COGA has proposed some rules, and we can talk about it tomorrow when West Slope COGA goes, if we don't want to do it this evening. But I mean, is there any applicability to the different criteria that you know, I acknowledge that it's been mischaracterized, but it's still a set of criteria that could potentially be considered in this rulemaking. And so just a question, is there applicability?
Thank you for the
Information, yeah.
Thank you for the question, Commissioner Messner. From in a current rule structure with tiers as proposed, and let's say as proposed by West Slope COGA, I think it complicates things, right? What we need is a simple implementable set of rules where folks have some certainty around what is the criteria and how do we get in. The way we had utilized it was sort of the exception to the rule. To answer your question, I think folks could use that data set to say, hey, look, I have a different particular financial structure here, leveraging this, that, or the other. I'm going to show you these Moody's ratings and these different ratios on liability, and here's what the financial plan would be, right? It may be a consideration. I don't think it should be locked in stone as to this is like criteria to enter one tier or the next.
Thank you.
Thank you for the question.
Further questions? All right. Thank you for going last today and for agreeing to go today. We do appreciate it. And we appreciate the perspective of your client who are sort of uniquely situated in this situation. So with that, I believe we have concluded the priority presentations for today. I would note that the hearing officer will be shipping to everyone, including commissioners, within the next few minutes, a revised agenda that accommodates the shuffling and sets forth who we will be hearing from starting tomorrow morning at 9 a.m. We've got about, I think, 3-ish hours of direct, and we have obviously our questions to parties. So whether we're able to get through all of that tomorrow is a to be determined stage. We'll see where we go. But I want to thank everybody for the attention today and the presentations. This has been a lot of really good information, and I think the commissioners are very, very appreciative of the information and for getting a chance to have a dialogue with folks with regard to the Q&A that we're having with you. With that, I'm looking for a motion to adjourn to Thursday, January 27th at 9 a.m., at which time we will reconvene for purposes of financial assurances rulemaking.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
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 Any opposed? We are adjourned till tomorrow morning. Thanks, everybody.